Y'all can hear that? Y'all can hear that song? Wait a minute. I was playing one of the most goddamn depressing ass songs. Hold on. Shit. Can y'all hear it now? What about now? Come on, old ass people on Team Chaos, you know this song. Sing it if it applies. Sing it. Especially if you're a soprano. Sing it. Oh shit. Hit it. All done for. See, it ain't for me, because I'm an alto. I can't do nothing with this. I can't do nothing with this song. I say you're the where I can't tell the rest. Huh? Come on, old ass people, Team Chaos, come on. I know it's some sopranos out there that can hit this. y'all, everybody, on one. Come on. One. So I can't get it. I can't get it, baby. Nothing came out. So you take shots at me, baby. I gets brutal. I make it go somewhere and just like, I wanna kill my own self. I wanna choke myself. What's good with it? What's good with it? Baby, I can't do nothing with that, honey. That ain't made for me. That wasn't mine. That ain't made for me. Let me get my check call out the way. What's up, Lady Tech? Shawty. Karen Johnson, what's good with it? Cookie, hey, honey. Hey, Hammer Time. Marietta. Oh, Mary, I hope you feel okay. Yes. Hey, Stephanie. Jay Bennett, and everybody that's looking in the window. I would like to dedicate that to my sister wife, Nisimo. Anyway, so listen. So y'all. Okay, honey, we do our homework over here and we get our work done. So I left. If you don't read the message board, sometimes you'll be lost because I'll pick up from my message board and go right into the live. So what I was saying is that in order to understand this case, right? Meaning, because I know several times I have to go over why this evidence wouldn't be admissible, why she denied it, why this, why that, whatever. And I don't care how many times I've said it. I don't care how many ways I even broke it up and broke it down. We still come back to why I don't know this, whatever. And like I've said, I had to get in Levi's ass the other night talking like, how come when you get something positive about R. Kelly, it's like, him and her. It's not, him and her. It's that I don't believe in, false hope and shit like that. You know what I'm saying? I don't speak in absolute, so I never said there's no possible reason, no way, why, how, and this, I'll never say that. I'll just tell you what's the likelihood and how it would have to work if it works, right? But I don't give a damn, and, there's been some times when I say, well, this has a good chance of doing something, and it still gets struck down. Other attorneys have said the same thing about the same pieces of evidence, and it gets struck down, right? So that goes to show you, right, that your attorney may think something they put forth would be a good piece of evidence, or the motion would persuade the judge in their favor, what have you, and it gets knocked down. And that only tells you that your attorney may think it's a good piece to put forth, and the judge knocks it out, or the prosecution comes back with something, an explanation of why, it shouldn't be allowed. So, and it's the same here. So I need y'all to kind of think in that matter. Think always that, like I tried to give you the basis, when they write a brief, and it doesn't matter which side it's on, to be honest. That brief is a persuading argument. It's a persuading argument. All right? A motion is what? Is because you want the judge to do something. So therefore, you're going to write a persuading argument, right? A pleading is what you want the other side to do. Combined together, along with other stuff, they're all called filings, okay? But I want you to always think that just because, it don't matter which side it is, just because they put forth, it doesn't mean that it's a guarantee. Doesn't mean that it's close to being a guarantee. It doesn't even mean that it makes sense, because we have seen where the other side will respond and pretty much say it lacks merit, which is a professional way of saying it don't make sense. And I don't know why you put this shit forward. That's a professional way of saying it. So I want to make sure you guys just start to think along with that line. Take the person that's giving you the information out of it, and I want to pretty much deal with the rules and the regulations, and we're going to read them. I'm going to put them on the screen. You're going to see them for yourself. So you'll see that I'm not just making it up. And you'll see what it takes for evidence to be admissible. Okay? The 3 R's: relatable, reliable, and relevant. Right? You'll see for yourself. And I remember, I know a lot of times Levi likes to talk about the O.J. Simpson offense, and he even spoke on the fact that Mark Furman was able to get on the stand and got caught up with using that N-word. I think he had said he had never used it or whatever. Then they found some kind of evidence during the trial, proof of him using the N-word, right? I think we went over that on Levi's last live, and maybe the live before that when I was up there on the panel. But we're going to look at how that evidence of him using the N-word was admissible during that trial. I'm going to show you. I'm gonna let the writing, black and white. I'm going to put it in writing for you. Or they put it in writing for you. Okay? So you can always understand. So it's not of my doing, me shooting down hopes and dreams and shit like that. It's not that. It's just the process. Okay? And to support that I'm, correcting what I'm saying, it usually comes back as denied, right? There have been few motions granted. And the motions that have been granted are motions where the other side, don't object to, or something as simple as getting additional time over there for visitation with the lawyers or whatever. Nothing hard-hitting or something that can affect the trial in a big way. I think the Chicago trial had more motions, that meant something granted in a way. You know what I'm saying? It was very few, but still they got something, a couple of them, as I can recall. But it was more related to the motion in limine, okay? So, but anyway, so let me tell you this, right? And so I've already pulled up the documents. Now, we're going to talk about the scenario that would work in favor of R. Kelly. And you know, I'll be looking to find some. You know, Levi was supposed to go live early, and I was going to come over there and do it. But since he didn't go live, I said, well, let me do it tonight, because I no telling when I'll be able to come back on, because I got to, get that money. But listen up. Thought about something, right? Now, but this depends on, I wasn't in court, so I didn't hear it. I pulled up the transcripts, and I want to talk about those text messages, right? Okay. Those text messages. If you haven't figured it out, what's up, Sir Miguel? Hey, Gospel Glam. If you have not figured it out, those text messages are from the government's exhibits. Okay? That's why they're formatted that way. And if you can remember back, they look just like the text messages from those Mayweather twins and from the employees or whatever. Okay? Those are government exhibits. Okay? So they're real. Okay? Now, when I say they're real as far as what the government put forth. Are they real, like compared to the fake letters or whatever? I don't know. I mean, I can't tell you if they are considered some text messages that supposedly R. Kelly made them, do. I doubt that, being because look at the span, just look at the date range. I doubt that, those were text messages like those letters were allegedly, but I still have to, put that particular disclaimer out there, because, I don't want to come back later on and say, oh, they were fake, and what have you, you know what I'm saying? But we're going to assume that those text messages were text, implicates the mother, the daughter, and whatever was going on, honey. I haven't even finished reading them or whatever, but if y'all need me to, and I can put it up here so I can show you the government exhibit, and I really need to look at it anyway. I need to put it up on the screen anyway, so. But I want to take it step by step, because I want y'all to get it in y'all head, so y'all could, when you get evidence and things like that out here on these streets or whatever, you can start to think about it in a way to where you'll be able to say, okay, what I'm reading, will it actually help him? Will it hurt him? Will it be admissible? When can they use it? That type of thing, right? I want y'all to start to think about that, you know what I'm saying? And of course, God is over this entire process, right? But I just want you guys to, be able to look at this stuff and think about it as it comes, because who knows when I'm be able to get on or whatever, and then y'all are pretty smart, so y'all could figure this out. So let me put that first page up here. Now I apologize if this is choppy, but I'm kind of going out of what I need to go out of. Where is the damn text message? The damn text message at? Oh, okay, here we go. Okay. Alright. So right here. What the hell? Hold on. the damn thing's open. What the hell did I do? I'm sorry, y'all. Wait a minute. Be hitting shit. Oh, I'm trying to get this. But anyway, because I want to get it up because so it can go with what I'm telling y'all. But in the corner, in the right hand corner, you see where it says Government Exhibit 233. Y'all know we done talked about 233. I mean, my God, I don't know how many times, but Government Exhibit 233. Okay, now let me put it up. I want you to see it. Hey, Donovan White. I'm not. Hey, Demetria. I never compromise my integrity like that. I'll never do that. You know, it is what it is. You know, I mean, there is no way, but I want to make sure that you understand. Damn, all this. I want to make sure that you understand that while even if even if a lot of this stuff had a chance to play out in appeals or whatever, it still have to go through all the remedies, okay, that the legal process takes you through before they'll vacate a sentence and grant a new trial or what have you. But just in case it does, I'm gonna give you one way that she might be thinking of. Okay, I already told you that I really think that this is pretty much going to be left for a writ of habeas corpus, 2255. But I figured out a way that may be able to play in an appeal, within an appeal. I'm sorry, y'all. Let me get my shit together. Play out during the appellate process. Let me sit up. Because when you lay down, you're lazy. So you start being lazy. So right there, you see right there, it says Government Exhibit 233A. All right? So it's pretty much taken from a cell phone or iCloud or whatever. And then it's packaged in this type of way, right? And if you can remember those text messages between those Mayweather twins was like that and some other stuff. So this is a Government Exhibit 233A. All right. Now, I got hopeful. I got hopeful because of my theory. I'm not on no side, but I got hopeful because of my theory, because of how it may be eligible to play in the appellate process. Because I'm gonna tell you how. All right, I went to the transcripts because I want to walk y'all through this. Hold on, I'm gonna show y'all. Where's 233? Okay. Okay, he overruled. He got overruled right there. Hold on. Now, if somebody was in court during the Azrael part of the testimony. If somebody's around that can tell me yay or nay that this happened, then that would be good. Okay, wait a minute. 233. Okay. Mama knows best. I saw Mama knows best. Trying to see about trying to find the where they talk about these text messages. Not the whole thing, of course, but you know the excerpt that we were first introduced to by Miss Bonjean. Okay, so I'm showing witness 233. That's 233C. Travel to see me. I'm sorry, y'all. I'm put up on the screen, but I wanted to make sure I get it up. I find it first. Different video. Dolphin Hotel. And I just want to make sure you guys understand when you get nuggets like this, you can figure it out in your own mind. You know, they don't have to listen to me. I'm going to show you black and white how this is done. And y'all stop trying to kill my black ass. Dolphin Hotel. Okay, that's 247. Okay. 247. Okay, that's that Malik girl. M-A-L-A-K. Malik girl. Remember that person? Okay, here we go. Cooking with gas. Okay. Okay, do you recognize Exhibit 233? I do. What is it? It's from my, it is my phone from high school. And is that the, okay, here we go. Here we go, people. Here we go. Class is in session tonight, honey. Oh, come on. Okay, window. Is this it? Okay. Are you kidding me? Okay. 233. When I was 17 years old. Okay. Do you recognize Government Exhibit 233? I do. What is it? It is my phone from high school. And is that the phone that you were using to communicate with the defendant, or one of the phones you were using? It was. Government Exhibit offers 233. Government Exhibit offers 233. Can it? No objection. Ooh. Court, all right. It's an Exhibit 233. Damn. I think Canic just sink my goddamn ship while I was going with it. We're going to still go with it, okay? Because I wasn't there. I don't know who was there, and I need to have somebody I trust that heard this correctly that was in there, okay? Because, you know, and I'm not saying y'all didn't hear that, but that's what I'm saying, but I need somebody that would have the trained ear to hear what I need them to hear. And I just don't know if they were there at that, you know, in the courtroom or what have you. But I'm still going to talk about it. Because I see Canick said no objection. Damn. Boy, now I'm about to do the Levi on his ass. I ain't going to talk about him bad. Okay, it says, all right, that's in the evidence. Government Exhibit 233 was receiving the evidence. Now, before we met with the government or first met with the government, when did you last see that phone that's in evidence as Exhibit 233? Okay, so he said no objection. Okay, let me still go on with what I was going to say. Okay, so let's say this. Let's say 233, that whole entire thread that we have. She can use it in the appellate process, but to show that that it was a prosecutorial misconduct or that it was an ineffective assistance of counsel in some kind of way, however she wants to write it up, right? If it was there, or if he tried to get it in. Remember, we were talking about that pretrial when it was talking about extortion. If 233 was what they were talking about, who was that? Who was the attorney at the time? Farinella, Nicola, one of them was talking back and forth about it, right? I think it was Farinella. I think did Farinella try to get it in and it was shot down? But if he raised an objection, right, then those text messages can play during the appellate process. Now, how she would play it, I don't know, because this is the reason why I'm thinking about this again. Because if she's not objecting to these text messages being out here and all this whatever, maybe she thinks she can use them during the appellate process for some kind of reason. I'm thinking, how would she get them in if that whole thing, if they didn't talk about that whole thing during the trial, which clearly they didn't, but if that whole thing was admitted into evidence, then it's not off the table. Now, how she would get it, how she would write it up, who knows? So, what I'm saying is that it's a strong possibility that it can be brought up. Remember the rule, right? If it's not on the record during the trial process, then 98% of the time you can't bring it up during the appellate process. But if it was right there in the evidence, and especially if one of the attorneys objected to it or whatever, or tried to get it in and it was shot down, they said it wasn't admissible, then that evidence was there and it's on the record. You might not have heard about it, but it was in there. If it was in there, then it could play out somewhere in the appellate process. Yeah. What's up? What's good with it, Atmos? Did I lose anybody? Because I have to think about it in my head to try to translate it to you guys so you can understand what I'm saying. So, if the text messages were sought to be admitted, but it wasn't, okay? Because remember, they had the extortion thing going on. When we looked at the references for extortion, 233 came up. 233, is it the whole thing? Was it the whole thing? If so, then it is actually on the record. It just didn't play out during the trial. Because if she ruled it inadmissible, if she ruled it inadmissible for that extortion, then that thread of text messages is on the record. Just didn't hear about it. Am I losing anybody? This is for the advanced class tonight. Am I losing anybody? What's up, Atmos, my queen? Is anybody lost? Let me know. Because see, preservation of the record is when you hear an attorney say, hey, I would like to preserve the record, or if they make an objection, like, okay, they say, okay, Judge, I would like to offer 233 into evidence, and it was objected to, or the judge shot it down or whatever. That's also preserving a record. Okay? You can say, hey, I want to preserve the record, or, I tried to get it in and she shot it down. If this was part of the evidence that they shot down due to, for extortion and whatever that defense was, then it's on the record. Anybody confused? Y'all got it? Jennifer, what's good with it? Anybody understand what I'm saying? Okay? So it's it could be very well that whole thread is there. And I'm leaning towards it's there because it says, 233, government exhibit. I'm remembering when they were talking about the extortion defense and the evidence. She was talking about, remember, direct evidence, whatever. It was in that pre-trial transcript we read that several of us got our hands on. If that's the case, then it's there. It's on the record. And it can play during the appeal. Now, if just the little parts they, whatever is there, then hey, you're still back at, back at one. But if the whole thing is there, if the government put that whole thing in, and especially if they put it in, and and what's name didn't use it, that can probably play out as ineffective because it was there. They didn't use it. Is anybody confused? Oh, thank you, Atmos. Thank you so much. All right. Another thing I thought about. I don't know if the jurors would, I don't know how they set up the, so I don't know if the jurors' information could be released to the lawyers or whatever, but if they speak to that jury, right? And this is another little trick. Not a trick. I'm stop saying trick. This is a process. A jury has to convict you based on the correct standards, right? And the standard is reasonable doubt or preponderance of evidence if you're in a civil case, right? They can talk to the jury and to see, why did you convict my client? Now, if they give something different than reasonable doubt, if they give something like, well, you know, well, somebody got herpes out of the deal or whatever, or well, let me change that a little bit. Somebody died with herpes, something like that. That's not the standard. Standard simply is reasonable doubt. That's another opening. See, I'm fair. I always give y'all. Nobody give y'all more plausible legal openings than me. Hell, I did a whole goddamn exercise on defenses, so I don't want to hear that shit no damn more. But I be knocking down y'all hopes and dreams. I'll be doing that. No, but I'm saying. Okay, so you understand what I'm saying? You got to convict the person the correct way by those standards. Then, hey, if that jury say, well, you know what, they died with those herpes, or it was more of something about their feeling, or something catastrophic happened, or something more other than reasonable doubt. They don't have to have absolute doubt. See, if you convict somebody because they died with the herpes, well, or the fact that the one young lady isn't back with their parents or whatever, that's something like absolute doubt. But reasonable doubt, that's another way. But I don't want to confuse y'all on the text message thing. Now, if somebody, and we can get closer to a better answer if somebody was there and said, hey, was the entire thing, because I did look and they have 233C and A and all of this or whatever, and I don't know, and in the transcript it just said 233. On that text message it just says 233. And we do know there's bits and pieces out of that thread that ended up in Bonjean's motion and ended up on the transcript. But was that entire thing there? And I'm thinking, and it makes more sense than not that the entire thing was there, because one, the government has a duty to disclose exculpatory evidence. That would be exculpatory. Something that, that looks like it could help the defendant, right? Depending on how it's used. Okay? It does, but in the best case, it probably mitigates some of his criminal liability, but other than that, so I want you to understand, when these things come up, because I don't know what's going to pop up next. I don't know. But when it pops up, I'm going to need you to go through in your head. I'm talking about the people that, and I ain't telling you to abandon prayer. Now, that's not what I'm saying. I'm saying outside of that. Of course, we do know that faith and all of that is and God's will is the absolute. But I'm saying, when you get these things or whatever, you don't want to sit there and be thinking, yeah, this gonna free them and this is whatever, and then they come and say, well, we couldn't use it, or it didn't work. We couldn't put base an appeal off this, whatever. And you seem like, why, you know? And you be somewhere crying, and some of y'all be on the damn bridge about to jump off. So I want you to understand when you see something else, I need you to put it to the test. And I think it was Sky, somebody was trying to say that the transcripts are now more like watered down. It wasn't, so it's not so, that's the Bible. Well, actually, in the court case, it is the Bible, other than the actual Bible, but it still is the Bible. But what you have to look for is what's on the record, right? So it's going to be in that transcript. You just got to find out is that entire thread in that transcript. And I'm thinking that it is. Because I don't see how would the government just take bits and pieces out and let that be what we read off the transcripts. Because then that would create a Brady violation, right? I think that whole thing is in there. And if it's on the record, now, did the brother Johnsons do what they were supposed to do? Because they didn't object for 233 coming in. But here's the thing, right? They didn't object for it coming in, but if that whole thing came in, I'm thinking about what Azrael testified to. She testified. If that whole thing came in, and they asked her on that transcript, if I'm not mistaken, if that was her mother texting as her. Anybody remember that? Didn't she say that was her mother texting as her? If that was the case, then the prosecution opened the door. The brother Johnsons could have used that. Could have picked the part out. And this don't require that much skill. So just say, hey, my mom is the one that says, hey, okay, they did the initial texting, right? I'm 18, I'm blah blah blah, whatever that whole scenario was, right? The brother Johnson could have came and made the point, picked the part out of there that maybe showed the parents' influence, or maybe that there was some type of conspiracy going on or whatever to trap them up or whatever, and to show the parts where it did speak to the enticing. I'm not even talking about the enticing for the traveling. I'm talking about the enticing as far as showing where, showing that their kid, that they are kind of giving their kid the okay to go ahead to maybe to act inappropriate with the defendant. Now I know you saying, well, Miss Angela, I thought you said you couldn't do that. You're not listening to me. He can go down his line of questioning and have that in there. Now, I'm pretty sure the prosecution gonna say that could be confusing the jury, but they can also came back and say, well, you talking about her mother texting as her from the jump is also confusing the jury. So you can't have it both ways. If you say, when we say the mother is texting as her, it's confusing the jury, okay, then shit, what y'all saying, the mother texting as her, is confusing the jury. See, remember last night I told you on Levi's there is a way that you can get inadmissible evidence admissible. But there's a little skill that you have to know how to ask the judge and how to get it in. See, you stay away from the extortion because it is true. You don't have any direct evidence with regards to extortion, right? I'm not even sure why why whoever came up with that. But if you want to plant in the juror's mind that there's a good reason why R. Kelly could have, mistaken her age, okay? Because you got the parents saying she's 18, she's saying she 18, and this shit about the ID and the Dolphin Hotel and all that other bullshit, right? So, you see what I'm saying? So, that would have played into his defense as well. Now, we did see where the judge did not allow the mistake of age defense, mistake of fact, right? But maybe if they would have packaged it up, and I don't have the file, and I don't know, but maybe they would have packaged up in a way like I'm suggesting or something like that, then maybe the judge would have allowed it. But the prosecution is going to holler, is going to be over there hollering about, yeah, but it's, misleading the jury or what have you. But then, if that's the case, we'll try to move to get the whole government exhibit 233 removed out of there then. And that takes away one piece of evidence. That takes away that phone and all of that. And, that makes the prosecution have to pivot some other kind of way to come up with something else, right? So, but, am I losing anybody? Because this is kind of advanced tonight. Am I losing anybody? Hey, Chrissy. Right. The mom texting them is only about 1% of the text. I understand that, but what I'm saying is, but check this out. That was some of the questioning they asked on that stand, if I'm not mistaken. And I'm just going by what was in the transcript. Hold on. Let me look. I don't want to get it wrong. Okay. The last time I saw that phone was in Florida before I left my family. Okay, do you remember when that was? It was probably June or July of what year? 2015. And did you use the phone after you left it in Florida with your family? I did not. Just wait until the lawyer finishes asking questions, blah, 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 blah. Okay. Okay, wait a minute. Wow. Okay. Because it says something right here about the mama. It says, that's all right. So go ahead. When you said that you saw some of the messages that your mom had been exchanging with the defendant. This is in the transcript. I'm not making this up. So they open the door. It can be 1%. It can be, shit, I don't know, whatever's less than 1%. Yeah, you know what I'm saying? They open the door though, and it's on record, cause I'm reading it. And he can get up there and say, well, and this won't be no hearsay because Jane Doe number 5 is directly related to this evidence. She's our witness. Her mom was texting. Her mom had been texting her and sending her the stuff and whatever, based on, that long thread of a text message. But the prosecution opened the door. And I'm surprised. Before, I don't want to attack the brothers Johnson, and I'm not. Let's see what the brothers Johnson said. Let's see on cross, what did they say? What did he say? Did he say anything about the mama texting? Shit, I don't remember. Well, here's the thing, right? Hold on, I'm trying to look. Trying to get to the cross. Y'all know my computer's slow. And know this now. Know this. With regards to the evidence, relevance doesn't necessarily have to prove someone's innocence or guilt. It just proves or disproves a fact in the case. Y'all follow me? Relevance does not have to disprove or prove someone's innocence or guilt. It only have to prove or disprove a fact in the case. So let me see what he said on cross. Let me see what he said. I'm looking, y'all. I'm trying to see what did he say? What was his line of questioning? Okay, that's a sidebar. Sidebar. Damn. Does anybody know where it is? I had somebody over here knew these page numbers. That was in the last lives here there. That's direct. I'm coming, y'all. Cause I want to explain. I want to go through rules 401, 402, and 403 with y'all. Direct. Well, goddamn, how long she was on the stand? I was under the impression that 233 was chopped up, right? Meaning, I guess 233 was the phone, and 233 was part of the messages, and I mean the actual phone itself, and the messages and stuff like that. I was, on the impression that was chopped up. In that case, if it ain't on the record, whatever. But that whole thing is in there, and it looks like that whole entire thing we have. That's the whole entire thread of those text messages. If that's the case, I mean that 2255. I mean, shit. You got that, and there are some options, right? It could be a situation where, you know, he have to go and get resentenced, right? That can be an option. You know, a new trial without that. I mean, with prosecutorial, if it's prosecutorial misconduct, if it's like they allow her to give false testimony and they knew it and so on and so forth, what I explained on Levi's yesterday, then if you get a, they say, well, he's ordered to have a new trial, that can run into double jeopardy, So it's a lot of shit that can take place. So, and I ain't no fool. These text messages is just, floating out here, and the attorney ain't said shit. Oh, God damn, how long she was on there? Damn. Lord, where the people with the page numbers? Okay, hold on. Oh, she's still on the stand. Okay, here go the cross. God damn. Okay, do you remember calling it? Okay. I'm sorry, okay, I'm going to withdraw that question. Okay, it's the candidate with the Dolphin Hotel. Where did he go with this? Okay, substantial gifts. Server overrule. Do you recall being asked this question? Kelly told you that you were not pulling your weight. What's up, New Black? Okay, again, looking at these 3 pages. His concert calendar. You talking about a damn concert? Wait a minute. Now, he testified yesterday to the jury, although the encounter with Mr. Kelly first time was actually in the course on the trip to Stockton. Okay. Maybe he just stuck to the elements, defending or opposing the elements. Maybe he stuck to that. Hold on. Okay, in fact, told Mr. Kelly that, told the government, sorry, that the date you first met with Kelly was at the Dolphin. No, what did you ask about the mama? That's what I'm trying to get to. About the parents or something. Hold on. The Dolphin. Come on, man. Cause I see he objected to a lot. Well, no, he got objected to. Never mind. Okay. But let me ask y'all this. Let me ask y'all this. You know what? I think he didn't. I think he didn't preserve that record. I'm gonna tell you why. Because didn't in the judge's answer to one of those post conviction motions that she told her that you can't that it that you couldn't bring it up now. Hold on. Fuck these transcripts. Hold on. I need to know what the judge. Hold on, y'all. Let me find what how the judge responded. Hold on. Sorry, y'all. This is totally off course. Y'all always do this. I just have to make sure I be right in what has already happened. Hold on. Because if the judge addressed this, then it's on the record. Hold on. This is gonna be interesting, honey, how this shit play. I want to see this before I move on to evidence. And it ain't that much to read with regards to evidence. I'll tell you that now. Judgment. Order. Is this it right here? Letter order. Order. Court. The party is addressing defendants of resolution. Objection. Order. What order is this? Order defendant director to submit supplemental. Rule 29. Oh, wait a minute. Hold on. This will tell me right here. Okay, is the California hell? Okay, so she did address that. So it's looking like that whole thread was in evidence. It's looking like that whole thread was in evidence. So I don't know how this gonna go, y'all. It looks like that whole thread was in evidence. Well, that's a little different now. It's a little different ball game now. It's a little bit different ball game. And it just makes sense now. So I'm going with that whole thread is in evidence, y'all. So, woo. Thank God, classified private. What's up, Lavelle? So, okay, so enough of that, because I don't want to confuse y'all no more. So I just want to make sure y'all understand that, hey, I think that whole thread is in there. Yeah. So, remember, and I don't know how many people listened to that live with Levi when he was talking about, Mark Furman got on the stand and they found that he, used the N word and all that type of stuff, right? So, let me show y'all the O.J. Simpson case, right, and why that was allowed, okay? That evidence that they found during the trial that showed that he was a racist, that he used the N word, right? So you know his what's his name? O.J. Simpson was charged with the crime of murder. So you know his elements and shit was all about murder, okay? When I told you that the judge not only shuts down evidence, but shuts down defenses as well. But I'll show you why this defense was allowed. I'll show you why. Why the evidence? Because when he was on the stand, and I don't know if he said, did he say he had never used the N word, or did he plead? I don't know. But during that trial, the defense got evidence that he did use the N word, and I'll tell you why it was admissible. So this will give you an idea how they allow certain defenses, and certain defenses are shut down when the evidence does not prove or disprove the facts in the case, right? So O.J. Simpson, here we go right here. Very simple. Let's see. O.J. Simpson's defense. Okay. The attorneys representing Simpson, known as the Dream Team, included all those people. Okay. The Simpson defense was based largely on the grounds that evidence had been mishandled and that many members of the Los Angeles Police Department were racist, particularly Mark Furman, and so on and so that thus forth, right? So that means that if they get evidence about him being a racist, evidence that showed that the evidence at the crime scene was mishandled, and whatever their defenses was, that would have been that. But that's why that evidence was allowed. Not like when they were talking about extortion before the trial started, because there was no evidence of extortion. There was no direct evidence of it. Okay, so you see why that evidence was allowed on Mark Furman, because that was a part of his defense. That was a part of his defense. I know that the brothers Johnsons had an exculpatory defense. You know what I'm saying? And with the exculpatory defense, it could free somebody or just mitigate their criminal liability, right? Meaning that they're not all the way guilty, but they have some degree of guilt because of some justifiable or excusable reason. Okay? Had they would have had mistaken of fact, which was mistake of age, would have been allowed, I don't know how different, the outcome would have been, but evidence to support that particular defense would have been allowed. So meaning the mom texting, as she was Azriel, fake ID, whatever, the theories y'all have going out here. So that would have been allowed. Now I want to show y'all real quick about, if y'all looked on my community wall, I want to tell y'all real quick about rules of evidence. And I'm going to read it, so when I say these things, when y'all not thinking I'm just saying, oh, okay, anything by R. Kelly that could be positive, we're going to kick it out, it's bullshit. No, I'm going to show you why. Hold on. And you can read it yourself. Okay? And this is the FRCP, right? This is Federal Rules of Criminal Procedure, okay? Now, Rule 401, relevant evidence. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Okay? Relevancy is the notion that every piece of evidence admitted in the courtroom must be tied to the case somehow. Any probative value will make evidence relevant. Note that relevancy is different from credibility. If evidence is merely unbelievable, the presumption is that it should be admissible, and the jury should decide whether or not to believe it. Okay? So, meaning, that's why, and let me give you a good example. You hear cases where, like, I'll use trace DNA or something like that, right? Where they're saying, okay, the only way, one of the other reasons, on the other way that evidence got on this person is because this person touched a door handle, and this person touched the door handle, and that's how that trace evidence got on them. Not that they were there to kill that person or whatever, but they touched the door handle, and some trace DNA got on them or what have you, right? So that can be, if I don't know how and I'm not saying, because the trace evidence is true, is real, right? But sometimes it seems too wild. Okay, I got all that blood all over me. All right, I got all that blood all over me, but the only way I got it all over me is because I walked in the puddle of blood, splashed it up on myself, thereby make me looking guilty because now I got the blood all over me. When in all actuality, I probably killed their ass and got the blood all over me. But my defense attorney said I just walked in a pool of blood, splashed it all over me, and then that's how, the blood got on me. It was transferred on me, to me, right? That don't sound believable, but that's what it's saying. It doesn't sound believable, but they saying that's a possibility. And if they have evidence like that they want to, enter in by way of some kind of expert, by way of some kind of splash pattern or something like that, then hey, that would be admissible. Okay, so you'll have that, and then the other, which is most likely, I killed their ass with a knife, or something like that. So, and it says relevant evidence need not be probative to the core issues of the case or of a disputed issue. Matters of consequence can include the background of parties and witnesses or any other matter which weighs for or against the case of one of the parties. 402. Relevant evidence generally admissible, irrelevant evidence inadmissible. All relevant evidence is admissible except as otherwise provided by the Constitution of the United States, by act of Congress, by these rules, or by other rules prescribed by the Supreme Court pursuant to statutory authority. Evidence which is not relevant is not admissible. Rule 402 makes relevancy the first consideration when objecting to evidence. If evidence cannot be tied to a matter of consequence, meaning the outcome, it cannot be admitted at all. Okay? So regardless of whether rules might indicate its validity, if evidence is relevant, then the other rules of evidence come into play. Okay, because so, you know, it's some other rules with regards to the rules of evidence. So what I'm showing you is, you know how a lot of y'all be saying, oh, they didn't have no evidence, oh, blah, 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 whatever y'all consider no evidence. Well, I'm showing you why they considered it evidence, and this is why. And it says, for Rule 403, exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. So I know I got a lot of side eyes when I was saying that you cannot admit evidence, or evidence would not be admitted that confused the jury. It says it here. I'm not making this up, I'm reading it to you. It says, although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Rule 403 provides a balancing test. Remember I told y'all there's tests and all of that built up all through the legal process, okay? It ain't, you know, Levi always talks about a sterile process. If it ain't sterile, it should be thrown out. That's not how it works. It says Rule 403 provides a balancing test for excluding relevant evidence. The balancing test is strongly weighed towards admission. There must be a danger of unfair prejudice that substantially outweighs the probative value of the evidence. Unfair prejudice is not the same thing as prejudice. Almost all relevant evidence is prejudicial to one side or the other. Proving unfair prejudice is often difficult. Proving the balance is even more so. Ordinarily, a 403 objection is the last objection a lawyer makes when seeking to exclude evidence. Besides the burden of tipping the balance, another key problem is that a 403 objection concedes the relevance of the evidence. So, I read all that to say this. Evidence travels through all these steps. What I was saying on Levi's channel, that some people think that, okay, once you do A and you do B, C is the result and it stops there. No. To undo a guilty verdict, it's not, okay, we got new evidence, or, and when I say new evidence in appellate process, make sure you understand this. New evidence that was not known at the time of the trial. So I'm using this as an example. New evidence wasn't known at the time of the trial. That is allowable at the appellate process. So listen. So just say you got some new evidence, some DNA. So that is what usually the new evidence is, DNA. You got DNA from somebody else who was most likely the likely killer, right? And you submit that, and boom, it shows that somebody else killed the person. And you often see that sometimes those cases take years after that for them to set that person, the innocent person, free. Or sometimes you have the prosecutor still insist on the person in jail being the murderer, even though DNA says something different. And a lot of times the defense the attorneys for the defense have to convince the prosecution. They have to join together and go to the judge and say, hey, we both agree that this person most likely is innocent and someone else looks better for the crime, right? But even that, what I'm trying to tell you is that even though DNA comes through and shows somebody else most likely did the killing, it's some more steps after that. A lot of y'all think that, hey, okay, this proves this, boom, automatically new trial, he's free, he's sent home, blah blah blah. Nope. They're gonna take it. They're gonna take the new information or whatever through a test. Even if it's a violation of constitutional rights, right? It's not automatically, it's over with. Go home. You didn't follow the law, to lock me up. Still gonna have to answer that question. Should we overturn the guilty verdict? That's when the harmless error test comes to play. The reversible error test. The reversible error, I'm sorry. So, and the reason why I wanna, and this is choppy, and hopefully I'll go have a chance to go over, because I was supposed to do this with Levi, but he had something else to do. But hopefully I'll get a chance to go over it a little bit better, a little bit earlier next week, where y'all can understand. And let me know if y'all confused now. I just want y'all to get it in your head. It's not me saying that, hey, when something positive come out, woo, that's it, that's a smoking gun. Just say, no. And it would be vice versa. Anything that came out that negatively affected him, and I'm looking at it and I'm like, well, that don't mean that it actually is going to negatively affect him. That, you see what I'm saying? I want you to know that I'm going through a process. And the process that I just went through. So that's what I put on my wall. SpongeBob added to it. He added to it. I told you the federal rule. Excuse me, Lord have mercy. What's good with it, killer? What's good with it? What you mean that's not what your argument would be, JoJo? What you talking about? What you talking about, JoJo? What are you talking about, JoJo? What would your argument be, JoJo? Oh, let me drop that link real quick. I get out of here. Oh, damn, it's late. Hold on, I'm gonna drop the link. Y'all see that link? Oh, this shit ain't responding. Wait a minute. Damn. I don't know if y'all can still hear me or not. I'm trying to get back around now. Can y'all still hear me? Okay. What would be your thing, JoJo? was saying on my wall, I was saying that once y'all understand the federal rules of evidence and the federal rules of criminal procedure, SpongeBob he added the local rules and the federal rules of appeals. But listen, appellate process. But listen, the reason why I didn't say the appellate process is because we still have a big argument sometimes over evidence and over the rules. The appellate process, honey, that's a whole nother different goddamn animal. I'm still fighting with y'all about the goddamn rules when it comes to evidence and the rules when it comes to the legal procedures. You know, some of y'all just want to bypass that. And they're like, And some, you know, and I know as eager as you guys are on both sides to put the parents, you know, at fault, at worst, at the most, they're just going to create an indictment for themselves. And still don't free R. Kelly. You know, that just gives him co-defendants or their own indictment. And I know some, but I have no idea why nobody does not understand. I know some people understand it, but I'm talking about the ones that I be getting into it with. Or the ones be leaving me messages and shit. Hell. Yeah. I mean, and I'm not going to say that the Brother Johnson's legal strategy, because we don't have the file. We don't know, we don't know what the preparation was. We don't know a lot of shit. Okay, and there's no way for us to know. It ain't our business either. But I did peep that they was trying to have an exculpatory defense. We went over that several times. But I just can't see. Maybe it's my naivete, but I just can't see them reading those text messages, then hearing the prosecutors ask, and I read in the transcript, ask Jane Doe number 5 about your mother corresponded with him during those, at some period of time. Having what we see now in evidence and not, and here's the thing, right? Even if your defense wasn't going to take you that way, right? Because you don't know, the prosecution don't give you a list of the questions they're going to ask. They don't give you that. But if you would have read those text messages, and you would have heard that prosecutor ask anything about them, the mama now, for texting. Okay? I'm not saying you can't get up there and say, hey, you try to get money out of R. Kelly and all of this here, unless the prosecution went there. No, I ain't talking about that. I ain't talking about specifically what we know that was asked. Meaning, they opened the door. And you have that text message up there. and you don't ask, what's good with it? What's good with it? Chicago
Good with
Slayer
it.
in the building.
Good with it.
What's up?
Shit. Man, so you down here in the lowdown.
Yeah, I'm in the lowdown, baby.
I hear
Yeah,
a little
so
echo. You hear echo on my end?
uh-uh. You
I
hear
hear a
echo
little
on me?
echo. I do only for me though, not for you.
Oh, uh-uh.
But it's all good.
No, Levi tried to go off my integrity last night.
Man,
Talk
these
about
text messages.
talking
They
about yeah, talking about every time me and SpongeBob talking about when it's a ray of sunshine for Kales, y'all be like, maybe I don't know, oh
I
no,
don't. Is it a ray of sunshine for 'em?
is it a ray of sunshine? Well, like I was explaining, it all depends. So listen, if okay, let me see.
I'm gonna have to come out, come back in because it's echo killing.
Okay, okay. I'm waiting for Kel. Oh, I forgot to take this stuff. I'll take it in the morning.
Okay.
Oh, you know what? You know what? It's probably me. Hold on, let me do this.
Yeah, 'cause I
Let
still
me
hear.
tell you. Yeah, yeah. It's me. Hold on. Let me change it. Okay. Here now.
Uh, yeah, that's a lot better.
Okay.
But yeah,
Well,
is it a ray of sunshine for 'em?
okay. Well, here's the thing. It 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 could very well be that it was on the record. And here's the scenario. Okay. When you look at them, it says Government Exhibit 233. That's the whole thread. So I matched it up with the transcripts, and I know they had like 233C and all of this, and contained within 233 was the phone. So, but that is a government exhibit, meaning that it was probably submitted as exculpatory, so it was sitting there. So if that's the evidence that they tried to introduce as extortion, and remember, it got shut down during pre-trial.
Was that pre-trial? Was that a sidebar?
No, remember, it was pre-trial because they were saying that was when they was talking about the
Okay.
if there's no direct evidence with regards to the extortion, that they weren't going to allow.
So, if memory
So,
served me correct, go ahead. Go
uh,
ahead. Go
so
ahead.
if that being the case, it was inadmissible. If they preserve the objection, if they preserve the record, either by objecting to it or by saying, well, we want to preserve the record, that whole thread is there in evidence. Therefore, it can be brought up on appeal.
So, yeah, the thread was there. Uh, they didn't utilize it. That was Bojane's argument. I
Right.
think
That's
she
what I
used that
was.
for I think she used that as for ineffective counseling. That
Right. Right.
they didn't utilize it. It was there. Now, if memory served me
The
correct,
whole thread.
Right, and they didn't utilize it. They didn't utilize the portions that she highlighted. She said that it should have been, utilized, and they failed to do so. Now, if memory serves me correct, Bojine said that when it comes to this extortion, not Bojine, I'm sorry, uh, and Donnelly, she said that I'm not going to you won't be, and I'm paraphrasing, you won't be able to use that the parents gave the daughter consent as a defense, and I'm going to instruct the jury that the parents can't give consent. However, if you have an argument for extortion, by all means have at it, but you can't say that uh, the parents you can't say that the parents gave them consent. Um, she warned them that if you do that, you're going to open that door, and I'm going to allow them to, ask their questions.
Right.
I
Right.
believe that they didn't utilize it. This is just my opinion. The reason that they didn't utilize it is because, yeah, it will throw the parents under the bus. It will fuck them all the way up. I'm sorry. I said that wrong. It will it will expose the parents and fuck them all the way up. But in the process of that, it will throw their client under the bus. Reason being is the same argument that they're saying about the parents. He's being charged for that. So if you say the parents is guilty of it, then you is too.
Right. That's what I said. I said. I mean, at the most, it will give the
A
parents an
co-defendant. So if you said that the parents is wrong for this, goddamn, we charging you with the same shit. Because I believe um uh for one of his predicated, I mean his what you call it, for racketeering, what was those things they had to prove? You know what I'm talking? You hear me? Hello. Did you hear me? Did you hear mute by accident? You there? Can anybody hear me? Is it me or was it Angie? Oh, she just gone. She gone completely. Okay, so I guess it was her. But shit, I guess I finished my point until she come back. When they did the racketeering, I know they had 12 predicate acts that they had to prove, and one of them was forced labor. So pretty much in them text messages, it appears to, maybe not so um, egregious, but it appears that the parents, to some extent, was doing forced labor to their damn daughter. So if you said that the parents is wrong, shit, it's a double-edged sword. How you gonna split the baby? Um, yeah, predicate X. That's what it was. Um, so I don't think they're going to be able to use that for the appeal because they tried to use it in a post-conviction motion, and the judge said that you didn't bring it up in trial. So as far as utilize it, so they didn't even touch on it. If y'all remember, when we was waiting to see, like, about these text messages, and the government didn't even touch on it at all because they said that you didn't bring it up in trial. It's not on the record as far as the transcripts. It's in evidence. It's in evidence, but it's not. You didn't bring it up in trial. Therefore, you fucked. I don't know what the hell happened. I don't know what the hell happened to Angie. But it's gonna be interesting to see what's in this appeal, because I think she already put her best arguments, in my opinion. When it comes to Bojine, she always pull a rabbit out the hat. But in my opinion, I feel like she put her best arguments in a post-conviction motion, and to no avail. But we shall see. We shall see. I know she keep doing the extensions, and to me, I kind of wonder if she's extending it for uh, the outcome. Is she purposely extending this appeal, trying to give the outcome for these emails? Are you back?
I'm back. Lord have mercy. You know how that shit work. Thank you, Purple Purple. Hey, Leslie. You think she's extending it to see
I,
how?
I wonder. I wonder if she's purposely extending the appeal. Because this is like a third time extending it.
I
I wonder. I wonder if she's doing that on purpose to try to give time for the outcome of these emails, the investigation of these emails, to see if she can include that in the appeal.
what investigation done already? What? What you mean?
It's not
Another
concluded. It
investigation?
started. It started, but it hasn't finished. They haven't finished. They started the investigation, but they want to know the outcome of
Uh-huh.
it. Last I heard, that it wasn't completed, and that was damn near a year ago. So I wonder if she don't want to be in the position that, okay, once she do her appeal, now the outcome come out, and then she like, damn, I could put that in my goddamn brief.
Well, I thought that when the prosecution responded to her motion to compel, they talked about what happened, what was the outcome of that investigation.
I
They
thought
didn't
they said
say
it was
that was
still under. I thought they said that it was still under investigation. It hasn't finished. It hasn't concluded yet.
I don't think they said that, but you could be right
So what was
because
the
you
outcome then? What was the outcome? So
the outcome
what's the purpose of them sending the letters in?
because they wanted a further investigation, a further investigation.
I mean,
They
I
wanted
guess.
they wanted they wanted a further investigation.
I guess.
Like whatever else they thought maybe may have happened. But see, but back. Let me go back on text messages real quick. So if she could use that as an example as an effective assistance of counsel, or
So
if
she tried that though. She tried that in the post conviction motion, and I don't know if you heard me earlier, but you
not with
remember
those text messages, she did that with the
with the text messages. With the text messages, yes.
not ineffective. It wasn't ineffective.
What was it?
It wasn't ineffective. It was
What was her argument behind it?
her
Because she
argument.
said they should have used it, and they didn't.
Yeah, but it wasn't ineffective. Hold on.
But
Yeah.
in any event, remember we were waiting to get more information from the government about the text messages, waiting on them to respond, and they said that it wasn't brought up in court, therefore you can't bring it up. And Auntie Anne agreed in her decision.
Was it the text messages or was it about
It was those text messages that she
California?
highlighted. It was the text messages that remember she highlighted certain text messages, and she said, you're right. You're absolutely right.
Yeah,
Her argument was it was the parents who was doing the coercion. That's what her argument was.
yeah, the
I
coercion.
think.
Yeah,
I think.
hold on. See, you got me confused. Hold on, let me see what it was. Okay. This it? That's the order. Motion. Trial.
So I think Koenig used 230, 233. I have to double check. I think Koenig used some of 233 in his recross, but
And that's what I was looking on the. I was looking on the trying to look in the transcripts, and it was taking too long.
all you gotta do is put in
What part of 233 he
text message.
used?
Um,
Did he use the part to talk about?
I don't know. I have to
He
go back
could
and
use
look.
the
Let's
part
go back
about
and
the
look.
parents texting. He could have used that because the prosecutor opened the door for that.
Open the door for what?
They talk about it was the parents. The mama was texting at first.
Did they open the door for it, or did they just get ahead of it?
No, they opened the door for it. They talked about when you talk about it, you open the door.
Yeah. But they also talked about, that she lied about her age too. So, they say that to get ahead of it. So you know,
Well, yeah, but anything, even if it's not to get ahead, you could do it could be one and the same. You talk about it. Getting ahead of it, like she used her she gave fake ID or whatever. That
I
still
didn't
will
see
allow
what I didn't
the
see no fake ID in there. I don't know what people getting that
Well,
from. I
I'm
never.
just making that up. I'm just making that up because that's
Okay.
I already heard. Yeah, I'm just making that up. She used what is that? 16. So let me see what's 16. What was her objection?
But I don't see how these text messages help him. I don't see it at all. It put the parents, it make the mother look fucked up. And when I see the text messages, it just for me, it just put I just put the mother in the same category with Aaliyah's mother, Rashana's mother.
Ah,
But it don't change the fact that they were victimized because their parents was fucked up.
right. It don't change the fact, but if we wasn't talk. Well, here's the thing. Okay, we had to. We knocked at. We talked about why it wouldn't be perjury. Okay, why? Well, let me take that back. Why it wouldn't be perjury with regards to appeals because it's not how it go. They were talking about it helps. Levi moved it from that to prosecutorial misconduct, and the reason why it could be prosecutorial misconduct because if the prosecution knew that she was giving false testimony and
What
allowed
was the
her.
false? Okay, go ahead.
Hmm?
I'm sorry.
Well, the
I think you
false
about to
testimony.
answer my question.
Well, the false testimony was, excuse me, and I don't know what would be false. So don't give me the line. Like whatever the events were, she testified to was the Dolphin Hotel and whatever is
Uh,
the case,
uh,
and the prosecution knew that she was lying on the stand. Just said the
about the
prosecution knew she
Dolphin
was
Hotel?
lying about anything. No, not about the Dolphin Hotel. I'm just using it as an example. Just
Right.
put it
I'm
like
just
this.
trying to figure out. I'm just trying to figure out. What did she? What when she committed perjury? In what way? You say she
Okay.
committed perjury, but okay, what did she lie about?
All right, let me give you an example. So then you can put it to the test because I don't know this that I don't know the case like that. Okay, say for instance, she said that she went to the Dolphin Hotel on her own by herself, and um
Well, we
you
can't
know
say. So let me correct. Let me stop you real quick. She didn't say that.
I know she
Oh,
didn't say that. I said it's an example. This is
okay.
this is an
All right,
example.
go ahead.
This is
Go
an
ahead.
example. I said, just say she went to the Dolphin Hotel by herself. Hey, Shaniqua. And her parents didn't know where she was.
Mhm,
And she gave fake ID to the cops. Okay.
mhm,
And just say the text messages that government exhibit says that, well, her parents took her to the hotel.
mhm.
So her parents did know. And um she didn't give no ID to the cops. So whatever she was saying
I'm trying to
contradicted
think.
what the government knew that was contained maybe in those text messages. If you can't
Now,
knowingly
I'm trying
allow
to think. I'm trying to
false.
think in my mind, like, and you know what? I couldn't. I probably couldn't answer that question because I couldn't read them damn text messages. It's fucking pissing me off. I read fucking like shit, a couple pages. I'm like, I can't do this shit no more.
Hey, my
Uh,
Stara. But
but
yeah, so
I
yeah,
think from
so
what I read, I see that it contradicts the goddamn what the parents were saying. I see that.
they can contradict the parents because the parents ain't on the stand. They
Right.
can contradict them, and they don't have a statement that was entered in via hearsay, so they can so they don't have no consequence because they and nothing happened to them unless somebody something they want to be charged with something else. But we're talking about Levi was saying that I think he was saying that the government knew that her testimony was a lie
See, I need
and
to
they
know
didn't go in.
what part he talking about.
Well, I don't know what part, but he's saying that and so if they put evidence forward that they knew was a lie, if they suppressed it or whatever, then that can be considered prosecutorial misconduct. And a new trial can be granted. And if a new trial granted, then they could run the risk of having double jeopardy issues.
How is that? I thought if you get a new retrial, if you get a new trial, I mean a retrial or whatever, you just do the trial over in front of a different jury.
If under certain circumstances,
Okay, so
jeopardy.
what would make it double? What would make? Give me an example that would make
Let
this
me finish
double
what I was
jeopardy
saying.
if it's a
Let me,
retrial.
let me finish what I was saying. Under certain circumstances, jeopardy remains, right? So it remains from the old trial to the new. Usually, when it's prosecutorial misconduct, that means this is the fault of the prosecution. This is the intentional fault of the prosecution. Then jeopardy detaches, and then jeopardy.
For acquittal though, for acquittal, not retrial.
Are you telling
Retrials,
me? I'm
How
just
you gonna do a
telling you.
retrial? How you
I'm
gonna
just
do a
telling you
retrial?
something very complex that I know you don't know. So can I finish what I was saying? Damn. Not
But,
talking about acquittals. I'm not talking about acquittals. I'm not talking about that. Why would we be talking about acquittals? See
because
what I mean?
that's when double jeopardy kicks in. But go ahead.
No, I don't.
Go ahead. I'm listening.
So anyway, Jeopardy. So double jeopardy when the prosecution makes an egregious move like that, then they don't get to enjoy all the benefits. So if depending on what type of prosecutorial misconduct they were hit with, this is just hypothetical, y'all. Then double jeopardy, they're going to run into double jeopardy issues. I said this before Steve Greenberg did, because
So so
go
that
ahead.
wouldn't be a acquittal if that situation happened. That wouldn't be a acquittal as opposed to a retrial.
Oh, okay. I'm confused with what you asked me. What you mean acquittal? Meaning,
Like if it was an egregious mistake like that for the prosecutors that the prosecutors did, wouldn't that be an acquittal as opposed to a retrial?
be a new trial. No, it'd be a new trial.
It won't be an acquittal.
Yeah, because it's going to be acquittal anyway, and it'd be a
That's
new
what I'm
trial.
saying. That's
No,
my point
I
exactly.
don't understand what you're saying, because it's like in that particular situation, it'd be one and the same. It'd be an acquittal. He got acquitted.
Well, the reason I say acquittal is now double jeopardy kicks in because he acquitted pretty much. So now you can't bring forth the same charges because he's acquitted. But with a retrial, you have a trial, or you do it over again and set up in front of a new jury.
No, that's not how it works. Double
Okay,
jeopardy. Double jeopardy. It would be the same circumstances if they had retried the 2008 case over again with the same charges and same jurisdiction.
right. You can't do that.
Or, you understand what I'm saying? So that would be
Right.
double jeopardy. Double jeopardy attaches after the jury
But
is
check it
seated.
out. Check it out. Did they damn near do that? Uh,
Well,
didn't they
no,
damn near do that with Illinois before they dropped the case? It wasn't in the same jurisdiction. It wasn't the same charges, but it had the same ingredients.
yeah, but they avoided it because it
Right.
was
So I
different.
say that to say, that they will probably just bring a new charge that that's the same but different.
Well, no, but with federal, it's a little different, because with federal, the penal code, they're broad for a reason. It's not as precise as state codes are. So sexual exploitation is probably the only thing that they have for that type of, for those those elements that happen. So the elements are going to be too similar. And
My
what are
brain
they going
can't handle all this shit at this
to? That's
time.
what I'm saying. So you ain't listen. You ain't finna get me all confused and me give
I,
up
I do
all.
have a question though. I do have a question. I do have a
Yeah.
question when it comes to elements. Now he was charged for coercion and enticement, and then he was charged for coercion and enticement, a minor. What's the difference for the same for the same same person for Jane
Well,
Doe?
wasn't one under the RICO and one under
No, 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 no. No, no. This is for her alone. For her alone.
I
It was.
understand that, but wasn't one set, the coercion and enticement was under the RICO, and then she had a separate count somewhere down in the indictment?
I mean, her accounts and the RICO was damn near intertwined because she had herpes. Uh, But what I'm talking about is I'm not talking about the RICO. I'm talking about her charges alone, outside of the RICO. One of the
But she
charges was
wasn't in the.
one of them
But
was
she had.
coercion and enticement because she had four of them. One of them was coercion and enticement, and another one was coercion and enticement as a minor or a minor or some shit.
Let me pull up the document
Yeah,
because
pull
that's
up the
all.
verdict sheet so you can see what I'm saying. If you got it, the
All
verdict
right,
sheet.
I'm gonna pull up the indictment because hold on, pretty sure indictment. Hold on, indictment. You know my baby.
And then for the racketeering, they had traveled across state lines and traveled across state lines as a minor. Same shit.
I don't remember that minor word, but I'll take
It
your
was
word.
one with and one without for the racketeering, and one with just hers.
Okay, let me put it up here. Hey, my starer. I love my starer. Hold on, let me put it up. I say this every time I move to a different computer. I don't never do it. I just get another computer and keep it in the box. You know my
I don't
baby.
even use my. I use my phone more than my damn computer.
I can see that. Okay. Where was. Okay. She is. All right. We got count one. This is the RICO. Count one.
Puerto Rico. So to start at two, then
Right, but she's in one. She's.
she's
I'm
in.
trying to.
She's in one. Her and Jane. I mean, her and Faith is in one. I get that, but I'm not
She's in
talking
count
about that. I'm talking about hers alone, outside of the RICO.
outside of the RICO.
Right.
So okay.
So you should just went to the verdict sheet. It would have been a lot easier.
Mm-mm. Cause I'm pretty sure you gonna ask me something else on this paper. Okay, count two. Jana number 5, Man Act Transportation, September 2015, October 2015. Man, okay, Man Act Transportation, Jana number 5. Man
Right.
Act Coercion Enticement, Jana number 5.
Okay.
Okay,
You
there's
see
the
why?
minor.
Do you see what I'm saying?
Okay, all right. So probably the herpes somewhere is the difference when she was under 18 and over 18. So let's see.
No, she got that too. That's separate. That's separate.
No. Hold on a minute. I'm saying
See,
there
keep
is
going to four. Go to four. I think four is the herpes.
no herpes is 3 too. 4.
Okay,
And
okay,
code.
okay. So one was New York, and one was okay. I see what you're saying.
Yeah.
See, and
So
then again, transportation of a minor, and then regular transportation without the minor. You see that too?
probably she wasn't a minor. See that's 2017. Like I was trying to tell you, this 2015. So she was a minor here, and she wasn't a minor there. Well, that's Jane number 6, but she was a minor there on 15 and minor 2015. 2015. Huh. Well, that's women. That's man at coercion and tights. Oh, okay. Is man act, coercion, and enticement
without the minor.
without the minor. Let me see what the codes are. 2422. Oh, okay, so they broke it up. So they got a 20, so they gave him a 2422A and a 2422B. Now we have to look at the code to see what's the difference. So the difference is in the codes.
Oh, okay.
Yeah.
You
So the
don't have to
difference
go through all that. You don't have to go through
is
all that.
the code. Yeah.
It's just something I saw, and I was like, it caught my attention. But
Yeah.
it ain't a big deal.
Yeah. So now what I was trying to say. Let me pull this other document up. When did when did he get convicted? Cause I cannot find Donnelly's um her when she denied him. She
Denied what?
denied him the day of his conviction.
Yeah, I remember that.
Remember what
Uh, right. Yep. Because
what
they
day?
kept on extending it. They kept on extending it, asking for more time. And she just did it the day of.
Yeah. Cause I remember her I remember the prosecution when they responded to J-Bo talking about the parents and stuff. They didn't really talk about the parents, but they talked. They addressed what she was talking about because it was as I told Levi, I said it wasn't enticement, coercion, and all of that for sex. It's enticement, coercion, all that for travel. And then what happened afterward is when the crime started at the travel, and then the sex and not crime. I'm sorry, the crime started when it went across state lines. Then the sex,
In the
not
sex, right.
not enticement for sex. So because remember, it was like she was enticing her to have sex with him and to keep his curiosity piqued and all of that. And then when I went back there and read it, I was like, no, she is using this evidence to defend against the enticement, the coercion to travel across state lines, being that is what when the crime started. They travel across the state lines, and then she allegedly got exposed to the herpes. Yeah.
Um, Now, looking at these text messages, do you see anything in these text messages that will supersede her charges or make them null and void, or
Um.
for or give any type of uh, reasonable doubt?
What you say now? The text messages? What now? You mean what you say upon a new trial?
No. The
Okay.
text messages, that everybody going crazy about. So
Mhm.
far, do you see anything in there that will affect her charges or give any type of reasonable doubt to her counts?
Yeah, they won't. Okay, here's the thing, right? Okay. Just say now, if he's granted a new trial and those text messages is in play, then I would be kind of worried if I'm, on team lock 'em up. Because here's the thing. You got to think about it now. You have a whole year or so worth of press, or more than that by the time that would happen. You got that. Then you got the human element of those people sitting on that stand and hearing about essentially somebody being coerced into committing a crime. That's how. Now that's not legally how it is, but that's how it may come across to a juror. So it may, depending on how she present her defense, it could, you know, render him a verdict of not guilty, or at least mitigate his criminality, right? Could say he's
Which one?
not all the way
Which count
guilty.
in particular? Which count in particular? Let's say it wasn't a new trial. Let's say that they actually utilized these with this trial. This is just a hypothetical.
Mm-hmm.
It's not a retrial, but they actually utilized these text messages to the fullest in the New York. Which count do you think it would affect for Asriel? Or which count do you think that it would give reasonable doubt to for Asriel? Or if is it all? Well, it can't be the herpes, so let's just cancel herpes out.
Well, but isn't her charges related to the
We just
herpes?
just read them. You
Well,
just read them off
herpes.
the.
Wait a minute. Herpes and sexual exploitation of a minor. Let me look at the. Hold on. Let
You
me look
just
at
read
the.
them.
Yeah, but I'm just saying. But you didn't. You told me to never mind. The RICO count. Is the RICO count? Is that sexual exploitation in there? I'm looking at it. Hold on.
Oh, okay.
Yeah, sexual exploitation of a child is in there. Is in the RICO.
Okay.
So you have, yeah, that can mitigate his criminal liability.
Which one?
Sexual exploitation of a child in that RICO, so that
And
RICO can fall apart, huh?
what's the so okay, RICO. Okay, so with the RICO, how many predicate acts that they need to prove for it to stick?
For what, 2 and 10 years? And
So
she
that's
got
stuck.
forced labor. Forced labor, that's dealing with her having sex too.
Well, yeah, with other people, and you had nephew to corroborate. They understand to corroborate that.
Restraint to that person. Hold on, wait a minute. Physical restraints and threats of physical restraint to that person or another person by means of serious harms and threat. Skin fun. But that don't really have anything to do with, whether it's him or nephew or whomever. They're talking about the
What's
forced labor is making her have sex. So it could be with him or
I
whomever.
get the abusive part you talking about?
No, you said that was with nephew. I said, well, it doesn't matter who it's with, because the elements.
Well, no, I was just saying.
Oh,
You're right. I was just saying that
okay.
nephew corroborated that. That's all I was saying. He got to
Uh,
understand it and corroborate that. Him and the other girl, the little mixed girl, can't think of her name. Okay, so let's talk about the RICO. You said only two within 2 years, right?
2 within 10 years. Two
Two
predicate
within
act.
10 years.
Two predicate act within 10 years. Ain't that's what it is?
Okay, so
Uh-huh.
you got Aaliyah. You got the bribery with Aaliyah, right?
Uh-huh.
That's stuck. That's up and it's stuck. Um, um, I need to look at it. I need to look. I can't think off the top of my head. I need to look at it. I think they overkilled that. I think that RICO was stand because they just overkilled it. Like they overkilled it. If you only need two within 10 years, I think that's stuck. Because
Hold on. I think it's
the her-
2 and 10 years. I know it's 25, huh?
the herpes is definitely there. It's staying
Yeah,
there. That's not going over.
two predicate crimes within 10 years must have been committed through the enterprise. So yeah, two,
Okay,
2 and 10. So
so
you need.
check this out. So
Mhm.
check this out. You got the herpes with Faith, and you got the herpes exposed. You got the herpes with Asriel. That's two within 10 years, right there, right?
Yeah, she's in there. Faith
So
is
that's
in there.
that Rico stuck regardless. That Rico stuck even if all the sexual shit come out, the herpes and that the herpes stand. The herpes stand. Ain't no way around that, right?
Yeah, like, but you got to, like I just said. I mean, I'm thinking that the prosecutor would be skilled enough to lay it out. Like, okay, it's the exposure and blase scars or whatever they how they lay that out.
Right.
But is it gonna
I'm
be
saying if
strong
they were to
enough?
try to dismantle it, I understand the prosecutor's
Right.
going to do what they do. I'm talking about the defense. If the defense tried to dismantle the RICO,
But and I hate, and I know he gonna be somewhere. Yeah, yeah. I hate to use JoJo's theory, but
what's that?
what if they say, based on those text messages, if it wasn't for her parents, she wouldn't have been there,
Wouldn't have been where?
been in this situation. They might not listen to the part that, hey, you have a right to go anywhere and expect no harm to be done to you. They might not hear that part. They might hear the part. You see that?
I feel that we've been there already, and we seen that with Rashana in Illinois,
Okay.
and we saw how that played out because
Okay.
if it wasn't for the parents lying to the government on R. Kelly's behalf, it wouldn't be no we wouldn't be in the they wouldn't have been in the
But
situation.
this is a little different because this one won't be on R. Kelly's behalf. Remember, based on them
No,
text
yeah,
messages, yeah, that the parent, the mama started off and was real active in her being there, in this situation.
so when I see the text messages, right, I see the mother saying some real fucked up shit. As I feel like she's dangling her daughter in front of this motherfucker. However, I don't see her crossing the line all the way to saying "fuck," go ahead and knock him down. She ain't saying that. Now, when you go to R. Kelly coercion and enticement, he's saying he's going all the way there. He said, "I need to bust a nut before you sing any goddamn thing. Uh,
Yeah, good
I need
point.
to eat your asshole out." He's going all the way there. As
Okay.
opposed to mother, she's saying, get him a lap dance. You know, sit on his lap, rub his head. She is fucked up, but it's not like she's going all the way explicit with it like R. Kelly doing.
Yeah, but there's a part early on in what we read, and it says something like she was given a lot of instructions about what was it? Because I only read to
Yeah,
think page
he told
11.
her, and I'm paraphrasing. She told her, don't dress too grown. Take that lipstick off. He like them. You like young people, shit like that.
But
That's
I
what.
thought it said something, but because if you give it to him, he's gonna lose interest.
Right, she did say that.
Yeah.
So that's what I'm
Okay.
saying. It's like she's not going all the way there because she's saying that he's trying to fuck. You need to focus on your music. You can't do this because he's gonna lose interest and not respect you. So it's like she is telling her to be extremely flirtatious with this motherfucker to a grown ass man, which is fucked up. But at the
Yeah.
same time, she's saying, "Don't fuck this nigga. He trying to fuck you, but you need to fuck. You need to stay focused on your music."
Right. And somebody said, Lord have mercy, and I said, and another action that may help, that just kind of helps me with this with her, the mama, is
Mm.
that she did get on the stage and try to get her, didn't it? And then got arrested or something, right?
That don't help. What the fuck? To me,
Well, what
that
I'm
don't
saying
help.
is, mother,
That don't. That's because she wasn't. She lost contact with her. That don't got nothing to do with all this fucked up shit she was saying in these text messages.
right,
Uh,
but
I think the link is pinned to the top, right? Ain't the link pinned to the top?
hold on, I'll pin it. Um, the I think, uh, but what I see, it looks like, hey Samantha, what's up, Jay Taylor, Courtney? What I'm saying is that kind of mitigates the mama
I don't
looking
think so. I don't think
totally,
so.
totally bad. She did try to get the child.
I don't think so. I think that was strictly because she lost contact with her. I believe that this fucked up ass mama was trying to dangle her daughter and do all this sexual ass shit for stardom. Whatever it takes. I wouldn't say whatever it takes, because I don't think she she didn't say fuck the motherfucker. Although that, that's what
I
ended up
see,
happening.
yeah.
Uh uh um and it was all for, shit, we gotta, you know, if this was gonna take for you to get stardom, sit on this grown ass nigga lap, rub his head, get him a lap dance for stardom. Not to set. I don't see no setup in this shit. Like people say, oh, they tried to set him up. I don't see no setup at all. I see that they tried to get stardom for their damn daughter,
Mm.
and they did some fucked up shit to influence that.
What's up, Jay Taylor? Yeah.
Hey,
Jeff,
Angie, how you
what
doing?
what
All
up?
right.
Robert Keller, how you doing?
I'm good, man.
All right,
Yeah.
all right.
That's some.
I Go ahead. I'm sorry.
No, go ahead. Go ahead.
Okay. In it, well, I was just catching the butt end of the exchange that you were having, and I think the discrepancy here is whether or not the young lady Jane Doe number 5 and the mother were in cahoots with I don't like to use the word setup. I like to use the word frame,
Yeah.
because whenever there's a discrepancy, if I can um if I could paint a picture of you, and I think Angie is an advocate of this ideology that I'm about to illustrate. If someone is going to give you a option to say, I want to be a part of this crime, right? And if you don't have any awareness of that crime, then you should not be subjected, or you should not be held accountable. These text messages basically show that R. Kelly was not aware of that he was doing any criminal activity because he was under the impression multiple times that this young lady was of age. But if you look at the text messages, for one instance, he was going to take them to an event, and you had to be 18 or older to be at that event. And the mother told her, "Well, look, you know you got to be 18. Put your ID, leave it in your car." Or another occasion was, don't act like you left it at home or whatever. So that dispels one of the predicate acts, that he had any knowledge of her age. Because if you have to hide your identification to attend an event and tell them that,
Elements. That's the predicate. One of the elements.
okay, one of the elements, I'm sorry. But so he had no knowledge that she was under the age of 18 at the parent, the mother's admission. So at some point she told him, "You're gonna have to he's doing things in the public domain, so you're gonna have to tell him your real age eventually." So that there's another element that shows that he had no knowledge that she was under the age of 18. This is in the text messages. So you had, now as far as any sexual interaction, the mother was definitely encouraging that. She told him, he's a Capricorn. He likes to have intimacy slowly and things of that nature. So you have that element as well, where he's not even really paying me any attention. Like, it took him a while to even notice her. He's dealing with so many different people. So you got all these different people that he's dealing with on business, other aspects, and he didn't really pay her no attention. We saw note of that in the text messages. The mother even said at one point, "This man has spent over $20,000 on you, and you didn't give him any sex." So that also was groundbreaking. Like, this man treated her very well and didn't ask for anything in exchange. So, when you factor in all of that, and there's more to come, there's just a few things I could think of off the top of my brain that let me know that, for one, this man was not knowledgeable of her real age. He didn't pursue her sexually. That's another. And then the mother was the one that she even used the word, "You have to entice him." The same word, the terminology that the government used to describe what she used in her illustration. So my question to anybody that has any questions, as far as this man had any criminal accountability, how can he be held criminally accountable when he had no knowledge that she was under the age of 18? He had no interest in her sexually. This is all due to the text messages that we've been reviewing. So I'll fall back and yield back and let y'all weigh in on that.
I don't think the text.
Well, the reason that we've been saying for a minute, and it again is also on Nicole's website, is that per the law, they say that as an adult, you should reasonably know that you're dealing with a minor. So it don't matter what those text messages say. This is already scribbled in the law.
And I was just going to say the same thing with as far as the text message. I don't think we even need the text message for that. By her own admission in court, she testified that she lied about her age and didn't tell him until she had to go to school.
Right.
So the text message, that wasn't a reveal. The jury was well aware of that by her own admission. But as far as him, simple ID check would property counsel some 4 counts out.
Okay,
You see your ID.
Let's put a timestamp right there. Now she admitted that she lied about her age, right? And we all are well aware of that, as you and Angie had just illustrated that point. So, but that is ignorance of the law is no defense for the law. I think that's what the point that you guys are making.
No, that's not the point.
He has to do his due diligence as an adult.
Yeah, well, that's a good way of putting it. It's just that's just in the understanding of the law, that it states that you should have a reasonable, you should be reasonably aware that you're dealing with someone that's under 18.
And it don't require you much. Let me see your ID.
Okay, now let's stop right there. Now, is it not a fact that she presented identification to law enforcement when they were in the Dolphin Hotel, and the ID that was presented, the police substantiated that she was 18 years old?
So here's the problem with that. Before the officers even came to the room, he was already eating them groceries before they even came to the room.
That's irrelevant.
No, listen to me. Without checking her ID, he already started eating her groceries. The officers came to the room, asked for ID, then he started back. So the act was already committed before the officers even came to the room. He was already eating groceries without checking her ID.
All of that is speculation. That's not fact. But
that's what was testified against. I mean, that's what she testified. That's in the transcripts. It's not speculation.
It's in the transcript, but it's not nothing that I could say that they charged them with. What I would say is this: the bigger issue is that identification was presented that night that substantiated that she was 18 years old.
Okay, well, Jeff. Okay, so let me ask you this. Okay, so let's go with this. So Jeff, so she shows them the ID that she shows the cops the ID that she was 18 years old. Okay, what is the point that you're saying with that? So, because I think I know where you're going, so I could.
They didn't ask her
my
age.
Point. Yeah, my point is.
I can go with both of y'all. So so she showed them her ID, and it said she was 18, or it said she wasn't 18.
So this is my thing. If she told him, he asked her, she testified, he asked her, "Are you 18? Yes, I am. Okay. Police is at the door. You have ID. Yes. She gives the police, these are officers of the law. She gives them the ID. They look at it. Okay. Y'all have a good night. She's of age. We're gone. The parents are aware. She's aware. He's aware. Everybody's coherent. So they all agreed that she was of age. So how does he become accountable when you have 1, the parents, you have 2, law enforcement, and you have 3, her, saying that I am 18 years old? So how did that get overlooked over all of these 3 different, levels of people that checked to make sure she was of age, including her parents? How is he accountable when everybody said that she was of age?
Okay, so here's the thing. So I'm gonna give you a whole bunch of scenarios. Just say, okay, you saying, I'm going with what you said. The cops said she was 18. The cops didn't allegedly have sex with her under 18. Okay, because we don't went through this before. It's supposed to be, again, he is supposed to know, reasonably know, that he is dealing with the minor. It is on his ex-attorney's website, almost the same exact language.
But Miss Angie, let me ask you a question.
Hold on.
Okay.
So the cops, so whether or not, and here's the thing, they could have looked at her license and seen that she was 16 and say, y'all have a good night.
Right.
The law
Well,
says
they should be held accountable.
no.
They weren't confirming her age. It's confirming her identity, not her age.
Supposed to be having sex.
Right. They didn't know they was having sex.
Yeah, they don't mean that you're supposed to be there having sex. You just so it doesn't matter if she was over 18, if she was under 18. The problem came in when there was alleged sex with the minor. That's wherever it was, whoever checked the ID. And if it was fake ID, he's still gonna be at fault.
I think if it was a fake ID, he'd have a better defense. If it was a fake ID.
No, they already
I mean, that's what
they already tried a mistake of fact, mistake of age. The judge didn't allow it. That only would mitigate his criminal liability. That wouldn't absorb him of it unless a jury found that, hey, he truly was tricked into this crime,
Right.
What did you say, Court Love?
I think you answered my question, but how you doing, Angie? It's good
All
to
right,
be here.
I'm good.
It's good to hear from you too.
Yes,
okay,
ma'am.
Now you said that. Now you have went over this with us, especially me and Sky, about him having to be responsible of knowing how old she was. Well, I wonder if he reasonably thought that she was 18.
Okay.
Exactly.
He thought she was 18.
If he reasonably, am I asking the question right? Am I interpreting?
Yeah, that's right. If he thought she was 18, but he didn't know for sure, he still is going to bear some liability per the law.
When I was looking at these text messages, he was.
Go ahead.
Okay, but one more question. Hey, how you doing, Keller?
I'm all right.
A long time no here. But okay, so is this back to what I'm saying, and I have said this before. So is it reasonably a RICO?
Yeah, if all the circumstances can apply, it could be
I think they overkilled that RICO word. It's stuck. It's stuck.
Mm-hmm. But for the sake of us, because I feel like even though we have not met each other face to face, but we've been here 4 years, and in 4 years we see the personality of Angelo Clary. In 4 years we see the personality of Alice. And in 4 years, we see the personalities of these players. So I want to just say safe on this side that when we use those words like Keller has said, set up. When I use the word set up, I don't mean, he was set up to get arrested. He was set up to do the things that somebody just said. He was set up for stardom. That's
Right.
the
I agree with that. I agree with that. But that's not illegal. That's not legal.
Right. But
I agree with that.
But I'm still saying that when we use when we on this other side of the fence, because sometimes Miss Angie, she gets a little confused on when we come in with the what did you call it a long time ago? Street law. You know, when we come in, this is what we're saying. And then, you know, I'll fall back. But for the sake of the argument and the debate, even before this came, Ray Charles could see that these parents was involved in this way before any of this came out. And I always ask people, and I'll fall back because it's a good panel. If you look at the way they broke, I'm talking about when I say when CNN, when those major news networks was involved in this, when they did that Gayle King, the validity of what she was saying was there. It's there. It's there in the interview. It's there.
Right. I see what you're saying. I mean,
I'll say this.
uh-huh.
I'm sorry. Go ahead.
No, go ahead. Go ahead.
Yeah, I would say that. I say that whole Dolphin motel, whatever, that is all hearsay.
Yeah.
I think that never happened because the text messages suggest something totally different happened. Because at that particular time, if you look at the time frame and the timestamp with the text messages, that's when she said, the mom said that this man, you know, at this time he had already flew her there. She been, you know, rotating with his camp. This man that spent $20,000 on you, he did this, he did that, he not paying no attention. So if as a man, and Robert Kelly, you a man, if you have had intercourse, sex with a woman prior to any of that, why would you stop? You know what I'm saying? You're gonna continue to do what you're doing.
Your timeline off. So the Dolphin Hotel came way before she was being flown out. Now she got flown out directly after that.
Right. Okay, that even makes my point even more. So,
but you know, you said that it already happened, and he spent $20,000 on her. No, it didn't happen. He didn't fly her out yet. That was for the audition. That's for the audition when she left school. So none of the flights happened at that time. He didn't spend no money on her yet.
Okay, so
I'm just saying, you got your timeline off.
Okay, the timeline off. Let's rationalize this. If the timeline is off, and the mama said, so you think he spent $20,000 on her before he flew out?
See, I haven't read that. I stopped reading those text messages, so I can't really comment on that. But what I'm saying is, he didn't spend no money on her prior to the Dolphin Hotel. That's what I'm saying.
Okay, all right. So prior to that,
I can't read all them text messages, so I didn't even get that far. Like, that's new to me.
Yeah. She actually said,
I couldn't stomach that shit.
Yeah, in the text messages said this is she already is all the way in at this point. She's basically living with him, and he's not paying her too much attention. He had already spent the bag. You know what I'm saying? And he like not even going there with her, and she's relaying that to the mother, like, well, he's not even on that. I'm not on that. We just chilling. And the mother is pushing that on her. Well, you stupid. You know what I'm saying? Well, make sure you do your music. But at the end of the day, what I'm trying to convey is this. If a man is courting a woman and trying to seek something intimate with her, at some point, he's going to make that known. He didn't make that known for months on end with her being inside the camp. I would suggest
make what known. What you mean?
He didn't make it known that he was interested in her.
He made it known the very first day he saw her before with the audition. What do you mean?
No, I mean, she said it in the text messages, like he's not even on that. She said that, like, he's not trying to pursue me.
She said in court that her parents wasn't aware that what went down in the hotels. So of course she's telling her parents that.
I
You
mean,
know, she kept it. She kept it from them. You know, her mother is, you know, pushing her to, you know, to be flirtatious towards him, unbeknownst to her that shit already going down.
but you got
Shit
to
already going
understand,
down.
the mom is sitting up there telling her, asking her, "Did you kiss him yet?"
And she already did more than that. Is what I'm trying to tell you. As she's telling her this, she has already did way more than that.
How do you know that?
Not according
Because she
to
testified that they had sex almost every
Keller,
day.
always okay now. Keller, you
Nah, you
always
tripping
get
that,
up
bro.
here and you we had this dialogue with you and you
Mm.
always talking like this is facts. It's not facts.
No, no, I'm just going off what was said in the transcripts.
Okay, we
So
know
I'm
that. We all
okay.
we all
It's not coming from me. It's coming from what came out on the record.
okay, we got
I'm
that.
not making this up. I'm not making this up.
We
It
didn't
was on
say
the record.
we know we know you we none of us is making this up. Okay, but it for the education of the people that's in the chat and on the panel. I heard okay, it took other people 4 days and they still not finished reading them text messages. It's on all kinds of platforms. It's
Hmm.
just not only in our R. Kelly sector. It's all over. It's on the radio. And I
Right.
also said that to say those text messages, to my knowledge, is 153 pages.
Okay. So
Okay, but
134,
let me
but
finish
it was
this.
close.
Okay, but I just want to say this. If you following it and if you looking at it good and you coming from it from some people, you know, like me, she was there before Joycelyn.
Was
She
she?
was yes. When you
Oh,
okay,
I don't think so.
if I'm not clearly mistaken, they both came almost at the same time.
I think she was a year ahead. I don't know. What is it,
See, we
Taylor?
see, yeah, see, okay,
I
but
don't
okay,
know.
now I don't want to get off on no tangent, but
no, she wasn't because she said. Remember, she said, uh, Joyce. Remember when the thing happened on in Trump when they got into that fight? She said, Joycelyn, you slept with me as a minor. So,
Yeah,
so Joyce was already there.
yeah.
Joyce was already there
okay,
because
okay,
she came in as a minor. Joycelyn didn't.
I know that, I know that, but when you when you really actually, you know, take the time, because it's a lot to absorb when you're
Right.
when you're reading those text messages
Yeah.
and you have it's not pop those text messages.
I ain't finna absorb no more.
I know,
I
but
absorbed enough.
it is a lot to absorb. But then even on the flip side of that, if you just knew coming into that, you could clearly see that this was the coercion, the teaching, the all them other elements that they say R. Kelly did. Mama did that too,
Okay.
and
Oh,
she also said it was a group text.
wait a
It's
minute. Can I stop you real quick? You said
yes,
the
sir.
mama. You said the mama did that
It
too.
seems like the
Oh,
mother
wait,
was
hold on,
living
hold on, hold on. I'm
vicariously.
focusing on
She
the
was
word
living
too.
vicariously through
Okay, hold on, real quick, real quick.
yeah,
You said
yeah.
the mama did that too.
Yeah,
Too.
I'm saying okay. I said too
So that means
because
both
that's
of them
what they
guilty, right?
charge. Okay,
So if
I
the
take
mama
that.
did, if it's a problem for the mama to do it, it should be a problem for everybody else who do it, right?
Okay, okay, I bow down. I take that one, but
But
I'm gonna come and
but
correct you.
only one
I
person is
take
suffering the
okay,
consequences of that, though.
I take
Yeah,
that.
you're right. You're right. You're right. You're right.
Okay, okay. If that's what you want to say, but if you were following this, we clearly still knew, regardless, we knew everything was staged. Who is out there throwing rocks when the girl constantly kept saying, y'all knew where I was at? They knew.
Hey, the bottom line is this: in America, we have 50 states in America, right?
Mm.
In majority of these states, minors can be emancipated if their parent or guardian says that it's okay. You could marry a 14-year-old in this country if they are properly emancipated through their parent or legal guardian. So with that being said, if the parent is co-signing that behavior, then who are we to question it? And from this, you have
So
a piece of paper on a trapper keeper where that child, or you want to say child or whatever, young lady, however you want to
I'm
classify her.
questioning that shit. I'm questioning that shit.
Yeah, I'm saying, so if that is the case and you got these text messages to verify that the parents were in cahoots with the whole situation, then what are we really talking about? It's like, I look at it like this. This man has been given 30 years behind bars when
Mhm.
Shanquilla, she's been
Oh yeah,
murdered in
that
cold
shit pissed
blood,
me off. That shit pissed me the fuck off.
and they won't even bring charges
Yeah.
with that young lady's death. But
Well,
this
I mean, we
man,
don't know why they're not bringing charges. We don't know if they don't have enough evidence or whatever.
That's
We
what they
don't know.
said. They don't have enough. That's what they said. They don't have enough
Right.
evidence.
So, I mean,
I
I'm
don't
not
see
even
how
keeping up
not.
with it.
Shit.
But
I
But
don't
that's
see
what
how
I'm
not.
saying. Y'all always circumvent the law with what y'all think. But this is
mm,
what, because Jeff, because you ask this everywhere you go, you say the same thing. You ask the same question. We had the same argument. I'm reading from Nicole Blank Becker. This is
He
mhm.
gonna bring it up
Nikki,
again. He gonna bring it up again.
Nikki, who
Watch.
you love. Yeah, this is Nikki, who y'all love. Nikki. I'm reading his attorney. I'm gonna read it. It says solicitation of a minor. Definition: accosting, soliciting, or enticing a child for any immoral purpose. Okay, so if you translate that over to federal penal code, that means enticement, coercion, whatever, man act, sexual exploitation or whatever. It says, according to MCL 750.145A, a person will be charged with the solicitation of a minor if they accost, entice, or solicit a minor below 16 years of age. So this is must be in the state of Michigan. All right. This doesn't matter whether the person is aware that the individual is a minor, aware of the child's actual age, or an individual they believe is less than 16 years. However, the prosecution needs proof of force or intent to induce the minor to engage in an immoral act or to submit to sexual intercourse. Additionally, a person will be guilty of solicitation of a minor if they encourage a minor to meet with them or other persons for the purpose of engaging in sex. Similarly, this doesn't matter whether the offender is aware of the child's age, knows the child's actual age, or believes the individual is below 16 years old. And it kind of repeats itself. So I'm telling you what the language of the law expresses.
I'm
But she
Just what
wasn't,
happy
I
that
said.
she wasn't
I'm
16 or below.
I'm happy that you recited that law, Miss Angie. Now, I would
I'm
ask that you recite.
beautiful.
I would ask that
Uh-huh.
you recite the law and make it more targeted. In Illinois, there's a law called mistaken of age identity.
Right. That okay, that could be. That could be.
So
Go ahead.
the,
But that
that,
what but
that
what that
What's the
law
law in
does,
Florida? What's the law in Florida? What happened there? Is it the same
well,
thing?
it doesn't matter because but go ahead though, because I'm gonna go with Illinois. What you
it's a law called mistaken of age. If you are in a situation like Mr. Kelly, and in Illinois, if you are not, I don't know the law verbatim, but if you have a mistaken of understanding of that person's age, if you think that they're of age, then you are exempt from that law. You know what I'm saying? Because if someone's sitting here telling you they're 18, they're of age, and actually the age of consent in Illinois is 17. So we're talking about 3 or 4 month difference between 17 and 18 for one. Let's make that clear.
You're shaving off some of what that law says. But because I'm gonna put it up, because you the one brought it up. I'm gonna put it up.
Okay.
I'm gonna put it up. Because
Yeah, I'm just
because it also hold on. It also okay, here we go. Mistake of age. And coincidentally, this is the same defense that the brothers Johnsons tried to get approved through the judge, right? And the judge didn't grant it, right? She denied it. Mistake of age. Unlike most states, Illinois does recognize a mistake of age defense for statutory rape crimes in some circumstances. It is also a defense to a charge of criminal sexual abuse that the defendant believed a child aged 13 to 16 was actually 17 or older. It is also a defense to a charge of criminal sexual abuse if a defendant younger than 17 believed to be a child 17 or older. In both situations,
stop right there. 17 or older. How old was she?
17.
17 or older.
And older.
But that's the Illinois is 17. That's why it's not. It's, Florida is 18. Florida is 18. But go ahead.
But I don't think Florida was in the indictment. I think, but it's null and void anyway because it's federal 18. But I don't think Florida was in the indictment.
So they just use federal.
Yeah, but if you're talking about Illinois, and we're gonna be specific because they do reference some Illinois penal codes, and you can reference that as a use that as a binding authority in a federal case or whatever, and so they did put and I'm talking about in the federal case in Illinois. The charge in Illinois is 17, and it was 5 years. How y'all write it in Illinois?
Well, it's like, if you 5 years that senior and they're a minor, you good within that 5 year,
so it's like a 5 year grace.
Yeah, so he obviously exceeds that, but at the end of the day,
I thought they said 3 years in trial. I thought they said 3 instead of 5.
I think it's 5.
Either way, he was well over that. So,
okay, but hold on. But see, like I said, you shaving because the first line says, unlike most states, Illinois does recognize a mistake of age defense for statutory rape crimes in some circumstances. And then the last line, it says, in both situations, the defendant must have had a good reason to believe the minor was 17 years or older, which means that the judge, if just say the only thing the judge had to go on was the fact that she had a fake ID, and I'll just keep using fake ID. I'm just using it hypothetically. She had a fake ID, or that the mama verbally out of her mouth said that she was 18, not texting something verbally out of her mouth. Then that to me would satisfy a judge having a good reason. But if you got multiple documents, like you at her graduation, you sent her back, you have sex after you find out allegedly that she is, that she's just 17. Or
now what did he do when he found out her age? They said he slapped her and sent her back home.
Right, and then she came back, but she went back home allegedly, if I'm not mistaken, I don't know, to get to come back to get some
Homeschool.
type of permission slip to be
To get
She was
homeschooled.
emancipated. She was
No,
emancipated.
that's
not
no.
emancipation.
That's that Danny J shit.
Emancipation is a legally
Whole court
filed
proceeding.
procedure. It doesn't really have to be a court procedure, but it has to be filed with the court that person is emancipated.
By that time, she was probably already 18. That's
But
what
she wasn't. We know her date of birth was December, so she wasn't.
But
December 30th. So it wasn't. She wasn't.
Who's to say it wasn't? You know what I'm saying?
We
That's
can say that
speculation.
because we know her date of birth is December 30th. So we can say that in great confidence that she wasn't, because we know her date of birth.
So when did they allegedly have
September.
sexual intercourse?
It's September, and it expired on her birthday. It expired when she turned 18.
So we have.
Coincidentally,
So
when she
you
turned 18,
saying
it
that
expired.
we have concrete evidence that they had sexual intercourse in September?
No, well, he found out about her age when she had to go back to school. Okay, so school started back August, September. She sent a message in October after he found out to one of her friends saying he nutted in me today, because she thought she was pregnant. And this after the fact. This after he found out her age. Since we want to talk about text messages, let's talk about that text message she sent to her friend. He nutted in me today. This is after he found out her real age.
I'm not privy to that information, but I'll say this. If he was aware that she was underage
Mm-hmm.
and they had sexual contact, I would like to see that transcript. I would like to see that.
Pull it up. Nutted. Put nutted in the goddamn keyword.
But it really doesn't matter because the parents pretty much co-signed the behavior. They was like,
the parents signed the parents cannot consent, so it don't matter. It don't matter.
Yeah, that's
The
the other
parents
thing
can't
I was
consent.
saying, Jeff, when you said that, like parents can give cosign that you can get married. Yeah, and this might sound crazy, but this is the law. Parents can co-sign for you to get married in some states at certain ages under 18, but they cannot say that you can have sex with an adult. Their ass is criminally liable, and so as the person that they have sex
That
with.
happened. Didn't that happen recently? Did that happen like a couple months ago?
Love you too, Donovan.
Didn't that happen a couple months ago? And they arrest the mother when the daughter got pregnant.
I'm not sure.
I got to look into that. A situation like that happened recently.
I don't know.
I gotta look into that.
So what I'm saying is, like, I know people have their theories, and as long as, and this is what I teach my class. As long as your theory, and I'll even take a conspiracy theory, as long as it's based off the facts in the case, I don't care. We can explore it. But when you have, like, alternate stuff and extra stuff and whatever, and y'all up here, y'all not doing that. That more of that's a Levi thing.
I got a question. I got a question for you, Jeff. So when she turned 18, she immediately the contact with her parents slowly but surely diminished to nothing once she turned 18. Why do you think that happened?
I think she probably got tired of. I mean, you could look at the text messages and see how pressed the mother was. She was just like text messaging up 40 going north, and she finally figured,
But
"Hey,
she could have
I'm of
okay. She could
age
have been
now."
did that. She could have been did that a long time ago.
But
Why
no,
18? Why 18? Why as soon as you turn 18, instantly it stops?
because she feel like I'm grown now. I was already dealing with this man on some type of level that could be interpreted however
So
you want to
so
interpret it. But
so at
I'm
18, she
grown
no
now.
longer
You know
need.
what do I
So
need you? You
so
know,
at 18, she no longer need her parents. Is what you pretty much saying.
I'm saying that legally she didn't need their consent at
Legally, I got
18.
you. Got you. Well, I said that to say this. In the text message, R. Kelly said, "Do you think your parents is your parents strict? Do you think your parents will allow you to fly?" He asked her this. Uh, the mere fact that he said parents indicate that she ain't grown.
If she needed her parent consent,
Don't need her parents for nothing at 18.
no, she don't.
Okay.
But at the end of the day, she's still gonna be their child, and she wants to make sure that they're able to agree to that. She was being respectful to her
Okay, so
parents.
let's go to this then. Let's go to this. The permission slip.
Hey, Sir
Guardianship.
Good evening.
What's up, Miss Sir McGill? So
Something Scully.
guardianship to who was it? Cheryl. What was her name?
Cheryl
Mack.
Mack.
No. Who they give guardianship to with the letter?
Supposedly Valerie Payton, but that
Valerie Payton.
wasn't that wasn't true though.
Right, it wasn't right. But on the permission slip, it says we're gonna give guardianship to that lady, and it expired when she turned 18. So therefore, he already know that you're 18. We don't need your parents. But prior to that, he asking about her parents.
Nah, excuse me. I believe the permission slip came in after Asriel told him how
It did.
old she was.
It did. It did.
All right. Now hold on. According to the text messages, Cheryl Mack was moving Asriel around.
Valerie Payton.
No, Cheryl
There
Mack.
was no
Cheryl
Valerie
Mack.
Payton.
Right. I'm just saying that on the permission slip, it was Valerie Payton.
Wasn't a permission slip. It was written on a notepad.
It could have been
Wasn't even
written on a goddamn
notarized.
napkin. It could have been written on a napkin. It don't
Doesn't
matter.
matter. It wasn't notarized though. So it was something they came up with at the end of the day. But let me say this real quick.
One was.
Keep this in mind. She gave 2 different birthdays. She said 97, December 97,
Okay.
and December 98. So nobody really knows how old she is, number one. Number
When did
2,
she do that? When did she do that?
go look it up.
I'm asking you.
Go look it up.
Okay.
Because she even have it under her on one of her social media pages as well. But anyway, number 2, I'm go back to what Jeff said earlier. When she was traveling, R. Kelly never was at the hotel with her at all. Period. Because even her own parents said they was always sending somebody with her, which was a lie.
That was a lie.
Number 3, if you look at those text messages, there's some text messages that are missing all throughout there. Because she even said in one of the text messages, make sure you don't take no pictures with R. Kelly. So let that sink in a little bit. It's still a little messy in between, but at the end of the day, the parents was wrong, number 1.
Yeah.
Number 2, whatever was on there, she was already involved in the case from the jump. She was already doing stuff for us, hiding her phone, recording stuff, this, that, and the third. So it's a lot of details in those text messages. And I'm gonna leave it at that.
And also it's a lot of details in that text message on when she went and spoke to the grand jury, because in the text messages she refers to the grand jury as the jury.
Mm-hmm.
See, Keller, I came in last. You ain't you like you said, you ain't read all of them. It's literally 4 and 5 parts to this, taking 4 and 5 hours to read these text messages.
I don't need that. I already got my decision. I think at this point, on both sides, we can all agree that the parents fucked up. So I think we both have that. There's no argument that this mother, her mother, did
But
some
that
fucked up,
but
fucked up shit.
our argument now, okay, let me get this so it won't get lost in translation. Our
Mhm.
argument now is we've been saying that 4 years ago.
That's true. That's true.
Mhm.
But I'm saying now, we all on both sides gonna be in total agreement with that shit.
Oh yeah.
There's no argument with that.
And we gon' uh and then also for us well, for me, you know, when I heard R. Kelly speak, he's gonna speak again. And when I heard when because that on our side now, I'm quite sure Sir Miguel will agree to it, that when we finally heard this man speak, because see, we never heard him speak. He's gonna speak again.
True enough, and that's
He's
the
gonna speak
thing.
again, and that's facts.
If he don't speak, it's a problem. When he do speak, it's a problem.
Right.
And I'm gonna say this much: you can call it whatever you want to call it, but at the end of the day, right is right, wrong is wrong. But when you cheat or you do stuff that's not, I would say, not of sound mind in terms of trying to get somebody, when you technically sort of cheat or you do conniving things, because remember, at the end of the day, Judge Donnelly should allow that stuff to come in, irregardless whatever happens on the defense side or whatever had it came up, because those parents should have been held responsible from the jump.
Thank you.
It's no different than when a kid go out and kill somebody, they'll hold the parent responsible for that child killing somebody. But at the same time, if a child or a boy or a girl go have sex, that's an issue. Hold on a minute. If they
Man,
got the mind, if they can think of using a gun, then at the end of the day, if they go lay down with somebody, they got enough intelligence to know that they gonna be spreading their legs to do whatever they need
Thank,
to do. So don't tell me that kids don't know right from wrong, because even
thank
the
you.
Bible says a child is known by his or her wrongdoings. So don't get it twisted.
well, I think if a child should know right from wrong, a grown up definitely should know right from wrong. But what? When you say the judge should have let stuff in, what are you referring to that she didn't let in?
She should have let them text messages come in.
The text
Period.
messages were in. She just read that the government mentioned it in the transcript. Text messages were in. Angie read that in the beginning of her. I don't know if you may not have been here, but yeah, it was in. The government read it. And she
Well,
said that yes, that was my phone. That's my text message from my phone I had in high school. So it was in.
was all the text messages or was part of it in there?
Exhibit 233. I would like to submit the evidence. Is there any objections? Koenig said, "No, Your Honor." And she began to ask Azriel, "What is this?" She said, This is the text messages of the phone I had when I was in high school. It's in. She let that in.
Well, I'm leaning toward that it's the whole thread was in, but it also could mean that sections of it was in, because see,
Mm-hmm.
233 also apparently was her phone as well. Not only was it the text messages, it was her phone as well, and we don't see her phone with that, that with 233. So you know me, I like to be
But when they
technical.
asked her, when they asked her, they start asking her questions about text messages. And I think 233 is the whole thing. Now, when we see this 233 G, B, C, I think those are highlights of
Yeah,
233
those are our highlights. But what I'm
or bullet
saying
points,
is,
whatever.
what I'm saying is, but also 233 also has her phone, because the prosecutor said, "What is this? This is my phone I had in high school." That is
Right.
also
And right after that, they start asking her questions about
right.
text messages. Directly after that,
Right after
they
that, you're right. Right
they
after
start
that,
asking her messages about text messages, and she's looking at the exhibit. So they got a phone to pull data off, and I think
don't
what they
know
pulled,
if go ahead.
they pulled everything off that damn phone that they could.
Y'all
Right.
gotta take that. You gotta take that L, man. Like, at the end of the day, we just gotta keep everything real, keep everything copacetic. The mother,
Shit,
and those
they
text
gotta take
messages.
their L. Shit, I ain't taking no L. They gotta take their L. Mama taking the L, not me.
I'm just saying, like you advocating for, who you advocating for. At the end of the
I'm
day,
advocating for fucking but him being held responsible for his actions. That's what I'm advocating for. And
but
and the parents
not.
is being exposed. That means they took the L, and charges need to be, if any, need to be brought upon them,
Yeah, the
and
text
so they can
messages
be held
is
responsible for
out
their
here.
actions. Huh?
So you can't you cannot ignore, you cannot discredit the text messages, because
I'm not.
for
I'm
one
not.
they show that the man did not pursue that girl. They show, for one another,
Oh,
that
I know
he
that.
did not
Well, the
know
text message is not
the
going to tell the whole
age.
story.
The age is he didn't know that. You know what I'm saying? And for three, it shows that the mother, the parent, was the one that was pursuing, the one that pushed that girl to do what she was doing. So you can't
Uh,
sit up here and say that that
so
man was held accountable
uh,
without any influence. You know what I'm saying? That he wasn't on that.
so the text
Let me
messages,
go ahead.
the text message is not going to tell the entire story, although it is additional pieces to the puzzle. However, it's not the full puzzle. Uh, um, um, and again, we don't need the text messages to come to the conclusion or to understand that she lied about her age. She admitted that under her own admission in court. So
Right.
there wasn't a revelation because of the text messages. To
It's just
me,
the text messages substantiate. They just substantiate what we already knew. So if we already know that, then what are we talking about?
the text messages exposed how fucked up parents really was. That's why I'm getting out of these text messages, more than anything, how fucked up this mother was.
There you go. And so we can agree on that. So we made some progress with that. That's something that we can agree on.
Right.
So
Like I
if the
said,
parent,
like I told McGill, that I don't think it'll be no argument with, on both sides when it comes to this mother.
But let me say something else with regards to the text messages, right? So then this is another way that they could have been utilized, what have you. All right. So during the bond process, and it carried through his trial, if I'm not mistaken, and you can correct me if I'm wrong, Keller, they were considered calling him a predator, right? Saying that, and giving different examples. Now, I'm not taking away from other examples, that they gave,
Mhm.
allegedly of him,
So you
some,
gotta put all the examples in there. But go ahead.
huh?
You gotta look at everything. But go ahead.
Right. But if you utilize those text messages in a way that can kind of defend against the predatory nature with regards to Jane Doe number 5, right?
If
Say for
if
Yep.
instance, wait a minute. Say for
if she was
instance,
the only one on if she was the
Wait a
only
minute, I
one
just
that
said
trial was
Jane
about.
on 5. You ain't let me finish. Just say within those elements and the penal code, if you look at it all, the entire language expressed fully out, right? Just say within then you had something regarding his intent. His intent would speak to his MO, his predatory nature, all of that, right? And if it was it just if it was a state charge and they had, oh, I changed, let me change that. I got some more fitting. You know how I show y'all the sentencing tables, right? Like where to take it up, like you put in the actual penal code, and then it asks you questions, and if it asks you if that person is considered a predator or whatever, and normally, ain't normally, usually always that if that box is checked off, that adds an extra 2 or 3 years to somebody's sentence. If they could have utilized those text messages and could have been a defense to them calling him a predator or saying that he had, when he came to Jane Doe number 5, he had some kind of, predator, some type of predator ways and shit. The way he, coerced her to do this and go across state lines and all that shit like that. I mean, that could have, potentially could have been, or maybe still is, a wrongful sentencing if he got additional years on that guideline based on him being considered a predator with regards to only Jane Doe number 5. You know what I'm saying? And that
Mm-hmm.
lawyer didn't use that evidence to at least knock that out, because here's the thing, right? When you are standing up there in trial, as a trial attorney, right? And you got to think, you got to be on your foot and think, just say if he gets convicted, I
He
still
did
got to
get
make
convicted.
sure my client for Jane Doe number 5 doesn't get additional years if they prove every element, and that's what a prosecutor's supposed to do, prove every element of that particular charge. And if he had being a predator and all that in there, and just say he would have got extra time, and it could have been a shame if they didn't use those text messages to say, hey, he wasn't a predator, at least with regards to Jane Doe number 5. That's what I'm saying. So it's so much other, so many things that you know, those text messages could have spoken to, just
I
not
I
what we're
think
limiting them to. You understand what I'm
I think
saying?
they could.
Mm-hmm. Yeah, I understand.
I think using them text messages would have been detrimental to them. It's a double-edged sword, and you got to be careful because by exposing the parents of their behavior, you're also throwing your client under the bus in the process, because if you saying it's wrong for them doing this shit, it also got to be wrong for him to do it too, because
Right,
he's
but he's the
being
defendant
accused of the same
already.
thing.
He's
Huh?
the defendant already, so it wouldn't matter. He's the defendant. He's gonna get sentenced. If just say if he's found guilty, he's gonna get sentenced on something regardless.
Right.
Only
You
thing
don't
he
want
Exactly.
him
could,
to get sentenced. Right. But in the
only
in the
thing he could
trial,
have,
I get that
this could have mitigated his.
I
He could have had
I
a co-defendant. You know what I'm
I,
saying? Could
I,
have.
I get that, but
Yeah,
they don't want him to be found guilty on this. They don't want this is you got to remember, this is in the middle of the trial, so they don't want this charge to stick at all. So if you exposing the parents of their behavior and saying it's wrong for the parents to do it, if it's wrong for the parents to do it, got to be wrong for everybody else that mimic that
yeah,
behavior.
exactly. But I mean, like, with the evidence they had, I mean, it was, I mean, how could, the jury's
And
gonna find
then this is
him
not a
wrong?
trial. This is not a trial for the parents. So that's another thing you got to look at. Unfortunately, even though they did some fucked up shit, this trial ain't about the parents.
But no,
Yeah,
but keep in mind,
about the
to
parents,
keep.
but they did speak of the parents when she was
They
talking
made
about.
it. They made it where they didn't remember they was arguing about breaking them parents up to a certain extent.
And then what did
Right.
the judge say? They couldn't. She denied them from doing it.
No, but the prosecutor asked her about her mama texting. And see, that opened the door because guess what? As is a piece of direct
So
evidence,
so
she's
that
direct
opened
evidence
the
of her
door,
mama
right?
texting. Yeah.
Right. So that
But,
that opened the door for Kanik, right, to go ahead and explore that, right? But why
right.
didn't he? But why didn't he?
He didn't he didn't ask the he asked well, first of all, it was
Because it would have
Farinelli.
fucked his client up. That's what it would have
Huh?
fucked his client up.
No, not
It would have fucked his
necessarily.
client up.
It would sometimes, but Kelly, you got to understand.
He would have
Sometimes,
to be very careful. He would have to be very
sometimes,
careful.
but listen, Cannon had already came up with the defense that he was trying to mitigate his client's liability. If he couldn't get him totally off, he was trying to mitigate his client's liability. We saw that, and when he
I
tried
didn't.
to,
I saw
he
that more so with Bojin. I didn't really see that with Kanik.
well, because you got to know, again, you got to know what the defenses are. And again, he was going for an exculpatory defense. I said this 1,000 times, an exculpatory defense. And one being the mistake of age. Those are exculpatory defenses. It means on a good day, your client can be found not guilty, but usually they are mitigating their liability, meaning they're not totally innocent, but
I gotta reread the summation again,
they're guilty. Well,
especially with
no, well,
James.
yeah, so I mean, he could have asked when it like I say, if he would have talked about the part where her mom was texting as her. I mean, the prosecutor put that out there. They the one said was, I mean, your mom had access to the phone. Your mom was texting as you or something. Something in that
Hmm. It was
transcript.
something along that line.
Yeah, and so they open the door. They get to, hey, is that your
You,
mama? Take that exhibit
you
233 up there. Is that your mama texting this? Is that your mama texting that? Is that your
you
mama
know what?
texting?
You know what else that could have influenced his decision not to go there is them letters. You know, when he went there with them letters, it didn't really work out for him. So that could have been a contributing factor of his decision too.
If
Oh,
I may interject, if I
mm-hmm.
may interject, and I'm gonna go ahead and because I got an early morning tomorrow. First and foremost, I want to because I didn't get a chance to say happy belated birthday to my brother Sir Miguel that's on the panel.
Thank
Um,
you, brother.
yeah, happy birthday,
Oh,
Right
happy
bro.
there.
birthday! What's up?
Thank you,
Yeah,
ma'am.
his birthday was a couple days ago. Didn't get a chance, but with that being said, the text messages confirm a few things for me that I take away from this whole situation. For one, um, they confirmed that he did not know her age. For two, it confirmed that he was not trying to pursue a sexual relationship with her while she was underage. And for three, it confirmed that the they actually plotted against him and enticed him to pursue any type of engagement with the the Jane Doe. So with that being said, I would say that is not only grounds for a new trial, it's also, this lady was the majority of his charges in New York. without Jane Doe number 5, a RICO is weak in any sense of the stretch of imagination. So
Jeff,
with that being,
how that's gonna go ahead.
no, I was just gonna say, with that being said, she was the star witness in New York. So if her case is compromised in any stretch of the imagination, should, in my opinion, be granted a new trial, if not an acquittal. To substantiate a RICO charge.
RICO there, bro. RICO there. They overkilled that RICO because they only need 2 predicate acts. And they got like 13. They got like 13 of them or something.
Without Azriel,
even without Azriel, because even with Azriel, the herpes going to be there. For Azriel and Faith, those herpes is there. The herpes charges.
Okay.
They know that's
you
there.
have to have 2 predicate acts within 10 years.
That's two right there. That's 2 right there.
But if Jane Doe number 5 is compromised, what do you have?
But what I'm saying, you can't compromise the herpes. That's there.
But
let's say you compromise everything else. The herpes, how you get around the herpes?
You still have Faith. Faith is in there twice.
Faith is in there.
Now we have Faith Rogers' mother coming out here on social media. But you have Faith Rogers' mother coming out here making statements saying that her daughter does not have herpes.
It don't matter. It don't matter. It don't matter.
And it's
exposure.
Jeff, I don't know where you be. I swear we do this every time. We go through the same points.
So the man got 30 years because someone said that he exposed them to it, but they don't have it.
That's not why he got 30 years. That's why the herpes charge is proven. That's not why he got 30 years. He got 30 years because of the collective of counts proven. But what I'm saying, as far as the RICO, you can't get around the herpes. That's there. You can't get.
I thought her Faith mama said she had it in her mouth and not genital herpes.
She said she does not have.
But it don't matter though. It don't matter whether she doesn't have it or have it. It don't matter. The exposure is enough. I hope she don't have it. But
let me ask you a question. Let me ask you.
That she does have it.
Yeah, she said she had. Faith said she have it, and she said she maintain it with her diet and try not to stress out. Faith said she got it.
Be that as it
may. She said she was taking herbs to maintain it on Dr. Oz.
Right,
you can't take herbs to maintain it.
Okay, so she got it.
Lose me with that, man. Lose me with that.
She got it, right?
Then on top of that,
the mother
she also
there on a public platform and said that she does not have it. Period. But the fact that he exposed her to
Miguel,
it.
What she say again? What she say again, Miguel?
On Dr. Oz, he asked her a question. What are you doing?
Okay.
To help you with it, and she said, "I'm taking herbs, and I got friends that tell me to do this, that, and the other."
So does that mean that means she got herpes, right?
Who knows if she got it?
She just said that's what she's doing to maintain it.
Look, if you seen the way Dr. Oz looked at her when she said she was taking herbs, get the fuck out of here. You can't take no herbs to maintain no herpes.
Not at all. Come on, man. Let's be real. And then you have the mother on public platforms saying that she doesn't have it, period.
Well, it don't matter if she have it or not. The mere fact
yes, it does. It does matter. It does matter.
According to the law, according to you, it matters, but according to the law,
no, it does matter because even at that's the first time in New York history they ever put somebody in jail for herpes.
Bro, according to the law, it's exposure. Now, according to you, it's not exposure. So
at the end of the day, it matters. Because if she's saying she's doing herbs, come on, man, you can't maintain that with no damn herbs at the end of the day.
You supersede the law? You saying you supersede the law? Is that what I'm saying?
I'm not saying I'm superseding nothing.
Okay, that's all I need to hear.
The law says it's basically either she has it or she don't.
Either she has it or she don't. One of the two.
I'm saying it don't matter. It
It
don't
does
matter.
matter. It
Okay.
does matter.
The law said it doesn't. The law
Well,
says
it's
exposure.
different exposure.
It
It's
matters.
The
not
law
just that.
says exposure.
So
Like
you
I
saying
said, I'll say it again.
Oh, I'm getting off his
Whether
cow here now. I'm going. I'm
exposure
done.
or nothing, her mother says she don't have it. Number two, she had already told the police, I think in New York, that she had got it. She had already got it from somebody else or some shit like that. Even prior to that. So
Okay, he
Yeah,
should
what's
have
the
he
deal?
charged.
said that
He should have charged her.
that came out in court too, but people don't want to read that document.
what?
So
But
don't
but
play
when
me
I
stupid.
went to read it, she said no, she got it
Right,
from
we already
our
debunked that.
yeah. We went through that.
We already
But let me
debunked that.
say this, Jeff. Jeff, you're saying that due to the text messages and the other stuff, I see Sky, that he should have a new trial, right? Not a new trial. What you say he should what now? You said
If
not too
not
long.
I
acquittal,
would say that due to
he
the
said new
text
trial, not
messages,
acquittal.
I'm saying this. I'm saying due to the text messages and the evidence presented, if he had no knowledge of any criminal activity being done by himself due to the age, we have that substantiated through the text messages. He had no knowledge of that. He had no knowledge of he wasn't even pursuing her. We have knowledge of that through the text messages, and we also have knowledge that he was not in any type of way being compromised through any type of transparent transportating a minor because he had no knowledge of her being a minor. So with that being said, upon their own admission through the text messages, and that wasn't being admissible in court, was malicious conspiracy. If you ask me, no, is that was a malicious prosecution, because if I'm sitting here thinking that this lady is of age and the parent told the fact that this young lady was of age and I'm not even pursuing her the whole nine, how can you trick me into a crime that I have no knowledge of?
So
Which
what
and
if he
I
had
never
knowledge of it?
been treated to a crime, but that has nothing to do with the law. The law says total opposite of everything you just said. So
He just brought that up. You said he's gonna bring
appeal,
it back up.
I
He said
told you, an appeals process is not a place to relitigate the case. So that's what I
Jeff,
want to do. Yeah,
Jeff,
but I
what
knew
if
you
he
were gonna bring
had
it
knowledge?
up.
Hold on. Now I done sat here. I need to catch Jeff remixes. I hear laughing, giggling. The damn thing funny. What's up, y'all? What's up,
What's
Surrey
good
Gale?
with it? What's
What's up,
good with
Skylight?
it? What's good?
Hello.
Skylight.
Hold up.
Let me catch this remix now. Hold on now. Stop it. All
Oh,
that shit you said, Keller, with that happened, her
what?
testimony is over with. Okay?
What I say? What I
It's,
say?
Oh no.
you said what she testified to. There's no proof of it.
She
Where's the proof?
testified that she was 18. That's what I said.
She everything she testified to, especially with the Dolphin Hotel. It's not lining up with the messages.
Well, okay, what's not lining up?
None of it.
Okay, well, give me an example.
We already talked about an example.
What?
The police,
Hey, Skylight.
police coming to the demonstration. Oh, let me tell you, happy birthday too, Sir Miguel. I was listening. Happy birthday, my
Thank you, ma'am. What's up?
Okay, y'all go ahead. What y'all say?
Hey, Scott, before you get started, I want to just highlight one thing.
Okay,
that in the text messages, it said that this man he sat up there and spent $20,000 on you, and you ain't even give him no coochie yet. You a fool.
Yeah.
Hey, Miguel. I mean, not Miguel. Jeff. So you said he didn't have no knowledge. What if he? How would you feel if he had knowledge and did it?
But the text messages said that he
No.
not.
I'm just asking you. If he had knowledge of it and still did it, how would you feel then?
Now, if he had not, then you would have an argument.
Okay. So fast forward. So we're gonna use text messages again.
That's not
Let me get this out.
Go
We're
ahead.
gonna use text messages again. After he found out her real age, he sent another text message out to her friend and said, he nutted in me today and I might be pregnant. I'm late. So now he got knowledge now. And now it's text messages that was brought up in court. Hold on. I'm talking to Jeff. Hold on. Now it's text messages out that was introduced in court in the exhibit that Asriel stated that she got nutted in.
That's bullshit.
Now I don't have no knowledge of that. I ain't got that far in the text message, so I can't speak on that.
Okay, it's not in the thing that everybody else reading. It's in the transcript. It's in the transcript.
You've already stated that she's lied in her testimony, so why do you keep?
No, this is a text message. Her friend they brought her friend on the stand, and she read a text message. This is a text message that she's reading that Asriel sent to her way before court even was in the. Hold on. I'm gonna Jeff to answer this real quick.
Yeah. Okay.
Way before Asriel thought that it would ever be a trial. Years before, we didn't think a trial would ever happen. She sent her friend a text message, and they retrieved that text message, brought her friend on the stand, and said, "Read this." And it said, "He nutted in me today," and this was in October after he found out her real age. So now he know now.
Okay, so once again, bro, I have no knowledge of that. This is the first time I'm hearing of that. These text messages have been read on several platforms. What I will say is this. The man has came out and said, well, not the man, the text messages have substantiated that he had no knowledge of the age due to the hotels incident. Due to the mama sitting up there saying that he had he paid $20,000 and they pursue no sexual encounter with her. They were going to nightclubs and the mama was sitting up there telling her, leave your hotel at home so he won't know your age. And then another text message is saying that you need to let him know your real age at some point because he's in the public doing this and that. So that is totally contrary to what we have read so far in the text messages. So I haven't heard anything about him nutting in her when she was underage, so I can't speak to that. What I have heard and what I have researched supports the fact that he had no knowledge of her being under the age of consent.
Well, I mean, y'all still there?
I'm here.
Oh, okay.
Yes.
Okay, but what I'm saying is, and I'm trying to get Jeff off that. I mean, I got the points. I get the point, but I read to you from what his old attorney's website says about the age.
Can you read it again?
It doesn't really matter whether or not he knew or he don't know. They're saying he should have known.
Angie, can you read that again, please?
About the age.
Can you read it?
Can y'all hear me?
Yeah, I hear you.
Yeah, it's this.
She said, "Read it again."
Please.
Read it again. Okay.
Yes, please.
And then when you done with that, can you pull up 884 for Jeff so we can get him some knowledge? He said he don't have no knowledge, so we're gonna get him some knowledge today. So after that, can you go to 884 in the transcript?
No, what Jeff was saying that there is no intent. Okay, don't you?
No, we're talking about Jeff said he didn't have no knowledge, so I don't want to leave him without no knowledge of shit. So we're gonna get him some knowledge.
Knowledge what you talking about? it after the fact.
All right, hold on. She gonna read what she got to. She finna read that again for you, and then we're gonna get just some knowledge, and then you can go ahead and cuss me out after that.
We're not even at the pigeonhole. We prior to. We trying to figure out how you gonna sit up there and let the parents introduce this child into this case and act like it ain't worth a damn thing.
That's fine.
And
we're gonna get him some knowledge too.
Don't you have to have intent? Doesn't chaos have to have intent to do this crime? Or are you saying you about to read something different?
We finna get him some knowledge. That's what I'm saying. When you done with that, go 884 the transcript.
Back about not about the what she have on her website about dealing with a minor, whether you know their age or not, you still are criminally liable.
Okay, I'm listening.
Scott and read this with you up in okay, here you go. Says according to MCL 7, this is the Michigan State Code, a person will be charged with solicitation of a minor if they accost, entice, or solicit a minor below 16 years of age. This doesn't matter whether the person is aware that the individual is a minor, aware of the child's actual age, or an individual they believe is less than 16 years. So it doesn't matter if they think that they're 18 or not. If you break the law with regards to them, you're still going to be held liable. It says, however, the prosecution needs proof of force or intent to induce the minor to engage in an immoral act or to submit to sexual intercourse.
Now let's stop right there. You just said it.
I knew you was going to stop there.
Intent. Can you read that one part again? They need to have force. Say that one more time, Angie. That part right there.
However, the prosecution needs proof of force or intent to induce the minor to engage in an immoral act or to submit to sexual intercourse. So I already know you're going with this. So
you better know it. That's where I'm going. Because that's where
I know you're going with the intent
and the force. She was there willingly.
It says or.
Yeah, okay. Yeah, force or intent. Okay. So that both of them are black. So how are we using
here it is, Sky. You got to know when it comes to intent or force or whatever. One is how it's weighed. Two, so y'all getting me real technical. And two, what not intent, like, okay, I got a plan already that I'm going to do this, that, and the third, which that is more than enough that satisfies intent. But intent can also mean I call you and say, hey, I want you to travel to come. And when you get here, we're going to have sex. My mind is inducing you into sex when you get here. That's also a level of intent. Right, which is man.
Who's snoring? Hold
on. Because
I knew she was going there. I knew it.
Okay, wait, hold on. Because that was already obliviated by, because there was no she wasn't forced to fly. She wanted to fly. She flew willingly. Am I missing this?
What does that do with the intent?
No, I'm talking to Angie.
She went willingly. Right.
Willingly.
Flew willingly. She did it all willingly. But guess what? According to her birth certificate, she was under the age of 18.
But you just stated that you have to have force or intent, and none of those apply.
Yes, because he got on the phone. Remember the facilitator, the phone. See, you got all the elements. When
Interstate commerce.
Pieces out of it. We got other stuff in it. So, we got a first time hitter. I think ain't Big Vaz a first time hitter over here?
Who?
Big Vaz, ain't he a first time hitter?
Now, I probably, I don't know if I. What's up, Miss Angie? What up,
What's
Jeff?
good with
What up, Sky? What up, Sir Miguel?
Big
What up, big
Bob, what
dog?
up, bro?
Only
Wait,
people I see on the panel. So
hey, hold on 1 second. Okay, so we got to the point there was no force or intent. Okay. Now, when he was on the phone, he was not under, because you said he has to force or intentionally seduce a minor. When he was on the phone, he was under the guise that the girl was 18.
Exactly.
Lord have mercy. I ain't gonna never get
You're
about
gonna
this
have to
question.
break it down. I'm
I
not
ain't
Uh,
gonna.
gonna get I ain't gonna I don't know how many times I can break it up or
you
down.
can't just you can't just go keep go.
I
Can you go
don't
to
understand
884 real
why.
quick? Cause I'm
Now
finna get up
stop.
out of
Now
here.
stop. I need to get this understood. Hold on.
How many lives I got to do about this? Okay. Because I just said it on Levi's channel. Just because you jump one hurdle, that don't mean it's some more test when it comes to the law that you got to jump across to get to the final. So listen, they said his method of whatever, I forgot what it was with Jane was a phone. Okay. That's what allegedly what he used to induce, entice, or whatever, coerce her to travel across state lines. Once you got across state lines, when per the conversation they had, he was asking her, "Can you fly? Can you come with me? Can you do this? Can you do this?" She said, "Yeah, yeah, 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 yeah." As a matter of fact, my mama said it's okay. I'm more than willing to go. That's fine. They're saying his intent was to have sex with her because they did have sex.
but when?
No,
When
that
she
was
got
something
across the
that
line and she was under 18.
But according to the text messages, when she was flying to these hotels, this man was never showing up.
Exactly. That's what I was trying to convey. That the man had no interest in her until much later on, like way like months, almost a year until her being there, which would have placed her after the age of 18. The
but
Okay,
text
but
messages substantiate that.
as a
okay,
minor,
but
he
let me
was
say
talking to
this.
her as an 18-year-old.
Uh,
Right, but I just read to you. Oh Lord, my business going in circles.
But I'm
That
asking, did you read the text? Did you read the messages already?
no, I just heard bits and pieces. But
And
let me tell you
that's the
about
problem though. That's the
no,
problem.
that ain't the problem because I'm just giving you the law.
But
The
I'm
text
saying when you saying
messages.
you giving us the law, and I'm listening, I've been listening on here for like an hour, and I'm hearing
Okay,
what you're saying. But when you
okay,
go to the messages between the
okay.
mama and the daughter, and the mama is also telling the daughter to copy and paste these texts that I'm sending you, not forward them, copy and paste them, and
Right.
send them to him.
She
And
complicit.
you read the messages between the mom and the daughter. It's the mama who's initiating the daughter to get with the program. She say this clearly. You
Right.
need to get with the
Right.
program, as in the plan, have sex with the man. But the daughter's telling the mama that he's not interested in sex.
Okay, let me see if I can explain it this way. Okay, like I've done on all the time, I will give you all of that. And I've said, even if the girl, was butt naked, willing, show up
spread
off the
eagle.
plane with a bow tied to wherever. Okay, just say she was willing, whatever. And we see that in text messages. We see her mama. We could say, either her mama was complicit, her mama was responsible, her mama pushed it, or whatever you want to say. The elements of the crime, the penal code, the elements and everything in that charging instrument and that indictment pertains to what he did and what he allowed. That's what it's a plan. If y'all can understand what I'm saying, it only pertains to his actions.
And that's totally understandable. But to sit here and to be like, well, it's only, you can't sit here and say it's, oh, so really what you saying, oh, it's my actions. If someone entice me, never, not one time say, hey, I'm 16, I'm 17. Never, not one time. But the whole time you confirming to me that you 18. You started telling me you're 18. But the only time she had a problem with being 18 is when it came time to go to a show. And
Mm-hmm.
other
I'm telling
things.
you
But
what
I'm
the
listening to
law
what you're
part of
saying. I'm not gonna debate what you said. I understand.
I'm saying
I get where you're coming from.
I
But
don't agree with nobody being tricked into no crime. That's my personal. I don't agree with nobody being tricked into no crime. If
But
somebody
that's exactly what happened.
okay, but that's my personal. That ain't got to do with the law. I'm just giving you the law. My
Right.
personal belief. I wouldn't want nobody to trick me into no crime because know what that says? That says that you did not give me the opportunity to turn it down.
So
Okay?
don't police do like sting operations all the time to set motherfuckers up
they
for
just
Yeah.
did
drugs and prostitution?
they just did one of my
So
to a
that's
guy in
tricking them
my
into a
hometown.
crime. That's tricking them into a crime, ain't it?
They just
Yes.
did one. They just did that to a guy in my hometown.
So ain't that tricking them
Right.
into a
But
crime?
no. But hold on though. Let me show you what the difference was with this guy. You know what the difference is when the police do it? And I'm gonna find it for you, Miss Angie.
It's entrapment.
The girl never told the guy that she was 18. She was saying that she was 14. But the guy said, just don't tell your mama. She never pretended to be 18. That was the difference between this. I'm gonna send it to Miss Angie so she can
Right.
read the article.
But
The police set up the sting operation, but they never pretended to be an adult. The whole time they maintained that the girl was 14, 15 years old, and the guy still went along with it.
so he knew.
Right.
So you saying he knew?
He knew, so she never
So
said she was
so with
18.
that being said, Angie, can you go to 884 the transcript, please? I
No,
gotta
but
get
what
out of here.
Big Black.
You
So,
about right to
but
get
what
up
I'm
by.
saying, but did you hear that part where I read off of from Nicole Blank Becker's website
Oh my God,
about
that's
like
prostitute.
having whether or not you know the age, the person know the age or not? What you say? Is 8? What is it?
884. And
Whether or
then
not you know the age or not?
if you want to go to a friend, it's 1388. 884 and 1388
Okay.
to corroborate it.
And so, and then another thing, the text messages, you know, they late to the party, right? But if the
This
process,
this
if
shit.
his
This whole court thing.
if his counsel didn't use them, and you know, then well, let me put it like this: didn't use them when they where they could be used. I put it like that.
A
Then
strategy.
you know that's a
But
miss,
but Levi
missed
made
opportunity.
the day when you was on Skylight, when Levi said when she was asked, did she know about her mother sending those texts acting as her, and she said no, and the government knew the whole time that she did.
She didn't say no. She said she did it. She did know.
Man, Miss Angie just talked about this on Skylight. Calm your ass down, man. What the fuck wrong with you?
Man, my hope, man,
Hey man, all that
you
shit.
telling me to calm down. Look how you
But
coming at me.
Miss Angie, did you and Levi not go over this on
I
Skylight
don't.
Live?
I'm telling
Yeah,
you
we
what she said in the transcripts. She
prosecutorial
said she
misconduct.
knew. She
Okay,
said she knew her mother was talking as her in the
Russ
transcripts.
did not, man. Miss Angie and Levi talked about this a couple days ago.
Yeah,
Okay, so
it
you not
says we talked about it
okay.
being
Go
prosecutorial
go
misconduct.
884 so I can get out here before I start
Oh, I
cussing
got
motherfuckers out.
884 up
I'm
Man,
about to
now.
burn this
Okay.
shit down in a minute.
It's the internet, bro. Fuck. This is the internet. You
It
tough, ain't
says it says question, and you can read what's written here, where my pen is pointed. I said, he nutted in me before his show today. And again, you're referring to the defendant? Yes, I
Can you go to
was.
3? Can you start at 3? Can you start at 3? Because that's very important. Line 3.
Okay, it
Line
says,
3.
and what is the date on which these were sent? October 3rd, 2015.
Okay,
So
real
yeah, the
quick.
prosecution is trying to establish something. Go ahead.
So real quick, that permission slip was dated September to her birthday. So he knew her age at this time. Go ahead.
It says,
The
and can
permission
you
slip
read
was
what
false.
is written here where my pen is pointed? Yeah, I already read this part. So, and it says, before its performance, and again for the jury, may I publish 205D? Yes. Where's my pen pointed? These are the first text messages, and on what date? October the 5th, 2015. And when they keep referencing dates and shit like that, they're just trying to
They
establish
got to, because
timeline.
they got to.
Establish the timeline and establish that, all the people were where they're supposed to be with regards to this. And also to establish that the defendant was there as well, wherever they're saying. It says, and where my pen is, what does it say? It says, I'm going to kill myself. And what did you send after that? The procedure of how an abortion is done. Oh.
So she thought she was pregnant. R. Kelly knew her age. R. Kelly, at this point, he knew her age.
He thought.
And this is a text message that y'all so rare about these text messages. Hey, here's a text message right here saying he nutted in me. She sent this text message years before she thought it would ever be an indictment.
Where is the proof of her confirming that
you up there? Okay.
Say that again?
I said, where's the proof that she confirmed that her age wasn't 18 but 17 to him?
The proof is she told.
No, where's the proof?
I'm trying to tell you. The proof is she told her real age before she had to go to school back in fucking October, September.
No, she wasn't in no school in October, September.
No, she had to go back to school. So due to she had to go back to
May.
Listen to me, man. I'm trying to tell you something. Dude, when she had to go back to school, she informed them her real age because she had to go back and finish her senior year. That's where the proof was at, and that's in the transcripts.
But I thought she was homeschooled.
Here's some more proof for you. The permission slip that he had her sign is dated September. September.
The
permission. Okay, but he told her to do it, though. He told her to do it.
What was she at?
Man, you're missing the whole point. The point I'm making is he was aware of her age. You deflecting. He was aware of her age.
I disagree.
Big vibe.
The facts is there.
Correct me if I'm wrong. Didn't she give 2 dates of her birthday?
Man, it's 3 days.
You can't even tell me what that was at, bro.
I just told you go.
You told me to look it up. That's hearsay, bro.
It's 3 days.
I said go look up on one of her social media pages.
I just showed you this. Now you showed me what it was 2 dates.
It's 3 dates of her birthday.
Okay, show me. I just showed you. Show me.
I mean, at the end of the day, the thing that we have to keep in context is that the mother told the daughter to lie about her age, for one. For two, at the end of the day, the mistake in the age is substantiated through the fact that she lied about hiding her identification from when they went to the club on several occasions.
And at the end of the week, he found out her real age and nutted in her.
I digress. What a proof.
I just showed it to you. What the fuck? You blind?
Bullshit.
You blind? What motherfucker said? What a proof? Look at the screen, nigga. Look at the screen. Open your eyes. Are you fucking blind?
Bullshit.
What the fuck? This motherfucker said, what a proof fact. All you gotta do is open his goddamn eyes. I'm done. Y'all fucking crazy.
No eyes.
Y'all fucking crazy.
Bro, you deflecting. You deflecting, bro.
Oh, man. I ain't deflecting.
This dude right
Yeah.
here, man, he
What's
died,
up?
got brand nose somewhere.
What's up, bud?
I'm trying to find out. Okay, we done went through this again, and you still talking about hiding the ID and all of that. When you ain't read what I said, rap from R. Kelly, old attorney.
I didn't say
Not
nothing about no
the
ID.
Not you. I said Taylor.
Oh, I thought you called me out.
No, I said
Yo,
Taylor.
Oh, I thought you said Keller.
No, I
Oh,
said
man.
Taylor.
you know, I was taught where I was from, man. A person lied to you at one time, can't believe nothing else they say.
Yeah, it's
And
just like this.
you are supposed to attack a witness on their credibility on the stand by by the lawful means. You are supposed to do that.
Can we go back to the point I was trying to make? I would like to walk down that law that you were talking about, please.
Again.
All right, y'all. Y'all have a good one.
All right. So what Nikki put on her website?
Yes.
Let me see.
Because I'm not understanding how. Okay, because we already, the one you said didn't apply, and like you saying, the steps. Then there's the next step.
Right.
But there was no intent, and there was no force for that one particular law that you said.
Exactly.
Okay, I'm reading Michigan. Okay, and it doesn't matter, but
And
the
is
intent.
that a general law?
Okay, you're narrowly defining intent. It's not narrowly defined. Intent has multiple levels. It is general intent, it's specific intent, it's unintentional intent.
Okay, I'll go with
Okay, so it's
I will
not
go with unintentional intent. Okay,
right.
okay. But how do we know which
Okay,
one there? Do they all apply, or do they have to define which one, what type of intent we talking about?
it could be either one. It could be either one. It don't have to be, when it's specific intent. Excuse me. That means like premeditation murder. Okay.
Mm-hmm.
When it's general intent means second degree murder. Like I had a reasonable as the defendant. I had a reasonable idea that me stabbing this motherfucker may kill him or may not. That's general intent. Unintentional is like manslaughter or vehicular homicide. I didn't mean to kill him or something along that line. Okay. So it
Okay,
can be unintentional intent.
right. But does the prosecution have to specify which one? You're saying no. It could just be all three
No,
of. Okay, okay.
it
Now
could
I'm
be either. Yeah. Yeah. So they just have to prove the elements. Okay. They just have to prove the elements. And
okay.
in the language and the penal code states what it states, and then the elements of however it is, just for instance, like did they travel, and it's not hard to prove. Did a person travel across state lines under the age of 18? Yes. Okay, element proved. It's just that simple. So I know,
I agree.
I know it's a lot of confusion when it comes to the because the parents are responsible.
Right, man.
Y'all can hear
And
me?
that's the
Yeah,
question.
no, I'm
Yeah.
present because
Okay,
And
I thought
the,
y'all was gone. I couldn't see y'all. Go ahead.
the initial. All right, if I'm out somewhere and I meet, just say we out, you in the mall, I'm in the mall, and I meet
Mhm.
you. That's our initial meet, and we talk and we exchange numbers, and you say, well, I ask you how old are you, and you say I'm 18. So from that point on, like you then open up the door for us to have a different type of conversation, or even have a conversation. Because if you tell me I'm 17, I'm 16, 17, then maybe I'm not even want to talk to you. But when you
Right.
say 18, now you didn't open up the door for a conversation.
And that's what I was explaining. That's why I don't like, well, I call it being, tricked to break the law, but I don't like that particular part of the law. Even just say, even if I'm a bank robber, right? Just say I'm a bank robber, that's my profession. And I get in the car with you, and you're a bank robber too. But on that day, you are going to rob a bank. I don't feel like it.
Right.
But you done drove me there, and told me to come in, and you told me, just hold this for me, just hold this bag or whatever, and I'm in the bank, and then next thing I know, you throwing money in at me, telling me, oh, put this money in this bag. You have robbed me of my choice, because although I'm a bank robber, maybe on this day I don't feel like robbing a damn bank. Maybe I got my child with me.
Right.
You understand what I'm saying? So that's why I don't like that part of the law.
But it's
I don't
the
like
law.
that part of the law,
God,
because you're taking away my choice when you trick me. When you trick me, you're taking away my choice. Maybe, on the day that, they allege he had sex with her when she was under 18, maybe if R. Kelly would have known her real age, he might have said, no, I'll holler at you when you get 18. You rob him of his choice. And I always maintain, I never like nobody being tricked into a crime, because it's not fair.
Can you read the second one? Because, okay, so the first one is force and intent. Well, can you start over, please? Because I got to horn in on this. Because
Start over where?
with the,
With
the,
this?
to start with the lady that she got on the website, please.
Okay. It says, according to, this is a Michigan law, and this is all over, but this is
Mhm.
just every state going to have their own, penal code. Says a person, and it's going to be worded different, but it has the same meaning. It says, according to that law, a person will be charged with solicitation of a minor if they accost, entice, or solicit a minor below 16 years of age. This doesn't matter whether the person is aware that the individual is a minor, aware of the child's actual age, or an individual that they believe is less than 16 years. However, the prosecution needs proof of force or intent to induce the minor to engage in an immoral act or to submit to sexual intercourse. And I'll read this. Additionally, a person will be guilty of solicitation of a minor if they encourage a minor to meet with them or other persons for the purpose of engaging in sex. Summarily, this doesn't matter whether the offender is aware of the child's age, knows the child's actual age, or believes the individual is below 16 years old. So it doesn't matter. So they're saying is, they don't care if you know, if you don't know, or you was tricked into knowing something else. They still hold the adult in the situation responsible. And the only thing that you can hope for, if your attorney can get the mistake of fact or mistake of age defense in, then that they could use that successfully, to defend them, to at least mitigate some of their criminal liability.
Right, to go to mitigation. But I still say the same thing. Because to me, it's still different in regards to how she got there. I feel like that is a huge mitigating factor. And with the rest of that, I understand what you're saying about the law, but I just truly believe that I don't think they have it with that the force and the 10. Of course, you could say, like you're saying, with the age, that one's hard to get around. But in regards to, he had no intention, because when he was talking to her, he was under the gas that she was 18. Now,
But check this out right here. Okay, here's the very easy for the prosecution. All right, if you didn't have intent to have sex with her, then why you had sex with her?
Because she enticed me.
Yeah.
But you
Miss.
can't entice under 18.
But there's a what they say false pretense though. You pretended. But then
Right,
what
but I
about
just read to you it doesn't matter
I,
per the law.
I,
But where do
I
we? But
don't
where
have
do
a problem
we
with
even
it doesn't
know?
matter, Paul.
Let's go
let me
back. Where do we even know that he had sex with her outside of that testimony? Where do we know that?
Okay, but if his attorney wasn't able to, you know, damage her credibility on the stand, then I mean, I don't,
Okay, I'm saying we at the
it's
appeal
just
process because I didn't mean for us to be in the case. I want to be at the appeal process. So at this point, what we're arguing is a mitigating factor only. And then when Levi came up with prosecutorial misconduct is another issue that could be.
prosecutorial misconduct. Maybe
Mm-hmm.
if they can prove that the prosecutors knew that they were putting forth testimony that was evidence that was false, and some more, you of course I tell you some more accurate, and it outweighs the excuse me, and the verdict would have been different. It'll made a difference in the case, and it it um it changed the facts, stuff like that. It just goes through the test when it gets to the appeals, all the different tests. Remember, I don't know if you was listening or not, but like I said, when it goes to with the appeals, you still got to jump over those hurdles with those different tests.
Yeah.
right.
Was it on harm? Is it considered a harm? I'm just giving an example. Is it considered a harmless error? Is it procedure error? Is it a structural error? Is it a reversible error? What type of error is it? So it still has to go through that. Would it have made a difference in the outcome of the case? You're gonna be put through that test and all of that. So it's not just cut and dry and that's it. No, we got to go through some more stuff.
Yeah, but I feel that has legs, and then we also have the ineffective counsel piece. So I believe with those together, because we're now you probably see it at the same scope that Bonjean does, but I think we're seeing it from a minuscule scope, and she's seeing it much broader. Because in regards to what you're saying, changing the facts of the case, changing the case, I believe
Changing
we're
the outcome. Change. I
changing.
mean, you think that these text messages would have changed the outcome of this case?
Yes,
I,
ma'am.
her
Yes.
testimony is
Can I
now in
tell,
question. So
can I
yes, so if
tell,
her testimony is in question in any kind of way, okay, for what she testified to, because I don't believe I didn't see it. The proof that whole episode with the Dolphin Hotel happened, meaning to me that she did not engage in sexual activity with him at that time. So, as far as I'm concerned, yes, that changes the whole entire testimony. Her saying, her, I'm sorry,
I'll
go
Go ahead.
get out of here.
What you
Um,
say?
I want to make one other point before I get out of here.
Okay.
According to the messages, and why I say the messages would have changed the outcome, because she also knowingly knew what she was doing. Every situation that came about where it could have made him aware of her age, she knowingly avoided it, purposely avoided it. When
good
she
point. Okay.
when she
But
asked if he wanted to go to the shows, every
uh
time she came to a show, she was so concerned about going to the show because she was looking up the venue before going and said they checking for I. What am I gonna do? The mama telling her,
oh
well,
wow.
leave it somewhere in the room, and when you get there, tell them you don't have it, left it. And when you get back to the room, put it somewhere to where you have to make it seem like you're looking for it. When you get back there, and if you can't find it, just start crying, and maybe he'll feel sorry. So she denied them opportunities to really find out what her age was before any sexual activity took place. This is in the messages.
Oh wow.
See, Angie, it's a double-edged sword, because while you're stating the law, it is so much conspiring amongst those two. It's got to mitigate it. I just can't see how it doesn't. It's got to mitigate.
Well, unfortunately,
Yeah, I
now here's the
understand.
thing. Well, here's
What
another
I
thing. Here's
what
another
I
thing.
feel ain't what you go, but I'm just saying that's just my
But
opinion.
but here's another thing. You also got charges with her supposed to be under the age of 18, but then you got charges supposed to be over the age of 18, right? And here's the thing, right? You still got that issue with that um that man act with that exposure to the herpes situation. I think they got that charge as her over 18. And and they do that crafty charging, so because they know that sometimes on appeal some of those charges can be reversed. So they'll still have something they've separated them pretty good, so they'll still have something in place. But what I'm saying is, you still have, you do pretty much, you got to say this, right? Do those text messages defend against any of those elements of those charges? Okay, so we know one, the facilitator of the crime was her cell phone. We do know a cell phone was used when she talked to him or whatever. We do know she went over across state lines, and allegedly she was exposed to herpes.
But wait,
Those are all of the elements.
when she talked to him, when are you saying, at the beginning or later on?
No. When I say facilitator, in one of those in some of those charges, it could be Illinois. I might be confused. It could be Illinois. One of the interstate commerce. It's both New York and Illinois. With regards to interstate commerce, a phone is a facilitator. Remember, they like when they were on the phone with him. When they were going through that testimony, like they were on the phone with him. A phone is a facilitator of interstate commerce. The tape used in the video.
No. Let's stick to New
Film.
York. Let's stick to New York.
No,
So,
I'm thinking New York, but so a phone, because they were talking about phone and text messages and things of that nature. That's a facilitator to interstate commerce.
but he was
So
talking
I'm
to the
just
mom
one,
though. He wasn't talking to
huh?
her. He was talking to the
Huh?
mom. He was talking to the mom about sex. He wasn't
He wasn't
talking to her.
talking to the mama the whole time. I'm
He
talking about after the mama. I'm talking about like when she went over cross state lines or whatever. What did they say the facilitator was for interstate commerce then? Wasn't it the phone, or
I
was
thought
it
at that point,
huh?
weren't they together at that point when he was asking her, "Can you travel?" And the mama was on the phone saying, "Yes." I might be wrong, but I thought they was
Uh,
together having a conversation. And the
it's not hard to prove elements, if especially when you got some sort of evidence. It's not that hard to prove. That's
yeah,
why they charge it.
but I truly believe, and this is my opinion, that once they have identified that this is a different situation in which the daughter and her mother placed her in this situation. It's not like he gave the phone number out and he called them, "Hey, come, let's have sex, let's do this, you come talk to me." They put themselves in that situation. Okay.
So when they
So
gonna hear that? When they gonna hear about all of that, the text message and all that? When will they hear that?
When will they hear about the text messages?
Yeah, about the mama and daughter the mama putting the daughter in that
Oh, when they
situation.
discuss the prosecutorial misconduct, when they talk about her testimony, they to my understanding, if they get that in, they could bring in the text messages to discuss her testimony and do the contradictions between her testimony versus what they have on the text messages.
They're going to rule on the prosecutorial misconduct as far as what happened on the prosecution end. They're not going to relitigate the case. So they're going to sue that they're going to say, okay, y'all knew
She was
that
like,
this evidence
uh-huh.
that y'all was putting forth was not right. Y'all put false evidence. Y'all went forth with it. Y'all knew it was false when she was giving it, and so therefore it's prosecutorial misconduct. It's not going to be talking about the conspiracy about the mama putting that's relitigating the
Okay,
the
well,
case
hold on.
all over again. So
Hold on.
that's not for
So you
appeal.
think they don't have to provide any proof of why they're saying prosecutorial misconduct?
Yes, they have to provide proof, but they're not going to get into the weeds about the mom, or they're not going to litigate that the mom had a conspiracy and all of that in it. They're not going to litigate that. They're going to litigate what was the prosecutorial misconduct? What did the prosecutors do?
Okay, so when they say you allow her,
Actions of the prosecutor. It's the actions of the prosecutor.
okay, so let's say you allow her to sit on the stand and provide false testimony. The
Right.
prosecution say you lying. What happens at that point? They don't have to prove it.
The prosecute when the appeals go right now, the defense, anything after post conviction, right? The defense now have the burden of proof. Okay, now they have to prove what they're saying. So they have to prove that the prosecutor knowingly put forth false evidence.
Okay, so now how can they prove it? That's what I'm saying. How can they prove it?
Oh, okay, but that's why I'm walking you through it. Because I find out if I walk y'all through the steps, or you especially, I've never had to do it with Big Bye, that you're going to understand it the way you understand it.
Yeah.
But that's why I'm asking you the question. I already know the answer, but I'm asking you the question so you can walk yourself through it.
Right, but I'm saying like, okay, so they're going to say, prove it. I'm the defense. They're going to ask me to prove it.
Right.
And now
Don't ask me to prove it. That's your theory.
I'm saying I'm the defense. I'm the defense. You the prosecutor. Well, I guess the judge is going to say prove it, or whoever say prove it. So then you're saying at that point, I can't bring out my text messages?
No,
I'm
not saying. You're going to bring out, the text messages won't be litigated. Meaning, see him, the mama had a conspiracy and blah, blah, blah. No. You're saying this is prosecutorial misconduct. You need to prove the misconduct by the prosecutors. You got to prove that they knew, and you got to prove,
Okay, here we go. The prosecution provided some documents. Can I say text messages? The prosecution provided some text messages in discovery, and they were aware at the time that Jane Doe was testifying that her testimony.
Yeah.
Okay, her testimony was not accurate.
Right, it was a lie. No, you have to be aware. They have to blatantly know that it was a lie. Now,
she
I
stated.
Don't know. Go ahead.
No, you go ahead.
No, I don't know how. How they could, unless they say, and this would be a fair fight, unless they say, well, the defense, it was the evidence was there, and because it'll get tricky, because it's going to be a toss-up whether or not was the prosecutorial misconduct intentional, or was it, we didn't really focus on those text messages, so we didn't have recorded everything gets said. We just went ahead and corroborated everything Jane Doe number 5 said on the stand. So let me say, and I don't know why we get in the weeds with this, because this is gonna take
No,
a
I don't want.
real dangerous. No. This is going to take a real dangerous turn when I say this, because now it's going to really get confusing.
Okay.
Just say Jane Doe number 5 lied on the stand. Just say she lied on the stand. But what also happened is, of those lies, she had evidence to substantiate what she was saying. Okay? Just say she had evidence. The prosecution can then say, hey, we just provided evidence of what our witness testified to. If the text messages prove that she lied, and here's the handicap there, they can't litigate those text messages on appeal. You can't get into those. You're just talking about the misconduct of the prosecutors. You're not going to be able to sit up there and litigate those text messages and saying, okay, it says right here they knew this was, because it could be like what the prosecutor said, well, we interpreted them a different way, or whatever. It's all kind of tricky ways to kind of get around that. So it's kind of hard to nail a prosecutor on putting forth falsified evidence.
Well, it's your evidence that you provided into discovery. Therefore, you should be familiar with the evidence you provided. When I read the evidence, I see that the young lady had motive. She had intent. And even in her testimony, she half answered the question, and it was able to remain. I don't know what word y'all use. It was able to remain unimpeached. I don't know.
Well, okay, that's a good try. But what I'm saying is, okay, you can say, but the Supreme Court has all kinds of ruling on an attorney's the job an attorney must do, right? They say that an attorney does not have to be outstanding and just outperformed or know everything or whatever. All they have to have done is do a reasonable job. Well, who determines if the job they did was reasonable? The
Okay.
trial fact, the people that they are put in front of. So they can easily say, and they could be lying, they can easily say, hey, we saw the text messages and we saw that it differed from what our witness, our victim witness, stated, right? But we interpreted them different. We had evidence, corroborating evidence, which supported what she said on the stand, not what was in print on these text messages.
Okay.
And that's why we didn't explore it further, so on and so forth.
Okay.
They get paid to lie, girl.
Okay. So
Go
I'm gonna
ahead.
come in and I'm gonna say, well, Your Honor, when the defense attorney tried to come in to be able to question this said testimony, he was not allowed by the judge. Okay, so we couldn't even go further to explore ourselves or cross-examine her in regards to her testimony because it was not even allowed in the proceedings.
Hold on. Was that text message allowed or not?
Nope,
Hold
because
on,
she
hold on.
can't prove extortion. If you can prove extortion, you could bring it in.
It was
I mean, to get the
in
parents to
the
come up, it was for the parents. If you can
it was
prove it,
uh-huh.
then you could. Let me see what they say. Was that for the to bring the
If you
parents?
can if you have direct I'll paraphrase. If you have direct evidence proving extortion,
Okay.
then you can question the parents. Okay.
Okay.
So I pretty much believe that at that time they probably would have been able to would have seek to get those text messages
Right.
admissible. But what I'm saying is this. So damn, I just lost my thought. So if go ahead, keep going. What you were saying?
So the door was open, Your Honor. The door was open when they asked the young lady, did she know that her mother was texting the Mr. Kelly when she first met him? Okay, the door was open. And we
Mm-hmm.
were at that point, we wanted to cross-examine her based on this discovery. However, the judge stated something in regards to extortion, which was not our line of defense. We were trying to cross-examine her based on her own testimony. We're not allowed.
Okay, and that may sometimes that is called a procedural bar, right? So sometimes you know you may be able to get around those procedural bars on appeal, like if something just totally renders you unable to have a fair trial,
And
that
that's
can fall. Being unable to present evidence could be one.
yep. And
Um,
we weren't able to bring up some witnesses that we wanted to bring up to.
but it will go to was there see then you got to go back some. Your witnesses would be pretty much tied to your defense. Was your defense allowed, or did the judge shut your defense down?
The fence down.
Okay, she shut your defense down by not
Not
allowing you
to
to talk
fully.
about extortion.
No, to fully cross-examine her. The door was open when
Huh, but the attorney talked about extortion. They didn't talk about this when it may or may not be preserved on the record. See, that's when you get in it's a lot of shit. When you don't have the records, then you just don't know.
but
But
they judge Angie brought that in. The judge was like, if you see extortion, then you can use an extortion defense, but I don't see it. I think she pulled that out her ass and brought that in. If I'm
no,
wrong, no.
no, that would be the defense. The defense was talking about extortion. And she told them if you don't have any direct evidence, then they're not going to allow it. But if you have any direct evidence, then she will allow it.
So
She said that in that pre-trial motion I read, huh?
why would they use a defense they have no evidence for? Because he didn't pursue the extortion defense, to my understanding. So why would I think it
No,
was
that's what they were trying to use that. And then she was saying if you don't have any direct evidence with regards to the extortion, you can't use that defense.
that's what I'm saying. But to me, where correct evidence that the defense was using to prove extortion? I mean, it wasn't in the text messages from what I saw. So what? Maybe they
No,
had.
they were talking about that during pre-trial. This was pre-trial stuff.
Okay.
And in their pre-trial transcript, that's exactly what they said. They said talking about extortion. If you don't have direct evidence of talking about extortion, they're not going to allow testimony with,
Oh, wait. The chat.
whatever.
Okay. Hey, chat. I forgot to say hi to y'all. Okay. Stephanie said Alice told Azriel to tell Robert to deposit $5,000 in an account. Okay. So maybe that using. They shouldn't have went down. I wouldn't have picked.
You cutting in and out.
I am.
I hear you now. I hear you. I hear you.
Okay.
So
No, I was just reading what did you hear what I said? What Stephanie said?
right. She said about 5.
Yeah, the $5,000. Okay, so let me go back.
Is that in the text messages or is that in the transcript? I mean, that's probably in the transcript. That's in the text messages somewhere.
I just feel. Okay, let me think. Let me get my brain right back. Okay, so you saying that I just don't see how see that's what I'm saying. The judge butted in because the door was open. So how are you gonna tell me what questions I could ask based on what? I feel like the judge ran interference right there, Angie. You didn't let me explore. I couldn't question because to me it's a relevant question for me to be able to say, talk about your mama and that whole when she knew, because the door was open right there at that point. Now, why the judge would butt in with some shit, it just is beyond my understanding. And
But go
anything.
ahead. Well, once again, we're going back. How is the mama related to the elements?
Because the mother is the one who, let me think. The mother is the one who was, I want to use the word pimping her daughter. I guess so. Maybe the pimping could be seen as extortion too, because I'm giving you my child, so you need to give me some money in return. But that's just on a me talking off the hip level. But okay, so the mother is facilitating the whole arrangement of the minor engaging in sexual activity with my client.
How's that mother? That mother is not related or relevant to those elements.
Sexual
How?
exploitation of a minor.
I'm not talking about how she got. How is that?
You know before anybody else, your daughter's a minor.
Right.
I want to have sex with that minor. Instead of you shutting the whole thing down, you proceed to make arrangements for me to be in contact with that said minor.
Again, we don't went through this 5,000 times. Again, she did not tell her to have sex. That's number one. And even if she did, that just she would just probably be R. Kelly's co-defendant.
Okay, well, let's make her the co-defendant. She could be the co-de. That's fine. But we putting her in this case, okay? We are putting her ass in this case. Now, if you want to be the co-de, she could be the co-de. But she getting in this case. It's either pimping and pandering, being a madam.
Oh, Lord. Oh, Lord.
She putting her ass in this case now. Okay, so okay, so you saying, okay, that would make her a co-defendant. Okay. But it has to be some type of mitigation factor because she is promoting a minor to be, what's the word? Because this is the sentence that killed it. He wants to FUCK, but I'm trying to make it business. At what point, we never see where she turns it around to make it 100% business. Meaning, she knew, okay, she knew the possibility of sexual activity. And she also told her daughter, made her daughter aware of it. And then she came back again and doubled down and said, I'm serious. He wants the FUCK. So with that being said, you
But
still make
what is it
arrangements
she
with your
told her
daughter.
daughter to scream?
Huh? Okay.
She ain't
I'm
tell
not
her
gonna
daughter
say
to scream,
I'm
though.
telling you to entice them. Okay. Entice them. So now can we go to the definition of entice? I want you to entice him. That's what she said. I want you to entice him. Take a booty pic, rub his leg, make him want you. But the word entice was used by her. I mean, I don't know what more we need.
Okay, but the word entice was used by her. Okay, okay. You gonna walk me through it. You gonna come up with your own answer one day.
We put look, we're
Yo,
putting that mom in this case, okay?
I
She
see. Shit, before you have force, oh, I'm gonna be in the damn case.
okay, here we go.
Okay.
Elvira. Yes, we got Elvira too. The mother researched Kales. She made the initial call and text. She searched his horoscope to tell the daughter how he liked a person to perform. She took ass across state lines and made her sleep with Kales in the room. Boom.
Okay. So here goes the legal work, and y'all keep in mind whenever y'all um and y'all don't need a reliable legal source for this, but whenever y'all need to look up the legal meaning of a basic word, like entice is a word you can be found both in the Webster dictionary and the legal. Always look up the legal meaning of entice, okay? Because it's going to give you um, how it's usually expressed in a penal code. So
You said go to the Webster dictionary and then look up legal definition.
no, don't go to Webster dictionary. I said when you got to look, just say the word entice. Well, the word entice can be found both in the Webster dictionary and in the in a legal definition, right? A law book, right? So,
Mhm.
but what you want to do is you want to look up. You want to always say the legal meaning of entice. So the legal meaning of a
Oh,
word.
legal
Yeah.
meaning. Okay.
Like if you want to look at, say, if you look up the legal meaning of what is it, sadomasochist or whatever, it'll tell you that it means that those people should be um considered dangerous, given no bond, away from the public, things of that nature. It'll give you the legal meaning. So it says entice means, and this is in law, it says, as used in this section, the term entice shall mean to lure, induce, persuade, tempt, incite, solicit, coax, or invite.
Okay. Now that was used by the mother. So she was soliciting, coaxing,
To
luring
do
him
that.
into sex.
Right. So it doesn't free him.
It doesn't
If
frame.
anything, it gives her and
Yeah.
she has an indictment.
Yes.
If if they
It'll
if they
mitigate
want to
it, guilt, right? Mitigate.
it could mitigate if hold on, but if that was during the trial. Now if that was during the trial, that could mitigate his criminal liability, meaning that he'll say, yeah, I did it, but because and she also put me in that situation, that means he still probably get time, and she'll get time too. But that's during the trial. The trial is over now.
Yeah, I'm running my appeal. Okay, so here we go.
But that wouldn't come up on appeal. The mother's involvement won't come up on the appeal.
But wait, you was asking me, we was doing the back and forth. So you were saying, what proof do you have that the girl lied? Or wait, what are we talking about? Or was we talking
Right. The proof we have that we're talking about prosecutorial misconduct.
about?
What misconduct the prosecutors committed.
So they
Nothing
knew.
about the mama.
Okay, here we go. Yes. Let me run it. The prosecution knew that there was no enticement on my client's behalf. They were more than aware that the mother was the one who had the child engaged. She told her under her authority to entice my client. And based on what we saw, well, we ain't see. I still don't see no evidence of sex.
Okay, you are oh, I'm gonna ask you a question. What are you doing? You're doing what? You're doing what?
We're doing
When
the
you put
appeal.
that bill.
I'm proving my prosecutorial misconduct and how the Jane lied on the stand.
Okay.
My proof of how she created false testimony.
Now Jane lied on the stand. Jane lied on the stand, and what the mama did, that's prosecutorial misconduct.
Okay, wait, because we got away from it. We was doing good. I don't know how we got off of it. Okay, hold on. The daughter lied on the stand, and I just lost it all. We was going good. Okay, the daughter lied on the stand, and the daughter stated that basically the daughter was stating that he was the one that was enticing her, when she in turn was the one that was enticing him.
Okay, so you ain't pay attention to nothing I said.
What?
I said we on appeal,
Okay, we're on appeal.
and I need you to prove prosecutorial misconduct. These are actions, violations
Okay, yeah, this is what we
of
were.
the prosecutors.
I'm with you. We got to the point
I
where
said you cannot relitigate your case.
right, we're not really. We
So I
got to
don't
the
want
point.
nothing about what no mama did, what
Okay,
no daughter did. I need to know what the prosecutors did.
right. They allowed her because we got past that. That's when we went back. We got past that. They allowed Jane Doe to lie on the stand. And then you said your piece, and then it was up to me to prove that they let her lie on the stand.
That they knew
Yes,
that
they knew
she
she
was
was lying on,
lying.
and I presented that within the text messages, it showed that Jane had motive, she had intent, and she was the one that was enticing my client, and my client did not entice her. And they knew based on her testimony that she was not telling the truth. Can I say based on
They knew based on her testimony that
yeah,
she was lying on the stand. So
correct.
pretty much they knew that she was lying on the stand. They let that evidence continue. And here's the proof here.
Yep.
Now, here's the thing. You can prove that the prosecutors actually knew she was lying.
Yes.
So you can say that they knew she was lying on the stand or
Yeah.
in the text messages.
On the stand.
Okay, because here's the thing. So if that's the case, you're assuming that everything in the text messages is true.
Why can't I? It's the prosecution's discovery, and they provided it in the discovery, and they're using it to prove Mann Act. So why can't I use it to
But
defend?
did they say that they believed everything in the text messages? Did the prosecutor say that?
When they didn't say it. I mean, what do you mean? They put it
And
in.
hold on, now I'm because I'm gonna show you how this works.
Okay, because I don't know about that.
Hold on. Did the prosecution one know that which one was factual? Was what they was seeing, what they was reading in the text messages was factual, or what she saying on the stand was factual? And did they have, and did, here's something else, and did, based on the other corroborating evidence of what she had on said on the stand, was the prosecutors to rely more on that because they had corroborating evidence with regards to what she said on the stand, or did they have corroborating evidence with regards to what was in those text messages?
They had her testimony as evidence.
Okay, they had her testimony.
Now,
if they had her testimony, hold on. If they had her testimony and they had corroborating evidence of her testimony,
okay, we don't say
then
you
how can you
corroborating
say
it
that
with
there was prosecutorial misconduct?
This is my question. If they are corroborating her testimony with the text messages, why can I not use those same text messages to defend my client? They get to pick and choose which parts of the text messages is right and wrong. Is that what we doing?
You saying, are they trying to, do they get to pick what
I'm saying
part of the text?
They are corroborating her testimony. Now, and let me give you a sidebar.
Mm-hmm.
The father always said there was proof of when she had sex with him based on her iPhone information. I'm doing an assume right here that he was talking about messages, okay? So I don't know. But back to what we were saying. So I'm saying if the prosecution is corroborating her testimony from these text messages to prove the date she had sex with him, to prove when she flew with him, why can't I use those same text messages to defend my client?
You could have on the parts where the door was open with regards to certain parts of the text. Why are we going to defend your client? Why are we going there?
Because I'm saying you asked me what parts did they say the text messages were true or not. I'm saying if they're using them, they believe that those text messages are true. They're vetting them, they're validating them, and they are using them to support her testimony. So I'm saying
appeal. We on appeal.
Yeah, in appeal.
We can't litigate. We can't relitigate the case. So we don't want to say nothing about we're not talking about why can't we use a text message to prove that my client is not guilty. We're going in a different direction.
Angie, hold on. You just asked me a second ago, did the prosecution say they believe them text messages was real or not?
That's not what I said. I said, hold on. I said, did the prosecution know that what Jane Doe number 5 was saying on the stand, was that true? Or what was in the text messages, was that true? Did the prosecution, can you prove which one the prosecution? See, you're not listening to what I'm saying.
Okay, hold on. Wait.
You got to prove.
Okay, let me process that. Give me a second. Just let me process that. Did the prosecution know that either her testimony was true? They knew that what was in the text messages was true.
You right, Tyrone, huh?
They knew what was in the text messages was true, and that the testimony was false.
Okay. Well, I mean, we can go, you can switch it up however you can switch it up, but we're going to walk through whatever way you're walking through. We can do that.
Yeah.
So you're saying that they knew that whatever was in the text messages was true, and what she said on the stand was false, right?
Yep.
How do you know that?
Because when you look at her, when you compare her testimony to what is in the tangible text messages, the two statements aren't the same.
I ask you, how do the prosecutors, see, you're trying to get out, because I keep saying it's the prosecutorial misconduct. I'm only talking about the actions of
How
the
they knew?
prosecutor.
They knew because it's their evidence, and it's their evidence, and they are using it to corroborate their elements in the case. They are using these same text messages to corroborate the elements in the case, so they know what in here is in this discovery, because they are using this to corroborate.
They
The
did not use that whole
when
that
you say the
entire
whole,
thing to no that the pieces, just say the pieces that they used. Okay, just say, and here's the thing, right? And I'm thinking about the text messages. When I read the text message, I know they were saying something about the Dolphin Hotel. They could have used the dates. And I'll just throw this in, and maybe a paragraph out of the text messages, and that's it, right? If they have other corroborating evidence, which means other testimony, they have videos, if they have something that's date stamped in time,
to my
how
knowledge,
are
they
you going to
didn't,
say, hold on, how are you going to say that it's prosecutorial misconduct that they knew
because they
that
didn't have
what
none of that. They did, to my knowledge, they didn't have any of that, because this is why they used her testimony as
say they
evidence.
knew? Go
Listen,
ahead.
I'm telling you, they use her testimony as evidence, okay? And they are using the text messages time frame. The first question was, were you aware that your mother was texting Kels at the beginning? Where do you think where they verifying that from? Angie? Other than the text messages. They
Okay,
had it.
but
Okay.
okay,
So
but Scott, that's one line. Check this out. Now listen to me. Listen, just say out of that whole thing, that whole sheet, they use the mama text Kales and told as Azrael and told him that she was 18. They used the date of April 15th, 2015. And they used a meeting at the Dolphin Hotel. That's
okay.
all the prosecutors use out of that text message. That's
Okay.
all they
I'm
use.
telling you.
Hold on. When they got Azrael on the stand, they verified that Azrael was mother was texting her, texting R. Kelly as her, that this happened April the 15th, 2015. And they met at the Dolphin Hotel. Those three facts. That's
They
all the prosecutors use.
okay.
Just say that's all they used. They
Okay.
ain't use nothing else.
Okay.
How is that prosecutorial misconduct?
Because her testimony does not match what the text messages is saying.
Is it on the specific facts that the prosecutors use? It got to
Yes.
be on the
You
specific
mentioned
facts.
it. If you mentioned the Dolphin Hotel, yes. Because she went into a full story about the Dolphin Hotel, and that's not corroborated with the text messages. That whole story is not there in regards to the police coming. It don't say nothing about them coming.
Not there that doesn't make it prosecutorial misconduct. It has to be the facts that they used, not nothing they didn't use. What they used has to be in a contradiction to what she said.
And that's what I'm saying.
You
She's
ain't
saying
saying that.
something
You
that,
saying she ain't used the cops and she didn't use this and she ain't used that and whatever.
no,
You
I'm
saying the
saying
stuff what she didn't use.
she added to the story.
Okay, that does not. If she added to the story, that does not mean. First of all, that doesn't mean she perjured herself. That's one. So we got a problem there. That doesn't mean she perjured herself. And two, it definitely doesn't mean that the prosecution knew that they was putting up false
They
information.
did know because
The prosecutor is going to argue this down like this.
I'm gonna tell you
They're going to
this.
go deeper than this.
This is what I'm saying. There was no police activity at all. The young lady testified that there was police came to the location, and there was a whole story behind that where there was no corroborating evidence to that. Okay, that never happened. So, based on these same text messages, that was provided.
So, in the text messages, is there a story about the popo?
No.
There's no story.
No.
On the stand. So, how are you going to make that prosecutorial misconduct?
Because they were aware that she was lying on the stand. She stated that, okay, she went beyond that. But see, that means we back into litigating the case, because now I got to go into bits and pieces to prove.
You can, because we're talking about what I'm not this. I'm talking about we're talking about just the facts. When you're talking about just the facts that was used, you can use that. Just the facts that was used. We're not going to talk about the whole thread, and she contradicted the whole thread. We're talking about just what she said.
Okay. She stated that, and I'm gonna just go beyond that, and that might be a little fluff. She stated that the police came to the hotel door. They asked for her ID. She showed her ID. She also engaged in sexual activity with my client.
Mm-hmm.
Then she stated that she left and went. I don't know what she said. She said she went home.
Mm-hmm.
After that, and then my client left. That was not in the text messages, but I'm saying that wasn't corroborated.
No, what I'm saying. Oh no. What I'm asking you. So, was that in the text messages or not?
No.
So if it wasn't in the text message, how is it you're going to say it's prosecutorial misconduct?
Because they knew she was lying. They knew that. Wait.
That's not how she knows that's not how they know she's lying. See, this is what I'm talking about, because this is when it gets in the weeds. Let me give you another. Let me say it another way. Okay. Just say the text messages consist of this. It consists of her mom and them going to the hotel with her, waiting there, and for her to do the audition. That happened in April 2015. The cops came and checked the ID. All right. Just say she was on the stand and she said those things. And just say none of those things appeared in the text messages. None of those appeared in the text message. I'm not saying something different appeared, but none of those things appeared in the text message. That is not prosecutorial misconduct. Just say if she get on the stand and say, my mom and them took me to the hotel. I was in the room with Keith Sweat. This was on April 2015 when I was 17. And that's what the prosecutor, let her give her testimony. Just say it wasn't anything to corroborate that. Maybe it was. And just say in the text messages, Actually, her brother took her to the hotel. She was in there with R. Kelly, and she was over 18. And just say the prosecutors knew that, with or without corroborating evidence. That is more likely a play for prosecutorial misconduct, putting forth false evidence to sway a jury. But just because that information does not appear in the text messages, that wasn't even, a part that, the extra parts or whatever, that wasn't even used or whatever, you can't say the prosecution knew that evidence was not the truth, especially if they have evidence that supports what she says and supports the elements.
And they don't. Okay, I'm with you. Okay, let
You
me
see
try.
what I'm saying?
Okay, let me try this.
Yeah.
She stated that she engaged in sexual activity with my client, and she stated that the police interrupted them while they were having this sexual activity, and she showed her ID, and then after the police left, they resumed having sex. Now, can't that be used as I'm trying to give evidence to persuade the jury? Or no?
Is that what she's testifying to, or is that's in the?
That's what she's testifying to.
So what's in the text?
It don't say nothing about. Well, see, it don't say nothing about no police going up there. It says the mama said, "Okay, the police are here." And the next thing you know, she popping on text message like, "Oh my God, you're tripping! Like, what's wrong? We're okay.
Yeah,
I'm
I
fine."
did read that part.
Yeah,
But
it don't
that's
say nothing about, and she don't come and say nowhere, Angie, that the why you send the police to the door? The police were just here. We're coming down. She said no, and then it went from you're tripping. Why are you tripping? I'm okay. I'm fine. And then she's like, oh, okay, well, you didn't respond. That's after the mama said the police are here. Then it went to, well, are you coming down or whatever? She's like, I'm parked in the parking lot waiting for you, and your car is parked in this other parking lot. That's what was testified to. And they say nothing about the police coming to that door, knocking on that door, interrupting no sexual activity. They don't say nothing about no police.
right. But again, it's it because it doesn't say that. That's not prosecutorial misconduct. If it says something different for that particular, and it got to be, and it has to be more than a day off, a time wrong, and stuff like that. The law allows for those simple inconsistencies. Understand?
I'm saying she put something in place that wasn't there. She's saying the during sex, the police came to the door and checked her ID.
She said that on the stand.
Yes.
What is in the text message?
I just told you. It
Nothing,
stopped.
right?
It said that the mama texted and said the police are here.
Okay,
And
that's not prosecutorial misconduct. I'm trying to show you. And even just say the mama said the police are here. And just say the police is here with the mama, but as say the police is up there with the at the room.
Okay.
That little inconsistency is not enough to conjure up
Ain't no
prosecutorial
little.
misconduct.
That's a goddamn lie. You put a whole story together to prove your sexual act. That's what I'm saying. She threw the sexual act in there to persuade the jury.
Okay, but check this out. You are assuming, one, that the sex act didn't happen. Two, that the prosecutors knew it didn't happen and let us say it did anyway.
They knew the police ain't come to the door. You see why? This is why we didn't have no motherfucking police testifying. We ain't had none of that. And we was trying to figure out why the police one side. This is sidebar. This is why we ain't had a police on the stand. Cause none of that shit even happened, man. It
But
didn't
check this
happen.
out right. But check this out right here. The prosecutor, I remember this part in their response to J Bo, when she was putting her post conviction motions in, they were saying that because I had to look real good because some people was using the word police officer, some people was using the word security guard.
The mama said the police are here. Okay.
I'm talking about what J Bo put in her post conviction motion. I'm talking about what the prosecutor. I'm not talking about them text messages. I'm not talking about those. Y'all trying to see the problem is when you're talking about overturning a verdict, the bar is set real high. And when there are ways to remedy errors that may have happened during trial, when you're talking about overturning a conviction, you got to have something more than she ain't said in the text message. Just because and then it could be a case like this. Just because she ain't said in the text message doesn't mean that the cops didn't show up. It goes on and on till it finally stops.
This, okay, let me develop it. Because now that I understand what you're saying that we have to really prove that what she stated, the prosecution knew she was lying. Let me develop it. Okay.
Right.
Let me develop it. Because I'm on the
And
right
it can't
track.
be just because it didn't show up in the text message. Can't do that. Because they have evidence that corroborated what she said on the stand.
They don't, Angie. To my understanding, they are using them text messages to corroborate that.
No. It's the case is more than the text messages. The text messages is just to substantiate some of the facts in the case. You really got to prove the elements. The prosecutor got to prove the elements.
Right, but this is what I'm saying. I'm saying that particular time at the Dolphin Hotel is used as the first sexual contact with R. Kelly at the age of 17.
Hello, Ellison.
Huh?
I'm sorry, I was speaking to somebody.
Yeah, that is why that shit got to get blown up, because she is using that. That is what she is stating is her first point of sexual activity with him at that hotel. At that time. Do you see what I'm saying? That's why it's pertinent to that time.
If she's saying, okay, now your argument is getting better. If she's saying on the stand that the first time she had sex with him was, just say, April 2015, while she was under 18, but she actually had sex with him over 18 when she had turned 18, and the prosecution knew that she wasn't telling the truth, and the defense can prove that they knew, that may be, that could be outside of being considered a inconsistency, a small inconsistency. That may be, but if they have a, in the prosecutorial misconduct with evidence, putting forth false evidence, which is the testimony or what have you, is usually a bigger chunk than that, or something like, and if it's something like a capital case, I mean, like somebody killed somebody, and a person come on there and say it was John, and that the prosecutors know that they're lying by saying they seen John at the scene killing somebody. They know they saw somebody else killing something. You know what I'm saying? that right there is blatant, and that is, prosecutorial misconduct. But you're saying that the first sexual encounter is a challenge to that?
I mean, it's not really a challenge because her testimony is evidence. But I'm saying if we're able to refute that she embellished on the story and added the police there, when we have some text messages that's not showing the same information, you know what I'm saying? That's what I'm saying.
Is this hypothetical, Sky?
What you mean?
I thought you said that her first encounter is a
That
challenge.
She's stating that her first encounter. I see what you wrote, Cookie Bako Bala. I hold on, let me read what she's saying real quick. Exactly, Sky, and with the mention of the police in the text, the government could have had her fabricate. She's saying the government could have had her fabricate that story on the stand. She said that's the proof the government knew the details of the text. Yeah, I ran that one, that the government knew the details of the text, because that's their testimony. Okay, this is what I'm saying, Angie. That was supposed to be the first date of her having sexual activity with him at that Dolphin Hotel on that day. Okay.
Okay, so what you got that challenge? So what are you saying, that didn't happen?
I'm trying to figure it out, because I can't. I'm saying the police wasn't there. Now I can't refute her testimony on the sex, but I'm feeling she's embellishing to make that whole story up, because based on the text messages, we have no proof that the police came to the door. I mean, it seems like a natural instinct to say, if the mother's saying the police are here, and the daughter never says, why you send the police to the door? I'm telling dad. You know what I'm saying? She never says that. She just says, you tripping, man. Okay. What? We're okay. Wow. She never says, Mom, why'd you send the police to the door? I had to get my ID.
But that is something that's missing out of the text messages. So that doesn't mean that there was prosecutorial misconduct. That doesn't mean that.
How do we know it's missing?
Because you just said it's not in there.
Right, but I'm saying we can't say since it's not there that she embellished it, like fabricated.
No. You're trying to accuse the prosecution of putting forth false evidence, not missing evidence. False.
Okay, we got the beginning. The beginning is she knew that the girl was lying when she said she didn't know her mother was texting him from the rip. That's the first lie. Okay. We just had to get the second.
She said she didn't know that. When she said she didn't know that?
She said, I didn't know at first
that her mom was texting her.
Him. Mm-hmm.
She said that on the stand?
Correct.
Okay, so she could have not known.
How she could have not known when she knew?
But does that mean that the prosecutors knew that she's texting?
Evidence.
And you got to say that the prosecutors know that the evidence is false.
No, they know because it is in their evidence, in their discovery. They know.
You just saying they know.
Yeah, they know. They know she's lying. So what you saying? They knew she was lying. That's what I'm saying. That's my first point, where they knew she was lying.
She was lying about what they...
Knowing that her mother was texting R. Kelly.
Okay, I'm going to pull up these text messages to see if it's in there. And it better be in there.
What part you looking for? The part where she said...
I'm looking for the part where you saying that she
You
knew her mama was. She didn't know. Hold on. Okay, I'm not a studio author.
you have to go to the transcripts where she stated that she gave the number to her mother.
I know that part. I'm looking in the text message where you telling me that she said she knew that she didn't know that her mama was texting him. And the
Right.
text, if I'm not mistaken, hold on, wait a minute.
Yeah. You'll
Let me
see where her mother she knows the mom's doing it.
where she worked. It really
Go to
way
go to my chat for my support. My legal defense team.
Oh, no, you be making it up. I'm
I
like,
didn't
what the
make
heck?
that up,
Y'all
Angie.
be talking, no, y'all be with
It's
y'all
there.
conspiracies and all of that and
That
theories and shit. Okay. She says, okay, wanted to go after school. Who did R. Kelly text you? This is outgoing. This is her outgoing to her mom. Did R. Kelly text you?
where you at? We go to the
Yeah,
beginning.
no, no, I'm looking at um so she said, did R. Kelly text you? And
Because
see,
looking,
and you got to, I mean, you got to see if you can determine if the prosecutor would have known this. You got we are talking about the prosecution's actions. We're not talking about what's not there, what the mama did this, did it. We're not talking
that
about that.
Angie, there's no way to get around it. They knew because it was their evidence, and they're using it to corroborate their part of their part of the case. So you can't say that they only knew that part, that they knew that's gonna damn Kales, and they don't know the part that's gonna support them.
No. That's not what I'm saying because they have to do as much as they have to do an investigation to convict them. They have to do an investigation to find exculpatory evidence. And once they find exculpatory evidence, they put it in what?
So said the prosecution rebuttal. They knew. So what did Robert say? He then sex her at the Dolphin Hotel, which then will be. There's a conversation in the text where he spends 20,000 on ass and still had not had sex with him. Okay, I believe she was in Vegas at that time. That was in there. So that means that at the time she was at the Dolphin Hotel, that would mean that she was lying about having sex with him. When later on we see in the text messages that statement was made.
What do you understand about your mom had told you the defendant communicated back? Okay. It says it says hold on. Okay, the last time she seen that phone was in Florida. Okay. It was about June, July. And did you use the phone after you left it in Florida with your family? I did not. Okay. A question. You said that you saw some of the messages that your mom had been exchanging with the defendant. What did you understand at the time that your mom had told the defendant when she was communicating with him by acting as, to my knowledge, she did tell him that I was a musician and that I was an artist. And she did send him videos of me on YouTube of me performing live. And when you started to communicate with the defendant, what, if anything, did you remember the defendant discuss over the phone and text message? Initially, he said, I did tell him that I was a musician and said that I could come and audition. And what, if anything, did you tell the defendant about your age? I told the defendant that I was 18. Were you in fact 17? I was. You mentioned that the defendant told you that you can go audition, right? Correct. Did you arrange was the place to arrange to have audition was? what was to take place and who that did with the Dolphin Hotel exhibit. Did you realize what is that? I'm trying to see. Okay, let me go up and see where it says that she knew that, or she said that she didn't know that her mom was posing as her. Hold on.
Okay, I want to break in right there. How come she didn't say that my mama had a conversation with him wanting to have sex with me? Told me.
Okay, but that you can't just get out here and start just talking. They have to ask you questions. Let me see.
Okay, but guess what? We can ask our questions. That's my point again.
I'm
We can,
talking about this is the prosecution. I'm reading the prosecution.
yes, but this is what I'm saying to you. If the prosecution is able to ask all these questions, okay, why weren't we able to cross-examine on those same questions?
You were.
But why we got shut down? They
You did
would not.
not get shut down on these same questions. You didn't get shut down on these same questions.
These questions are validated by the text messages. With everything you just said is validated from the text messages.
Right.
Okay, so why weren't we able to cross based on the same goddamn text messages?
No, you can cross. Listen, you can cross on these questions about if the text messages had something to do with the elements, things of that nature. It still got to be relevant, relatable, and reliable. And if the prosecution opened the door, or if the defense opened the door.
Okay, so the door is open. You just asked, did your mama? Because you were just reading. Did your mother?
Yeah.
What do you remember your mother telling him on the stand? Okay, so why I
Okay,
can't
but
say, Miss Azriel, do you also remember your mother telling him that you were 18 and also having a conversation in regards to sexual activity when you all meet at the hotel? Why can't I ask that?
okay, well, did the defense didn't ask that or whatever?
No, they didn't
And you
because
can't. And if they didn't, hold on. And if they didn't like go into, I think the prosecutor did go into the sexual act or whatever, when or what have you. They did go into it.
why
So
couldn't cross?
he could.
So are we saying he didn't? I'm saying
I don't know because you won't let me know.
okay, go ahead, read it. Go ahead, read it.
Okay, it says okay, it says, and did you use another phone to text, message, and communicate with the defendant? I did. What phone was that? That's the phone that was 17. Did you recognize that's my phone at the time you used to communicate the phone? What
Took
were you
go by
using?
the testimony is evidence. So and when whatever she testifies to is considered evidence, so they don't have to have proof of that stuff. We just have to refute it, find something to refute it. She said in the text messages, the mother is begging her to tell him about her music. Once she finally told him, he said, I don't know.
Okay, here we go. Here we go. Here we go. Okay. Okay. Now, at the time when you first FaceTime with the defendant, did you learn whether or not either of your parents, if any, had any contact with the defendant? At that time, I did not. Okay.
Lie!
Okay. Hold on.
Lie
Okay.
right there. Keep going, Angie. Break the case.
So, all right. So at that, it says, okay. All right. Now, that said that.
That's a damn.
And then it says, let me go up here to this damn text messages. Um,
Yeah, so
Word Kelly.
look, yeah, we gotta get it. We got to get every inch we can. Okay,
Yeah, yeah, okay.
I'm gonna let you finish reading. Go ahead.
No, no, y'all good. Y'all good. I was trying to,
Got to get every inch. Yeah.
trying to see when the mama was. Can you hear me?
I'm listening.
Okay, okay, because you know my goddamn
I'm
computer.
letting you read.
Okay, I'm on page one. Okay, okay. Get up. I'm finna shower. Okay.
We know we got one lie on the table right there when she said, "Did your mama? Did you know when you FaceTimed them that your mama had already talked to him?" We already know that's a goddamn lie.
Okay. You silly. That man ain't trying to do nothing with you musically. He wanna fuck. That's 423. Okay. It has to be more than just hanging out. I hope you're not eating at McDonald's again. Okay. So I can show. Okay, it says you trying to date the man. You need to let him see what your shit, with your Gmail. Okay, movies. I just text him. He ain't text me back yet. Okay, hold
Yeah, ESO said for proof except the text and the testimony, and that is the problem because they using them text messages more than we think, but we not able to use them. That's the part that is, you know, I'm befuddled. I don't get it.
So I'm sorry, I was pooping. I was sleep in my car. And what boat are you talking about? Cause she hadn't talked to him before then. Okay, okay, all right. Be prepared to sing 3 songs. Go up some
We go
more.
this, bro, and this is pre full disclosure to text message. I this for a year now. We knew, she knew, the mama was texting him at the beginning the whole time. So that's never been a question. This is a year pre these damn the full text message. Okay, I'm going off the little lines that we had before from Bonjean's motion. I've been arguing this for a year that she knew the mama was texting him. So that ain't nothing new. She knew that. Cause remember we only
What he say? Send me screen. Dang, what he say? Send me. Did you work on those songs? My first period teacher. Okay, I'm looking in this text message. Okay, let's do Johnny. His comment. Don't say, Kong, you supposed to be practicing, remember. Really, get up. I'm finna go. Okay, have a great day at school. Oh, you be okay. You can say eating disorders, paper. Your father almost there. I'm not horrible. Why? I call you after school. He just so stupid, trifling. Who are you okay? My first period teacher. He said something, but I'm finna take a nap. You call me, I don't answer. It's because I'm asleep. Man, here too.
did you get
Okay.
to the part where they make the FaceTime now? Did you see that part?
Yeah, but in the text message now. Wait a minute.
Okay.
Dang, what he say? Send me a screenshot. Okay, wait a minute. Man here too. Okay, I'm on the phone with a PL. Okay, this man is serious. Okay, well, I'm gonna take a nap. Yeah, what it said, the screenshot. Did you work on the songs for Travis? This man be trying to scoop, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He want fuck since he can anyone he want. If you keep his curiosity peak, he can step and have to let him know. I already told him you ain't no groupie. He sent me this song, so you got to play cool. Now this was on 4/20/2015.
Now wait, hold on. 'Cause, like I already told him you're not no groupie. Why are we talking groupie language when we supposed to be talking business, talking about a contract? I'm confused.
You ain't finna get me confused because I'm trying to think on the part that I'm trying to think on. You talking about other bullshit. Okay, that was April the 20th. Okay. Let me see. I took a varsity class.
He talking about some damn I ain't groupie. You on my jock already, girl. Give it up. Quit playing with me. Trying to play like they doing a record. Girl, sit down. I'm not drinking the
I got the number.
Kool-Aid. Got
Performing part of the tour. Black panties. Take a related.
grip on her.
Okay. Are you okay? It's singing. Outside of school, you know.
Bonji ain't gonna find it. I ain't even worried about it.
Because musician as well. Critique of your own musical skills. I'm looking for the date. Now, your first time with the defendant, then you learn whether or not either your parents or any had contact with the defendant. At that time, I did not. How were you able to get the defendant's phone number? Well, when I realized that I didn't have the right number, I did. I happened to be on my mom's phone or something, and I did see that she had been texting the defendant. All right, so you did learn if your mom had in fact been communicating with the defendant by text. I did. And did you have a chance to look at some of those text messages? I did. Who was the defendant your mom reporting? Me. Do you recall the phone number? iPod. Okay.
Mrs. Clary, do
So,
you remember your mother texting him? You see what I'm saying? We couldn't ask shit. Go all the way over.
so,
It's Buzz moved.
so,
The bed and walked in. Deer's in the kitchen. We can't ask one goddamn question. I'm sick of it.
so, trying to see is there. What month is this?
McDam. McDam, she trying to work my nerves. We getting these text messages in there about hook or crook. Y'all hear me? And we getting this mom in this case. Now she want to be a Cody. She can be a Cody. That's fine.
Oh, yeah. Okay, so she said. Okay, so just if she said, and I'm looking, but I'm just thinking, if she said, okay, she didn't know at first her mama, had was talking to this guy. There's nothing in here that said she knew all the time. That has language that listen to what I'm saying because I know you're getting ready to jump. What I'm saying is this: they asked her a direct question. Did you know? You know, whatever that your mom had been posing at you as you. She said no, not at that time. In the text messages that's just released, there's nothing in here that says uh you've been posing as me or anything that address that when the time she's been posing as the daughter.
No.
So you have to-
Do you see anything in the text messages that show her passing any communication about what Kel says prior to that time?
passing any.
Kel said this. Kel's wants that. Kel's want.
And where?
So
And where?
in the text messages, do you see that anywhere in the text messages, the new ones, that her mother passed her any information about what Kel said or what they talked about or anything? Because if you say anything like that, then that's a damn lie. She know.
No. It said okay, but it doesn't. It doesn't. What you're not, what you're not understanding. It doesn't say. If you're trying to say that she lied, that she didn't know that her mama was posing as her, to prove that she knew, we have to find something that says
Not
my
posing.
mama. I know my mama was posing as me at a certain time or whatever. You don't even have to have a certain time. So yeah, I knew my mama was posing as me all the, initially or whatever. You got to have something that makes her what she says on the stand a lie. Specifically
Okay.
what she
When
says.
I my
Not
paper
that it's not there. None of that.
is
I
okay.
don't see that.
I don't have my paperwork in front of me, but she knew because the mother was she gave the number to her mama, and then
Right.
her mother was the one that engaged in the text messages at first. She
Okay,
never
so
got
right,
she
so
never
she
got in
said she didn't
communication
know.
with him first. So she
Okay,
knew
which proves my point. She said she did not know at first her mama was communicating as her.
no, she did know because she knows that she did not initiate the contact, Angie. That's what I'm trying to explain to you. She knows that she did not initiate the contact with
Okay,
him.
so okay,
She
just
knows.
say that. Just say that.
Okay.
How you gonna say the prosecution know anything? No, have that because they're not asking all of that. They're not saying, well, just because you ain't just because it ain't here, then we're gonna say, oh, we know you did it, and that's gonna be prosecutorial misconduct. No, it don't work that way.
Didn't she testify that she got the number and gave it to her mama?
The question is that was on the stand that the girl answered. Did she know? And this is what y'all put up.
Mm-hmm.
Did she know that her mama was texting as her? And y'all say the lie comes in when the girl say, no, not at first. How can you make that one a lie and two that the prosecution knew she was lying when she said that?
Because she also testified that when she got the phone number that she gave it to her parents.
Okay,
So
but that don't mean that she knew her mama was texting as her. She didn't know
she
till
didn't
she
know
knows.
because I got to when I pull up the paperwork, I give me time to revisit this point because I'll be able to show you where she knew because the mother is passing messages to her the whole entire time. She never made the initial contact with him. That's what I'm trying to explain to you.
Okay,
She
yeah, she
knows.
said that, but she said that as so much as saying she didn't know that her mom was posing as her.
That's a half truth because you know she was
Okay,
contacting.
but how you gonna first of all, one, how you gonna make that's a lie between them two, and two, how is that prosecutorial misconduct?
How do you testify to both that you didn't know but you knew you gave her the number and you knew that she was passing you messages, but then you want to turn back around and say that you didn't know that you ain't know at
She
first.
said she didn't know at that time.
Okay, which is a lie.
Oh,
You
Lord, how I
know
gonna make it a lie?
Because you knew that you gave the phone number to your mama, and you knew your
That
mother.
don't mean that her mom, that she knew her mama was posing as her at that time.
She knows because her mother is transporting messages to her about the conversation that Kels is having with her the whole time.
Okay, then maybe that's her first time she knew. The first time her mama say, "Here is a message for him." You got to substantiate, one, that she knew her mama was doing that when she said she knew, or didn't she, that she didn't know, and two, the prosecution knew that she was lying when she said that she knew that she didn't know what her mama knew.
They did
No,
know.
y'all, you
But
can't substantiate none of this.
okay, let me
Y'all
revisit.
making up shit.
Mm-mm.
Yes, y'all are.
That's not
As
made
far
up.
as
That's not
saying,
made up
because
because she.
y'all are taking what's
It's a
not
fact.
here
It's a
and
fact.
what you
She
think.
said
What?
he got the number and gave it to her mama. Period. So
Okay, she
how
gave enough. Okay, so Sky, if I give you somebody's number, then and you go to texting it, do I supposed to know that you texting it right offhand? I'm supposed to know that.
you're gonna know when I'm telling you that I'm setting up an interview with
And that can be her first time she knew. Or, like she said in here, she knew when she looked at the phone and saw that her mama had been texting him.
that's a
Now,
lie too.
that might be a lie.
Yeah, that's a lie
That
too.
sounds more or less a lie. But
Both
here's the
of
thing. Where can that be proven that she lying when she said she saw it when she got the mama phone?
when I have the moment to sit down and pull up these text messages, we're gonna look at the dates and I'm gonna show you prior to that date when her mother was passing her messages. That's when, okay? I can't do it today
Well,
because
I'm on 420. I'm on it right now. When her mama when she said her mama started talking about messages, that's like at the end of April. That's at the end of April. I'm looking at her testimony for that, and it's not
now, what
there.
what was the first day that she got a message, her mama sending a message or talking anything about R. Kelly said or on anything about it? What was the first point of contact the mama told her? The first text messages about him. What was the first day?
The first, wait a minute. Okay, I'll tell you this good. He said something to you, but I'm home. I'm finna now. You, uh, it's,
I don't
okay.
care if she said R. Kelly said.
Okay, I'm just say I'm okay.
You damn right, Parker.
Okay, so 420, 2015. That is a date in here with these text messages. One amongst the first dates. Well, actually, that is the first date where it says, "Okay, this man is serious." That is incoming. So I guess it's incoming from Mom Dukes. 420, 2015.
So we missing some because how was that the first point of contact? When didn't she meet him on the 15th at the Dolphin Hotel?
Mm,
We a week back because I thought we established that she went to the concert on the 11th and on the 15th. Was she at the hotel by then? See, I got all this stuff wrote down. But how was her first on 420? She talking about some he wants the F, and they supposed to had already met.
well,
Defense.
it could be that they have already met. I don't know. I'm looking at the text messages that y'all y'all want me to rely on to prove whatever it is. This is what y'all using. So this is
Okay.
what I'm using.
Okay, so we're gonna have to run it back because to my understanding, and I don't know if my defense team is still in the chat, they were supposed to have a meeting on the 15th. And I thought on the 11th was like around the concert. I could be wrong. But that's why I'm saying how do we get to he wants the F on the 20th? Something ain't right.
What phone is that? I
We gotta throw the text messages out now. Cause that ain't landing up with my defense.
ain't that some shit? Cause it ain't lying. I'm trying to tell you, is that you have to
But let me
walk.
but still, though, I need to check them dates because if them dates is accurate, I'm almost sure that that Dolphin Hotel date was supposed to be before that or something looked like. So we're gonna have to revisit that.
Okay,
Because I
there
don't know how.
go. Okay, there go his number on a paper. I know these people got this date in here. Some got a date in here. I done seen a date.
Because I remember you read it. You was like on 4/11.
Yeah,
Something
because I
happened.
wrote all the dates down.
Yep. And then 4/15, something else happened.
Okay, 2015. Article in the courtroom today.
You know what? Or some are missing. We might be missing some. No, because that still wouldn't make sense because on 4/20, we wouldn't be saying he wants the F. Something ain't right.
Right, but also it ain't proven that not. I mean, you got to prove with prosecutorial misconduct. It is what the prosecution did wrong.
Yeah, I got you. I got you. I'm
Yeah,
saying,
and so if I'm looking
I
for
got you.
these,
EL, so do you remember what the date was that she said she met at the Dolphin Hotel? Baco Bala, Magdan Parker, who else in the chat? Elvira, you might still be there. Some of the texts are out of date. Oh, she just said it. Some of the texts are out of date in order sequence. Okay, so we ain't gonna be able to use that. That's
but it has the date by the text message.
right, but I'm saying clearly that's not right because I promise, when you gave them dates, I believe you said on 4/11.
Okay, here we go. 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 Okay, and did you continue to have sex conduct for him for a period of time? Yes, I did. How long were you with the defendant for 5 years? I want to direct your attention to April 8th of April 18th of 2015. Do you remember that day? I do. Wherein did you go that evening? To the festival with my parents. Who was the headline at the festival? The defendant. So it was April 18th when it was the festival. It was either the 8th or the 18th because the prosecutor started to say the 8th and she said 15th. And then in what city? It was in Orlando. And you were then 17. In April of 2015, when you met the defendant, were you still in high school? I was. I was a junior. So she was saying, so either April 8th or April 18th, she went to the concert.
Okay, then we might be
Okay.
good. Okay, we might be good. Okay. Okay.
Okay. What
So
happened okay, it says, did you buy
then by
your
20th, it would be he won the FUCK. Okay. That'll work with my timeline.
Okay. A picture of him grabbing her hand. Objection to leading over.
But then that means we need the Alpha Hotel to be around that next week or so in order for that to line up.
What you say?
I said, so if they met on the 18th or the 8th, on the text message he won the FUCK on the 20th, then we need that Dolphin Hotel event to be after that sometime. You see what I'm saying? For that all to
Oh
line up.
yeah, it did because that's when Um, I remember reading that, but I had scrolled all the way up to get
Okay.
this. So it says, did you testify? Mm, Black panties.
Michael
Did you
said,
receive? Okay. It says, I gave, what if anything did you do with the paper with his number? Okay, so that was the, after the 8th, between the 8th and 18th. What did you do with the paper? I gave the paper to my mom. And what, if anything else, did you do with the phone number on that piece of paper? I did text the number. Did you receive a response from the defendant? Initially, no. I had entered the proper number. You later learned that you had entered an incorrect number. Yes. I want to step back a moment. You testified that you were in high school at the time in your junior year. What what was your interest in high school? In music and sports? And what, if any, music related school activities you participate in? I was taking 3 choir classes at the time and part of a page. I mean, how many weeks did you do? Okay, so did you take out of the varsity? Are you okay at the time? Are you okay at the time? Money singing. What pursuit? Okay, you testified. Sports participating. You testified. Did you reach? Okay. Were you then interested in the defendant? Okay. I'm going to turn back to one of the defendant associates who gave you the defendant's number. Were you interested in the defendant romantically? I was not. You testified, though, that you did try to contact him by sending him the text message. I did. Why did you try to reach the defendant? Because he was a musician as well, and I felt any critique would be good critique. Critique your own music skills, yes. How did you eventually get in touch with the defendant? I eventually had a FaceTime with him because I didn't know if it was necessarily just someone from his entourage who was trying to take advantage of me. And when I did the FaceTime him, in fact, okay, when I did FaceTime him, it was in fact him. Now, at the time when you FaceTime him, and just for the record, can you explain what do you mean by FaceTime? FaceTime is a visual phone call. Okay, so it was a way for you to see the caller that you were talking to. Yes. Now, at the time when you first FaceTime with the defendant, did you learn whether or not either of your parents, if any, had any contact with the defendant? At that time, I did not. How were you able to get the defendant's phone number? Well, when I realized that I didn't have the right number, I did. I happened to be on my mom's phone for something, and I did see she had been texting the defendant. Okay, seems like
okay,
this is
that's
part of
fine.
an
That
inconsistent story right here. All right, so did you learn that your mom had, in fact, been communicating with the defendant by text? I did. Okay, so hold on.
that's the lie, because
Now,
was the one that was talking to him first, and she's the one that said, "You know, you're gonna have to FaceTime him." Okay,
well,
that was going to be best.
okay. Now, at the time you FaceTime with the defendant, did you learn whether or not either of your parents, if any, had any contact with the defendant? At that time, I did not. How were you able to get the defendant's number? Well, when I realized, um, and I did see that she had been texting the defendant, so she didn't know at the time. Okay, so she didn't know at the time.
Now,
And going into the text message,
does that make sense to you?
she says the man, no, it's probably a little lie up in there
Oh,
somewhere.
okay, all right.
Hold on, it may, but we're not we're not talking about her lies right now. It's for we're talking about prosecutorial misconduct.
We talking
So,
about her, and we talking about the prosecution letting her lie.
okay, but again, you got to prove that one, they knew that she was lying,
They did.
and 2, that the lie was egregious enough to be considered as prosecutorial misconduct.
Okay, so because she basically took her mother completely out of the equation. She went straight to I FaceTime him, and then I saw that my mom was texting him. Damn lie. Your mother preempted the whole thing. She is the one that got in contact with him, and then that was how you was able to get in contact with him because she told you to FaceTime him. It's a goddamn lie.
When she told him that, when she told her to FaceTime,
In the text messages, she said something like, you're gonna have to FaceTime him, some.
and the text message that just came out.
Yes.
Okay,
When
the first thing I see that mentions anything about him was on 420, and when she's talking about, okay, this man is serious. Let me put in the word FaceTime. Or did she say FT? Did she say FT or FaceTime?
Oh, I want to say FaceTime. FaceTime. Oh, did the mama say FT?
Yeah, I don't know. They were talking about, hold on. Where is FT? Hold on. Okay.
Cooper said 422 was the hotel. Ooh, they moved fast, baby. They went from
He knows you're a singer, but he wants to
okay,
FaceTime.
FT. Cooper said
FT, well, that's on 420. Hold on. Okay. 420. Okay. When they said was the other day?
422. They was at the hotel. But we trying to see when the mama told her to FaceTime him.
He
That's
knows you're a singer, but he ain't playing. He wants to FaceTime. All of this happening on the 20th. Since he can, anyway, he wants to keep his security peak. Put him in, okay, but he gonna step, but I'm gonna have to put him in his place to let him know. I already told him you ain't no groupie. He sent that this morning, so she is letting her know about all of this going on, the FaceTime and all of that
where,
conversation happened on 420. Excuse me, I got damn hiccup.
okay, where does it say that she told her to FaceTime him? That's the part we trying to figure out.
Okay. How did you eventually get in touch with him, the defendant? I eventually had to FaceTime with him because I didn't know if it was necessarily just someone from his entourage who was trying to take advantage of me. And when I did FaceTime him, it was, in fact, him. Now, at the time when you FaceTime him, and just for the record, can you explain what you mean by FaceTime? Because, so was it, yes. Now, at the time when you first FaceTime with the defendant, did you learn whether or not your parents had any contact with him? Stay right there. Stay right there. Did you learn, did your parents have any contact with him? Okay. Okay. And she said, at that time, I did not. Okay. At that time, I did not. Wait a minute. I'll go on it. Okay, outgoing. Now, Okay, you call me outgoing man here too. Okay, I'm on the phone with, yeah. Okay, this man's serious. LOL. Dang. What he say? Send me. Did you? No, this man transcript. I'm trying to make it. So she did know. She, if they're talking about the same man, she did know. Did you work on those songs for Travis? I don't know what the fuck that is. Yeah, if that's the case, she did know that her parents had, after, yes, time FaceTime with the defendant. Did you learn whether or not either your parents, you know what? So if that's the case, she actually did know. She did. I would say she did know the parents had contact with him. You still there?
I'm waiting for my apology. Yes, I'm listening.
Hey, you don't get no damn apology. I was finding out when did she know or not.
So
So she knew. Okay, well she knew.
okay,
Now
she
you're
knew.
trying to make this prosecutorial misconduct, right?
Yes, the prosecution knew that she was lying because she knew. They all knew that the mother was the one who facilitated the initial contact, and she told her daughter to FaceTime her. So when the daughter FaceTimed her, the daughter had already knew that the mom had talked to her because the mother told her to FaceTime him.
Okay, so let me ask you a question. Do you think that would be considered an egregious error that the prosecution let this go forward in an effort to sway the jury? This one fact right here, that she she knew that her mama had contacted, was hadn't text him, even though she got on the stand and said she did not know. You think that is a terrible enough act of misconduct by the prosecution that would have if that swayed the jury to
Yes,
find him guilty? You think that?
yeah, that's swaying the jury because you're misleading the jury. You're misleading them by eliminating the fact that you weren't the one only engaging with him, that you did not make the initial conduct. You're your
Okay,
mom.
go ahead. But
Okay.
it's her mom and her actions. Does that have anything to do with proving or disproving any of those elements?
Yes.
How is whether or not she told the truth, whether she FaceTimed him, told the truth, whether she knew that her parents had contacted him first or not, have anything to do with disproving or proving those elements and the facts in the case? And that knowing, if the jury knew that little bit of information, that it would have changed their mind about the verdict, about the, I'll
Yes.
say, about the charge with the late. Are you
Yes.
serious? Tell
Because
me how, please.
I feel because any reasonable juror would understand there's a difference between him fully communicating with the minor instead of the mother. Okay, the mother is facilitating the all of the arrangements, all of the conversation. The mother is the one that created the lie about the initially, and them knowing that the mother put her in that situation would have swayed at least one juror. I do believe that. I don't believe
That's the reason. I didn't say sway the jury. I didn't say sway the jury. We're talking about we're
doubt
talking about the that one little fact would sway the jury to vote to say that he's not guilty. On
it.
top of all the other stuff,
Yes, it
how is the parents? How is the parents and that fact connected to that element? Connected to the facts in the case? You got to be. It's
because
more
it's
than
not.
just what you just think. That look. Are you serious?
Yes,
I went through and broke down what
because
they have to prove. Huh?
it's showing that he did not solicit her. It shows that he did not entice her. It shows that he did not persuade her into the situation. It shows that
Lord,
the mother created all of that instead of the daughter. There was a whole.
Lord have mercy, Jesus. Can y'all please keep
You
in
asked me.
mind about, hold on. Can you keep in mind that it does not, just forget about all of that. Forget about all of that about he is going to be found guilty for the enticement, inducement, coercion, whatever, just for the fact that she was allegedly under 18 and she traveled across state lines. Just forget about all of that, the enticement and all of that.
But I can't forget about that because if
Yes, you
I'm,
can, because it don't apply.
I'm gonna tell you this: if I'm a juror and you get on that stand and tell me that the mother was having an initial contact with him, she is the one that had the first sexual conversation with him, and then made her daughter aware of the intent of the I'm sorry the wanting of a sexual act to occur. If you're telling me that as a juror, I am gonna use that as reasonable doubt. Yes, I am.
Okay, so I was just going to say that. So now you're talking about reasonable doubt. You are over the place.
I'm not.
You're talking about reasonable doubt. Okay, just say this. Okay, the case is over. It's over now. It's over. We're on appeal, and
Okay.
you're shooting for prosecutorial misconduct.
Okay. So
Now, are you telling me what the prosecution did, and was it egregious
the
enough?
the prosecution hid the fact that my client did not coerce, persuade, and entice this minor to have sex with him.
It was the oh Lord have mercy, Jesus. The entice, persuade, induce, whatever is going to be there regardless because she's under 18.
Yeah, you're
It's going to be
saying
there
that as
regardless.
a legal term, Angie, but I'm telling you as a
Okay, but
rep.
now, but you're talking about reasonable. See, you're mixing two things in together. You can't relitigate the case. So reasonable doubt is out the door.
I'm
We
not.
can't talk about reasonable doubt.
I'm saying to you, okay, now maybe I ain't using the right words. I'm saying to you, if you would have introduced that mother in that case at the beginning of that whole situation, I'm going to say that he did not induce this minor. He wasn't a predator, all that stuff they want to say. He did not put her to the point of sexual activity. I don't know how to say it, but
What will you be doing when you do all of that? What will you be doing?
what do you mean? What would I be doing?
Well, if you're saying all of that, first of
I'm
all, who are you saying
I'm
it to? Who are you
I'm not.
saying all of that to?
I'm talking about if I'm a juror, I'm gonna find him
No,
not
no, no,
guilty.
no, no. Is there going to be a jury in the appellate process?
You're saying you asked me, how does that change the outcome of the case? How does
I'm dealing
that,
with the appellate process.
yes,
Listen. On appeals, it deals with that question. Would it have affected the outcome of the case?
and my answer is yes, because one juror would have see, I have to use the word I have to use the word reasonable doubt. One juror would not have believed that my client solicited this minor into having sex, which kills the whole theory of the solicitation of the minor and coercing the minor and persuading the minor. I feel like the mother and the daughter were the ones that were doing the enticement, and they, he didn't solicit them into sexual activity. That's what I'm saying. The outcome
That's
will
what
be,
you're saying, right?
huh?
That's your argument, right?
Yeah,
That's your argument, right?
yeah.
So you re-litigating the case. We can't do
You
that.
you
No, no,
asked.
no, no. I know what I asked you. I didn't ask you to litigate the case, though. I'm asking, listen, you got to deal with how does it make it prosecutorial misconduct? What you saying
Because
the
the prosecution knew that the young lady was lying on the stand by not
Stop right there. Stop right there. You're saying the prosecutors knew that she was lying on the stand.
correct.
How do you know they knew that?
Because based on their discovery and evidence that they put into I'm sorry, based on the documents that they put into
You're
the
right.
that shows inconsistency in her testimony.
Okay. Once again, that's dealing with challenging her credibility while on the stand. That deals with during the trial process. We're not in the trial process. You
Right,
see,
but
listen what I'm saying. Let me say it to you.
okay.
Okay. We're in the appellate process. Appeals. Okay. The trial has been litigated. If no juror was swayed at that time that that she she wasn't a credible witness or whatever, that's too bad, so sad, right? Now we're in the appellate process. You're saying that it's prosecutorial misconduct, that and you're saying that you can prove that they knew that she was lying versus just being inconsistent for something, just she made a little error in a testimony. She was flat out lying for the sole purpose of swaying the jury to get a conviction. The prosecution knew that she was flat out lying for the sole purpose to get a conviction. First,
Yes.
That's your one task right there. You gotta right there.
Okay.
You got
He because
how you
he
gonna prove that?
because he based on the information that was left out of her testimony, it proves that he was not the aggressor. It proves that he was not the one that was coercing her and soliciting her and persuading her. Also, it proves that, okay, and I'm looking in the chat. It
You
proves that
still going there with
wait,
the
wait,
enticement? Go
wait,
ahead.
wait. I might be saying it wrong, but I'm saying it shows that he was not the one. That's just one point. He wasn't the one enticing her. Okay. He also was not the one. It shows that my client is not using his celebrity to seduce women into having sex.
Injustice free Kelly, get your motherfucking ass out of here. That's a motherfucking lie. If you had your dumb ass in here in the beginning of this motherfucker, you would see where I was showing how they can do whatever. Get your motherfucking ass up out of here. Dumbass. Stupid bitch.
Okay, they said the same argument Sky's making, the same argument Bojine making her post trial motion. So Sky's right. But I want to continue and break down the RICO. I want to say,
I'm talking about you. Will you tell it?
okay, I also
You
want to
tell
say
me when I've been
also
wrong. You old sorry motherfucker. Get your ass up out of here. Bitch.
wait, let me say this. It also
I
shows that.
can't stand old dumbass motherfucker coming in here telling me something. Well, motherfucker, if you know it, you do it. You get
Wait,
all the motherfucking shit right.
wait. Look, it also
Oh,
shows.
and hold on, and I hope you go over to Bongino and the rest of his motherfuckers attorneys, because apparently when they put all those motherfucking motions in, they thought they had something that was gonna help them, and that shit got declined too. You stupid motherfucking bitch, get out of here. I bet you won't say nothing else and sound and look stupid. Telling me about what I said. And Kels always said, she came up with the same, all the shit she done came up with got fucked over too. Dumbass. Get your ass out of here.
Okay, now let me
I
let me
can't
put
stand
my
a dumb motherfucker.
let me use my piece for the RICO. It also proves that my client is not using his celebrity to entice minors into having sex with
Now
him.
you are relitigating the case. You
Well, no,
can't do that.
you asked me how
I
it would.
know. No, listen, you are relitigating the case. You can't do that. We
Okay,
are
let me
beyond
reword.
that.
Let me
That
reword
you had your
it.
shot. You
Let
had
me
your
reword it.
shot with
Let me
litigating the
reword it.
case.
Wait, let me reword it. The prosecution also knew that with them knowing that the mother was the one, and I'm sorry, the mother and her daughter were the ones that were enticing my client, also proves that the element in the RICO is not matched, is not satisfied either.
Why are you are litigating the case?
Okay, the price. No, because the price.
I
Okay,
don't
the
want.
price. Okay,
Listen,
hold on.
get it in your head. If she's under 18, the enticement, whatever, that's automatic. So it doesn't even matter. You don't have to tell me about no enticement, none of that type of shit. Because if that fact, just say she got on the stand and she was found, they called her. They say the defense called her and say, hey, you didn't know, no, you telling a lie about when you found out. Not they ain't gonna say you telling a lie, but I'm just for dramatic purposes. Are you sure? I'll just say you telling a lie. Okay, you telling a lie. Okay, that you ain't know that your parents had then got in touch with. They catch you on the stand. All the judge is gonna do at that point is say, hey, either disregard all of her testimony or that particular piece of it. If she found to be impeached on that little part, which most likely she would just impeach that little part. But with the proven enticement, coercion, blah 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 blah, whatever, and Jabo tried to do it herself to say that, hey, my client wasn't the one that's doing the enticing, whatever, just like you're trying to do. And the judge came down and what? Knocked it out.
Okay,
Deadly.
yeah, and
So
that's
so you're talking, so you can't relitigate the case.
but we are
I'm asking you,
showing
I
this
don't
to
want
our
to hear nothing about no
court.
enticement. I don't want to
Okay,
hear nothing
but
about no reasonable doubt that could have taken place during the trial. That you had your shot with that.
okay,
When
well,
on the appeal.
I'm showing you how it deflates the whole notion that it shows that they had purpose to be in this equation. Okay, it shows that they had the intent to meet my client, whether whether she had to have sex to do it. She was trying to do anything she can in order to get close to my client. It was not in reverse, god damn it. And that's just it. That's just all. Now, I don't know how to put it into words, but at the same time, the false testimony was known by the prosecution because it was their evidence that they submitted in discovery and they allowed it to stand.
And you can
Man,
prove
Angie.
that. Huh?
Now you see what I'm going through, Angie. Man, Scott been telling me this shit for the past 3 days. She said, "Watch, Angie gonna see. Angie gonna see.
We already agreed to the prosecutorial misconduct. It's a matter of getting the terms in regards to what supports the goddamn
No,
prosecutorial.
I'm talking about
No.
I'm talking about when you said Asriel, they knew that she lied because she said that she didn't know at that time. The
That
problem
was one
is
point. We also went to the Dolphin Hotel. We also went to the sexual activity.
right, but I'm saying the problem is we don't know when that time was to say that she was lying. So you saying that she always knew. We need to know when she knew, and we need to know when she said she didn't know at that time. We need to know when that was in order to prove
We
that
already
she
know
lied.
what we knew. We already established that she lied. What we trying to
How,
do right now is
how you
prove
establish
how we
she
knew.
lied?
It's a difference between a lie and
She's
something
trying to
that's
start
inconsistent.
the level of the
The
lie is
difference.
what we
It's
determining.
but you're trying to raise it to the bar of prosecutorial misconduct.
Right.
I don't
See,
know what am I.
oh,
Am I
I
in the
don't know how to
goddamn
do it.
in
I'm
the in
not
the
no
in
damn
the what?
attorney. I'm just telling
Okay,
you.
but you keep I keep telling you stop litigating, relitigating the case, and guess what you come and do? I tell you
I'm
that it
answering your
don't even
question.
matter
You
about.
asked me the question and I answer the question.
I'm asking. Okay, after I done told you for I don't know how many times, stop telling about entice, induce, coerce, and persuade. It is there.
Okay. I gave you a
Okay,
basic sentence.
you can, no, but that is not the answer. See, and I'm glad you're going through this because this is how hard it is going to be harder to prove prosecutorial misconduct. You keep going back to try to relitigate the case. Well, they ain't gonna let you do that.
Okay, but I don't want to relitigate it. I want to
That's
state
what you're doing.
that don't lied and that the prosecution knew because they have the evidence to show the inconsistencies.
But what you would have to do is point out like this is how you got
What
to tell them what they knew.
doing?
What okay? So what did they know to indicate that she was
They
lying and
have
they allowed her
text
lie?
messages. Why do we keep having to go to that point?
I know what in particular though. You broad with it. What in particular
Right. You
points
can't
out?
just
They
say
knew
what.
that the timeline of events did not match up with her goddamn testimony.
Okay, so you got to break that down. You
She's
broad.
saying
You
I
got to
can't
be,
break it down. You
huh?
can't relitigate the case. You can't.
I'm not talking about relitigate the case, but I'm saying persuade them. Why be more persuasive? You too
What
broad.
point are you pulling out? Okay, what I'm trying to say is this. I could have totally lied on the stand.
Mm-hmm.
I could have totally lied on the stand. And you get some text messages that prove that I lied on the stand. But what I told the truth about is the elements in the case. I said I was under the age of 18. I got on the phone with the defendant. I'm being Jane Doe right now. Okay. I got on the phone with the defendant under the age of 18 and say I'm gonna take my ass across these lines. Willingly, happily, with my mama help. I went across the lines. I had sex. You and an adult. I had sex. You allegedly exposed me to herpes. That is what I testified to. Those are the points in the case. Those are the facts. Those are the elements. The story part, okay, where you're talking about, well, on the stand, the defense had a missed opportunity where I guess because you said that too. You said well they didn't use the text message to prove that it was me doing all the coercion and whatever. But I tell you, if I'm under 18, the coercion, that's on the adult anyway. I don't care if I called him 20 times and promised him on the phone
I hear
before
what
I
you
went
say,
across state line
but
that
I'm
I'm
done.
gonna do some of
I'm
this
done
ass.
litigating. And this is my argument. I feel like the information that was not provided to the jury when you're saying storyline, I feel like some of the storyline that was not included in her testimony, we were not given the chance and the opportunity to cross-examine her in regards to that same testimony. So you shut my defense down.
Okay, that was the judge that struck the defense down. That
Okay.
judge struck the defense down.
Okay.
Or,
Judge error then. Let's
but
run it under the
listen,
judge error.
do you know that all of that was the defense? And is that defense even legal? See, it's a more. I'm trying to tell y'all, leave out.
What
It
do you mean
doesn't
the
stop
defense was legal?
where you
I didn't get the
started at.
opportunity
It
to even
goes
create.
on,
I didn't
huh?
get an opportunity to create a defense because I couldn't ask my goddamn questions. What are you talking about?
Okay,
I
but then
couldn't even cross
but you
examine her
also
to create a
are talking
defense.
Oh
about.
man.
Hold on, but you also are talking about she lied because of stuff that she didn't say on the stands that was in the text message, or vice versa. That still doesn't make it prosecutorial misconduct.
She misled the jury. I'm saying the information that was withheld, the jury did not have the opportunity to weigh the information. And furthermore, we were not able to cross-examine her in regards to the same line of questioning. So we couldn't even sustain a defense.
No, you can't say that they didn't have a chance to question her with regards to the same line of questioning. I mean, that would be a blatant, um, uh, you know, uh, judicial discretion, right? That'd be a blatant,
But they weren't. When were
No,
they able to do
that
it?
was listen. She had a cross. Can it cross?
Right.
And apparently, Exhibit 233 was
Was in
in
the
there. So you can't make it prosecutorial misconduct if Cannon didn't read the motherfucker.
But
And
if
then
it's
didn't listen to the
there
question.
and we can't, okay, but if you saying it's in there, then why couldn't he question her about it?
he chose not to. He chose not to.
Okay, well then we gonna move to insufficient counsel. Boom. We gonna walk it on down the
That
line.
would be your best bet. That would be your best bet.
Yeah, you can do ineffective assistance of counsel. I mean,
We getting it in there.
But you
know what?
The thing about it is you can't keep saying, it was the mama that coerced her. I mean, you
No,
only
I'm not saying that. I changed my argument to the information that was the information that was withheld from her testimony was not provided to the jury, so the jury was not able to deliberate the full storyline. Furthermore, we were not allowed to.
I think you
Shut up, let
adopted.
me finish.
withheld from the
We were not
testimony
allowed
is
to.
not against the law. Withheld from her testimony. Okay, all right.
What you just said about the storyline. I'm saying that they withheld the information
How did
from
you
the story.
withheld?
Huh?
You talking about withheld a storyline? No. If okay, the storyline is fair game for
On
the
both sides.
defense. Exactly. So if she gets up there and say, I met him in April, and the defense has said something that she met him in December, it's the defense job to get up there and say, no, based upon Exhibit 233, you met him in December.
Okay, we back in ineffective counsel then. We gonna show that her attorney had the opportunity to come in and straighten out the storyline and get that information on record for the juries would be able to deliberate it and take it into consideration in regards to my defendant's I'm sorry, my client's guilt. And that was not done. So we still in insufficient counsel.
Okay.
Man, I got a brief Angie that'll get them out tomorrow.
What?
It's on an ineffective counsel. You start off with, you had in the opening a crackhead ass attorney talking about, please find my client guilty. And then in the closing argument, you got another attorney giving a Martin Luther King speech. They gonna be like, let him go. He free. Free chaos.
Boy, see, that's why people want to kick your ass.
Free
But
chaos. That's
but
We ain't gonna worry
no,
about it. I'm
I'm pretty
going
sure
to
he's gonna
develop my argument because I still feel I'm on the right track. Because I feel like what I said, her not well, I guess it wouldn't be her fault at this point. Okay, we established that the attorney should have came in and made her correct that goddamn storyline.
if it's
And
egregious enough that
that's
what
egregious to
was
me.
left
Because
out.
you
Hold on. What was
see,
if it's egregious enough that what was left out that could that may have changed could have changed the verdict.
yeah,
Then
right. The
okay,
verdict.
argue
okay,
that.
okay, check this
The
out.
verdict.
This is just me speaking. I ain't trying to put it in no term. Because with that exclusion of the mother being disclosed, you're not able to show, and I gotta say it, that he didn't entice her. You're not able to show that this young lady was traveling with intent and also willing to travel to have sex with, like you're saying, it doesn't defeat the law, but it might mitigate his guilt. Okay, so every situation, it will mitigate his guilt. Okay, so with that not being in there, it helped us, we weren't able to create any type of reasonable doubt.
Well, no, yes you were, but the thing about it is, also, and I don't know if you was in here when I read the 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 rules of evidence 401 through 403. I told you you cannot present evidence that's misleading to the jury, that confuses the jury. Can't do that either. And in that pretrial motion, when they were talking about extortion and all of that in that little area, the prosecution said that bit of evidence would serve to confuse the jury.
Well, I
Because
want
because
okay.
listen, if you put on a defense heavily involving the parents, which they ain't gonna let you do it anyway, because it will confuse them, because it will have a jury thinking that, hey, well, R. Kelly needs to have some co-defendants. I know you're gonna say, well, ain't that what? Listen,
No, this is what I'm
he's the only one on trial. It would
right.
be different if the
All
parents
right.
and him was on trial. Then that's fair game.
Okay, but
Because
look at
he's the only one on trial, you cannot enter in evidence that will confuse the jury.
okay, now look at this. Let's stop right there. So you trying to tell me her not disclosing that her mama was the one that facilitated, I don't know the word, facilitated, produced, entered her into this entire situation, it did not confuse the jury? Like you basically created a whole new
you can't
storyline that is
introduce
not true.
evidence like that. I said
Huh?
you
You
can't.
know what? They tried it actually, and they tried it
Wait.
with.
Hold on, Kelly. Hold on. I'm saying you're telling me that is not confusing the jury because you left out a whole key piece of what really happened. So the jury is under the understanding that her and R. Kelly were the only ones in communication. A 17-year-old minor and a grown man, and he basically was predator, went after her, had her meet at the hotel, had sex with her, asked her to fly, had her fly, then had sex with her. Do you see what I'm saying? That's a whole new, how do I put it? That's a whole new line of understanding for somebody. When you add that mother, and I know you don't like it, but when you add that mother in the scenario, I'm sorry, it changes things. So you basically misled the jury because you left out the piece with the goddamn mama
But
and
the
all of
mama
her
didn't.
nefarious acts.
But the mama did not commit any crime, and the person that
She
is
did commit
direct evidence to
and
the
pandering.
crime, to the elements, is as.
She was pimping. Okay. She pimped her daughter. That's how her daughter got to the situation. Okay. I'm sorry. Y'all might disagree, but I am saying that them not including
I
that
understand what you're saying,
testimony
and
has,
so to some degree, I agree with you. But what I'm talking about with regards to the law, it ain't gonna be allowed.
but I'm saying you
They
confused the
tried it with
jury
the
though. You
they
created a
tried it
whole
with
and
the
contradictory storyline
father.
that's not true. Do you see what I'm saying? Because you have it where you just have him engaging with a minor. You don't have another adult, and not only an adult, but her mama being in that situation with her. To me, that changes the dynamic of this thing, all the way down to the man to her being there, everything. That's a whole different storyline.
But so what? So what happened? So what is? So would that be? R. Kelly would be found not guilty, or R. Kelly would have a co-defendant.
He'll be found not guilty if I was on the jury panel. I'm sorry.
I ain't no. Okay,
Oh.
so you are all the way off.
If they blame it on her instead of if they blame it, if they shift the blame.
If
Yeah,
I'm a
that's
juror
all the way off.
and
That's
you
all the
tell
way off.
me that this mother put her daughter into this situation, however you want to do it, I'm gonna just be simple. Put her daughter into this situation, was giving her daughter game to run game on my client. Okay. Okayed her daughter to travel, knowing she was 17 the whole time. Told and gave her advice on giving booty pics, making physical contact with this man, all of that. I promise you, as a juror, not knowing a goddamn thing about the law, nothing else, he is being found not guilty on her. Now, if you want to bring the other witnesses in, fine, but on her, not guilty.
Okay, but check this out right here. If that's the case, that's the case. Just say that's the case, right? The person, the victim witness, has a reasonable expectation from any adult, not to put her in harm's way, and especially intentional harm's way. That means that everybody that put her in harm's way or in intentional harm's way is subject to be criminally liable.
Okay, then let's make the
You
mama
have a cause of action.
We can add the mama as a code. I'm not opposed to that.
Right, but how does that help him though?
It mitigates his guilt. Because I just told you, in any reasonable juror, because you got to understand, the law may be the law, but
let's go support the RICO.
The person in the stand is the juror in the stand is me. Okay, whether you like it or not. Okay. The law could be the law, but if you bring that set of evidence to me, okay, that storyline I just gave y'all, he's not guilty. Now, if you want to say that the mama put her in harm's way, let's bring the mama in as a code. We could do that.
So what charge will you give her? What's her charge?
Pimping.
So sex trafficking. Okay. So if it's sex trafficking, now you got to give him that same charge. Now you just gave him more time.
I said no, because I'm mitigating his guilt because she's
okay. You can mitigate it, but you just gave him another charge in the process.
That's dependent on the juror. I already told you. I'm saying not guilty. He's walking if on her if I'm sitting there. I'm not putting any guilt on him. I don't care what I'm instructed to do. All that shit y'all say. I don't give
I can't wait to see.
I don't give damn
what that lady gonna put in her brief.
Me too.
How she gonna finagle this?
I thought her best arguments was in her post-conviction motion. I don't see what she's gonna do after that. It's gonna be interesting.
Like I don't know what I'm talking about. That changes it.
Huh?
Yeah, but the thing about it is, and I just can't believe that I don't understand why y'all think that just before we even came up with prosecutorial misconduct over on Levi, just with the text messages, somehow that was proof of R. Kelly's innocence or guilt.
Right. But
it really didn't
you know
affect
what's crazy?
me.
Time.
You
I
got
just said
to
it 1,000 times.
what?
You know what's crazy though?
About
So
because it's showing that he is not the aggressor. It's showing that there isn't. This is the thing that people can't, and they not.
no, it's
Wait,
not
Kelly.
showing nothing about him. It's showing the mama is
Says
fucked up.
that
Wait.
entice
It is
persuade.
not shown. This is what you all are seeing.
It showed the mama fucked up.
That
Nothing
the
about him.
mother
He's not.
is the authority over the minor. Okay, so
Okay.
whenever you have a minor, you cannot not put the mama in there as being what's the word I'm looking for? Responsible, because she
Responsible party.
is responsible for that minor. So to me, there's no way you leave her out. And at that same saying, there's no way that you leave her out of that testimony as well. How do you have a minor and a goddamn mama that was already in the case? Okay, she was in the case, but then wasn't allowed to be questioned. You know why she wasn't allowed to be questioned? Because she wasn't in that initial testimony. Did you see what I'm saying? They went around it and said, when did you know? Oh, well, I only found out once I FaceTimed him. Had she said, my mama is the one that texted him first, that would have really opened the door.
No, that ain't how they got it. They how they got around that. That mama, the mama is not connected to the elements, the actual crime that was
So
charged.
could the defense call the mama up?
Because the mother placed her there.
Can the defense
is
call
the
them
authority
parents
over
up?
the minor. So wherever the minor is, the mama isn't. Now she might be there virtually.
No.
I don't know how y'all need to see it, but she's there.
God, just because her mama, just say this. Just say her mama say, yeah, I'ma send you there to screw. The law still states that any person should be protected from harm, especially intentional harm.
Okay, but we are established that
even though the prosecutors didn't call her, can the defense call the parents up?
No harm was done, though, anyway. Even around Chicago, but
yeah, they could. They could have. Hold on, depending on the particular defense that they were going after, and if the parents were connected to the elements of the case or the.
So you saying based on their defense is the reason possibly that they didn't call her up, based on their defense or their strategy?
The defense, that extortion got shut down, so that was going to be a defense. So that got shut down. So that was out the door because found out that's later connected to these text messages. So
okay,
what's
back to
what's crazy?
Harm, Angie, where was the harm? There was no harm. She's saying she had sex with somebody in which we still haven't been.
What was the violation? It's more the question. What was the violation?
Harm is the penal code, Sky. The penal code.
The penal code was violated. That's what.
Meaning what?
The sexual exploitation and the Mann Act and.
Okay, how did I? That's what I'm saying. How did I sexually exploit you? That's what I'm saying. With all
because the elements was fulfilled to prove that.
With all of that you're saying, you're not allowing that piece of the dynamic to be changed. It's just a different. It's a different story.
Okay, but check this out right here. I disagree. I agree with you that the mama helped facilitate it, what have you, but it still don't mean that the person that allegedly did the violation is innocent.
I don't see how he's not.
I don't know what to tell you.
Other than you saying as a layperson,
oh man,
I'm saying as a regular person.
Who does
I'm sorry. This is what I believe, and there's no changing it. You are not gonna get me to believe that that this young lady didn't know that he wanted to have sex with her. She still went into this situation knowing the intent of sexual activity. She then went engaged in the sexual activity, and I'm sorry, I understand what the law is, but once again, if I'm in that jury,
even if she knew
getting found not guilty on her.
Even if she knew later when she got there, it still does not circumvent the law. The law is the law. Ain't nothing
The
I can
law
do
could
about
be
it.
the law,
Ain't
but
nothing we
I'm
can do
telling
about it.
you, if I'm a juror, he getting found not guilty. Now y'all can take it how you want it. All right.
You
Law
know
and
what's
all.
crazy?
Law and all.
Here's what's crazy. So the appeal, he have 30% chance of winning the appeal, but less than 1% chance of winning in the Eastern District of New York.
Oh wow. Yeah, Eastern District, they are beast on the financial crimes and they're
And
beast.
RICO,
Yeah.
racketeer.
Yeah, they're beast on that shit. It ain't impossible though.
Right. It's
It ain't
always that,
impossible. But the thing that
more times than not, they gonna win.
yeah, the thing that I just don't understand, and maybe it's just me. Oh, did I just get paid?
That's because you
Yeah.
are Angie. You're not gonna see it how I see it, and I'm not gonna see it how you see it, because when you are looking at it from the point of the law, you're never gonna see it how I see it. I'm looking at it from a regular juror sitting in the stand getting a storyline. That's how we
No, I'm
probably.
looking at it from the point of the law, and I'm looking at the point of common sense. How can I afflict harm on somebody,
Well,
regardless of how they got there,
to me, you
and not be
can't
found
on
and
the
not
person
be charged
that,
for the crime?
because I'm gonna tell you how. You can't inflict harm on the person that knew the act was coming and then went and engaged in the act. It'd be different if she got to that location and boom, he like, oh, I want to have sex. And then she had no knowledge of it. Two separate things, okay? She knew he wanted it. She still went to the location and gave it up. That's where we differ at. I don't
But the
see
problem is,
harm.
but here's the
If it
problem.
was, let me
Here's
tell
the
you something.
problem, Scott.
If it was
Here's the
harm,
problem. But
she
hold on.
shouldn't have went.
Here's
Why
the
did he go and
Scott.
put herself in
She
danger?
on one now. She
It
on one.
wouldn't have been a problem if she had been allegedly 18 and he wouldn't have had exposed her to herpes. It wouldn't have been no problem.
No, you ain't you not listening to what I just said. You said you
Yeah, it don't make sense. But I heard it.
I see why you can't understand. It's simple common sense that if a person knows harm is there, you saying it's harm. The person knows harm is there, and they go and engage in the goddamn harm. What are we talking about?
But
You
hold
knew
up.
harm was
So
there
you
before you
expect
left your
hold on.
house.
So you expect somebody that's 17 to know the law that she wasn't supposed to
No,
go there and give up her hand?
you know about harm. You know about danger. There is
She
a
she
wild,
know that she wasn't
there is a
supposed to.
lion.
You expect her to know that?
There's a lion waiting for you in this hotel room B. You take your stupid ass in the hotel B and got eat the fuck up. What do you, I don't get it. What do y'all need? She knew, if you want to say the sex was the harm, she knew the sex was on the table. She
Did
knew he
she know
wanted
that
it,
she was being
and she
exposed to
still
herpes though?
went to the situation, huh?
But did she know that she could have potentially be being exposed to some kind of? I don't get
That's
it.
the risk
See,
you
my
take.
thing is, no,
You should
I
know.
can't understand how you don't make
You should
everybody
know.
at
You
fault.
got it.
Everybody is at fault.
You should know. Because
Everybody.
Everybody
and
is at fault
you
except for
not
him.
only do you know that you have the possibility of getting the STD, you also know you got the possibility of a pregnancy. Her mama even said, "Oh, my what she say?" Now she didn't say nothing about I'm gonna have grandkids. Okay, I can't say that, but I'm saying she knew though. She knew that
She
the
knew that
sex
she.
was there, and she went and got it. Okay,
Well,
so I don't
even
see why we not
e-
comprehending this the same. It would be
e-
different
No, it's
if
not.
it would be
Because
different
even with a
if
condom on, you can get herpes. Even with a
now,
condom on, you
right.
get
But
herpes.
then
you're
my
not gonna
thing is,
tell
so
me that a sex
if she don't know that she is going somewhere and the person, got whatever, just say it ain't even herpes. Just say if it's gonorrhea. Can't you get rid of that? The gonorrhea. Yeah, just say if it's gonorrhea. Maybe if you tell me, I might say, oh no, I don't want to get down tonight because I don't want to expose myself to gonorrhea.
I'm not going. Y'all ain't gonna never get me to believe it. That's
I
why
mean,
we ain't gonna agree.
it's like me tell just like me going somewhere and saying, hey, it's a possibility that shit when I get somewhere, a motherfucker can turn into Freddy Krueger. I ain't know that before I was going.
That's
Just like, for
that's
example,
not a
Scott.
reasonable line of thinking. A reasonable line of thinking is if I have sex,
but
I
you're
have
not
the
doing it's reasonable. You're not being reasonable either. If you think that somebody that would voluntarily know to go and get harmed, that's not reasonable either.
That is real. If I'm okay,
You
let's
know
break
what?
it down.
I'm
Let's break
convinced
it
you got
down.
some.
Let's
I'm
break it
convinced you
down.
got some
Let's break
Valtrex
it down.
in your
Let's
purse
break it down.
by saying that.
I'm telling you that this man wants to have sex with you. Okay?
Mm-hmm.
You take your ass to this location and the man asks for the sex and you give it to him. I don't understand where we lost that. You knew he wanted the sex, and the common sense goddamn thing would be if you ain't wanting to give him the sex, then you don't go.
Lord,
But this
win.
coming, hey Angie, it's not
How
no
was
hope.
that not?
Okay, but check this out.
Ain't no hope because
if she was 18 and he allegedly didn't have no herpes, there would be no crime.
That's not you going past my point. I'm talking.
No, ain't no past no point. That's where the crime starts. The crime ain't her being. That's where the crime starts.
it ain't about your point. It's about the law.
herpes comes with the sex. Yeah. That's a package deal. If your stupid ass wouldn't have went to go get that sex that you wanted, okay, you wouldn't have got the herpes with you, okay? That comes with it. So, and y'all not gonna ever convince me that a 17-year-old does not know that if I have sex, I have the possibility of 1, getting the STD, or 2, being pregnant.
That's at any age.
What?
Any age the herpes part would apply. Any age.
Yeah, that's fine. But I'm saying, you contracted during sex. So her having sex, she knew that there was a possibility of contracting a disease. I don't care if it was like you saying chlamydia. What's another one? A UTI. I don't give a damn.
The person don't have the responsibility to tell people that they got a incurable disease.
Did she tell him if she had it?
I don't know. To my knowledge.
Okay, then we both out here. How do you know? How do you know? How do you know?
Ain't about what we don't know. It's about what we do know.
Oh, shut up, Kelly. I'm talking to Angie. How do you know she didn't have an STD prior to the event?
Did her medical records confirm it or just or unconfirm
like you said, we weren't able to confirm the medical records because she was.
But we was able to confirm his though.
Because she was in there as a victim.
His was able to be confirmed.
So I'm saying we walk in with the same situation, but y'all trying to act like this girl did not know sex was on the table, and
I didn't say that. I didn't say that.
You said that. You said that she had the reasonable.
She didn't know herpes was on it. She didn't know herpes was on the table.
Expectation. The herpes come with the sex.
I can agree. I agree with you. I said she knew. I said her mama knew. I said they went there and they could have expected sex.
Okay, so now you telling me
not no damn herpes.
Okay, so now you telling me that now she's 17.
Now I've been said you don't listen.
Okay, but so you telling me she ain't had no sex ed classes when she got puberty, none of that. You
what telling that me to do with somebody exposing you?
Because you have to have the knowledge of the possibility. You trying to make me think.
But you can get herpes with a condom on, Sky.
You want me to
herpes with a condom on.
No. You want me to think that if I have sex with somebody, I ain't got no possibility of getting a disease at 17.
Nope. That ain't what I want you to think. I want you to think that somebody that per the law.
Well, say I got some bumps down there before they do something.
Shut up, Kelly. I can't hear. What you say, Angie?
Hold on, hold on. I put the stuff in my nose. Hold on a minute.
Cause y'all done went crazy now. Now the girl.
Nah, I think it's safe to say your ass crazy.
On the sex, But I'm sorry. There are seven. I'm sorry. Okay, we just going to agree to disagree on that. There's no way that I'm gonna believe. I'm not even a 16-year-old, not even a 15-year-old. I believe that when you
I
have
told you
sex.
she can be 50.
Okay, but okay,
Oh
yeah. So
man, it's
okay, so
crazy. This
then, but
crazy.
that's what I'm saying.
It's
Anybody
crazy as
having
hell.
sex knows that unless you're a real minor, like 7, 8, 9. I mean, but a
No. It's
17.
I go with your crazy ass theories. I don't give a damn if they 75. You can go have some sex,
Okay,
okay? And if your ass get the fucking herpes or whatever it is, then guess what? And you went across the line because it don't have to be. You don't have to be
Don't
underage
do it
to
in
get mad
California
at,
or New York. Just don't do it
huh?
in California or New York. You
yeah,
good.
let me hear a
Yeah,
point. Go.
hey, and listen, yo, that person you had sex with, I don't give a damn, you 75, was supposed to tell you that they got the motherfucking herpes. And if I take my ass across there and I got the motherfucking herpes, I'm supposed to tell you. If I don't tell you, I mean, listen, he was running the risk of him catching the herpes or whatever else from her.
He was,
Somebody gave it to him. I
but
mean, he ain't out.
I'm saying
How
you
about
Somebody
that?
gave it to him.
you got on your law hat though, and I understand.
No,
I'm
I ain't got on no low hat. I keep
Common
you
sense.
this girl hear what I'm saying. I
and
am
That's
saying I am agreeing with you.
I
But
know,
for whatever point that you can say, I can counter it.
I
You
know.
can't tell me my shit is ridiculous when yours not.
I'm not saying that. I'm saying this. This is what I'm saying. Now y'all probably disagree. To me, the I don't know the word. The expectation of a STD comes with the sex. So I feel like when you knew you was going to get that sex, you was rolling the dice on whatever came with it, whether it was a baby or STD. I feel
And
like
when you was giving it to me, you was rolling that dick on, oh Lord, that penis on the table too.
oh shit! You got us.
hey, but at the same
You got us.
at the
And I don't even say
You done
that
turned
word.
that
I
out,
look at
Scott.
her, I'm like, did she say that word?
You
She's like,
turned that
oh
out, Scott.
Lord.
yeah, look, at the
Yeah.
same time you
How
should know,
about that?
and that's
And
what
Oh
he put it
shit!
on the goddamn
I'm gonna rest
table
my
too.
case. You
He
shouldn't
putting
have
it
been
on the
there.
table
You
too.
should have been at
Just
home
put
reading
for
a book.
every
You should have been watching Bambi while you running your
he
hot
should have
down,
did too.
trying
He
to
should have
trying
been
to get
watching
celebrity.
Blues Clues or whoever teach about
Now
sex now on PBS.
he was he
He
was
should have been doing it too.
he was a celebrity.
All
Now
right, all right. Check it out, Angie.
That's
Based
crazy.
on based. Okay, fuck all that shit. Let's, based on what you've seen so far in this trial, do you see any possible errors or possible incorrect rulings that the judge may have done, or anything wrong with the juror?
My lives on errors, possible errors that can
Let's
be
get back
brought
to
up.
this appeal shit. Fuck all that.
Lord, y'all done got
we
Kellen Nurse on the appeals.
No, 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 no. I can't think of any. I can't think of any. I was just asking if you.
you can think of some mother.
Um,
Ineffective counsel is one. You could think of one.
Um, I think it's just bad strategy. I don't know if it rises to the
You know
point of ineffective
know
counsel.
that.
well, here's the thing. Now, listen. The Supreme Court ruled with regards to people when defendants are filing ineffective assistance of counsel. They're looking at that more closely now because they're saying just because you had a bad strategy or you ain't like the outcome, you can't say claim ineffective
Right,
assistance of counsel. So the
right.
Supreme Court is all over that. I don't want to hear nothing about it. She just a la 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 la.
Be-
This is the
because
truth. I ain't got
I
nothing to do
find
with
it
that.
mighty strange. I find it mighty strange that all during the trial, everybody was praising Canic the mechanic, that he gonna walk from this. Soon as the verdict come in, Canic ain't shit, ineffective counsel.
They're supposed to do.
What other option did people have? If that was his attorney, they want
But
they want
say that shit from the. If you're gonna say ineffective counseling, say it during the trial. Don't wait till the verdict come back and you don't like the verdict now, because if the verdict came back in your favor, you wouldn't say no ineffective counseling.
you.
Yeah, I mean, it wouldn't be needed then, but
You this
it's
is
like,
it's not just left up. We believe that the judge was against him, and we also
Okay,
believe that the
okay,
jury was.
okay, cool.
So,
Now we talking.
so
Now
it
we
does
talking.
not matter what he doing. Okay, he can
So
go up there and sing jingle bells, standing upside on his head. But at the end of the day, if the jury's not for him and the judge not for him, he ain't got no win.
okay, so did the judge do anything, make any ruling towards him that was unfair or
I already brought.
presidential? But huh?
did the jury understand the facts in the case? And okay, so that's an issue
They
of
had questions, right? They did
of
have
the fact.
questions,
That's
right?
an issue of the fact. Well, not just because they had jury questions. That's not considered that. I mean, did they understand the facts of the case? These are reasons why you can appeal. Issues with the law, issues with fact, and judicial discretion. So,
That's right.
did they understand all the facts in the case? Here we go.
How would you know they did if they didn't?
How would you know they didn't? One,
You had to interview them.
no. Well, if you interview, and if they convicted on something different, then based on preponderance of the evidence or reasonable doubt, then
Wait,
you may have an issue there.
if they did, do they even know their identity to interview them when they
Well, that's why
sequestered?
I talked about that earlier in the live. I said they ever, I don't know if they got to talk
They just a
to
number, right? They just a
yeah.
number to them, right?
No,
Lovely to
it still don't mean that they don't have to talk, that they can't
I'm saying,
ask them.
how would they reach them?
My goddamn throat itching. Okay,
Lovely said that Bonjean brought in ineffective counsel, and she's right. It was not us. We weren't the ones that said ineffective counsel. Bonjean brought in ineffective counsel. So correct yourself.
Right. I think
of course.
ineffective counseling was a strategy out the gate. That's why she immediately had them come off the case
Right, but
immediately.
you just said that we as supporters were saying can it, and then we was like boom, ineffective counsel. No, it was Bonjean
Oh,
brought in ineffective.
oh no! It was some people. I ain't gonna call no names out, but it was some people that was talking.
Ineffective
That's
counsel. Bonjean brought it up. Is what I'm telling you.
no. What I'm saying is, it was people that was praising Kanik and
Yeah.
then start talking shit about him once the verdict came in.
Oh well.
Yes.
That's something that'll happen. But it really wasn't his fault when you got the judge and the jury against him. I mean, let's just look at this for what it is.
Flower
But
Pot Lady was one of
how
them.
did you think the judge was against them? I said we done went over that too.
Because
Because
just
the
Right.
lady,
you said about an hour
the
ago,
judge was,
every
huh?
motion brought forward was denied. Even the one with mistake of age, denied. Any motion that was brought forward, denied. So how are we to
Okay.
think that the judge was in support of him? Then people saying that was there every time Candy tried to present something. It was
It was
to a
it was denied because it was supposed to be denied.
Well, we went. I think I went through that too. Just because first of all, if you would have read the motions, and I'm not saying you didn't. I'm not talking to you specific, but when
I
you
knew that
read
shit
the
was
motions,
denied when I
and
read the first two sentences.
when you read the motions, the bulk of them, you can see that they were a defendant driven motion, meaning they were an emotional motion, meaning R. Kelly most likely was behind those motions, right?
why
And
Meaning denied.
back denied when that was a legitimate defense.
What motion
Okay,
you feel that shouldn't have been denied?
I just stated it.
I didn't
but
hear you. Say it again.
we remember she said a mistake of age, mistake of fact. Because I pulled that one up, that particular letter motion up. Do you remember what was the why did she deny it, or what was
I think
the
it was just
prosecution
that.
response?
I remember at the end she didn't. I don't think she denied it right away. It was one of the things at the end. When she came down at the end, she just denied it. So there was no. That's what I'm saying. Why was that one denied? That's a legitimate defense. Why would
Well,
that?
she did approve the motion. She approved the motion when they wanted the printer.
We talking about mistake of fact.
No.
That is
Okay,
a
she did mistake of fact, mistake of
why
age.
They
as
did the same thing in Illinois though. Denied everything.
Did they say that? Did she say that she didn't have any evidence to support that particular defense? Did she
how
say that?
Oh,
I
that's so long ago.
don't
So all blur.
have evidence to support it. When you got the girl testifying that she lied about her age, how do you not have evidence to support it?
Well, I mean, I don't know what was the denying reason, but she
Well,
denied it
that's
for
what
something.
I'm saying.
Let me see.
If you have a legitimate testimony, and to me that clearly
Or did
shows.
she not believe
Was
him?
that one of those motions that was untimely?
And I'm sorry, she just wasn't
Or
for.
was it untimely? Wait a minute. It was something that was untimely.
Yeah, I think that's one of the ones that was untimely.
It was something, because I know it was a letter motion. I remember that.
Out of all the motions, that one should have had some weight.
I can't believe that person came in here with that bullshit. And I came in here talking about how it can possibly the text message might be a play, not the
Okay, so
the
what's
text message,
considered
the whole thread might be um um a part of the record after all, and they come in.
what's considered
Get your ass out of here, bitch.
what's considered on so it's a rule of thumb that, and correct me if I'm wrong, it's a rule of thumb that when it comes to if you're bringing up a argument in your brief, it's a rule of thumb that it needs to be, in order for you to bring it up, it needs to be on the record. Is that correct?
Preserving the record or raising
So
an objection. Go ahead.
is that correct?
Yeah.
For appeal? For appeal?
Yeah.
Like if you're going to bring it up, it has to be in the transcripts or in the dockets. Or, well, we're pretty much saying that I'm asking you, what's considered the record? What's considered the record?
Is the motions, the transcript, those things.
What about the post-conviction motion? Is that considered the record?
Yeah.
So even though after the transcripts, I mean after the trial, that's still
right. That whole thing is going to get forwarded.
Okay. So if she brought up those text messages on her post-conviction motion, is it safe to say that it's now on the record?
She brought
Let's say, even though they didn't use it in trial, but she brought it up, her post-conviction motion. Is that considered on the record? And now she's able to bring it up in an appeal?
Yeah, but I was explaining this earlier, and see, I thought we had already talked about what wasn't on the thing. I said if that whole thing was in there, if that whole thread.
So evidence is evidence considered the record?
Yeah.
I say I didn't know that. I thought it was just what was said in court and motions.
Yeah, if your evidence wasn't admissible, It's inadmissible. Still a part of the record.
For appeal.
Right.
Let me say this. So basically, the text messages were an exhibit.
And if I'm sorry, and if you objected to it, let me make sure I say that. If you tried to get some evidence in, and the judge said, it was inadmissible, whatever, he said, Judge John, I'd like to preserve the record, then yeah, it's on the record.
Okay.
What about objections? Can that be brought up in the appeal?
On the record, yeah. That's
overruled. No. Anything that she overruled, can that be later brought up in the appeal?
That's on the record, yeah.
The fact that she overruled it can that be considered unfair? And they can appeal that? Wherever it was?
That would fall up under judicial discretion. I mean, not discretion, Lord, not discretion. Judicial misconduct, right? So, like, yeah, I'm sleeping. Scratch that. That would be issues of the law, meaning that the law was applied correctly. So, her rulings, that will fall upon.
What about jury instructions? Can that be brought up on the appeal?
Yeah.
See, I'm trying to help y'all out. Shit.
We already know this stuff.
You all fucked up, Sky. I'm trying to help you out.
Oh, that the judge. Let me say this. My opinion is that the judge made rulings, especially on the one with mistake of fact. I feel like that should not have been denied. And that's just me with a non-legal mind. Okay. I also that the jury, in regards to the documentary, I feel like them having seen that was the issue, and I believe Bonji gonna bring all that up.
Can the appeal be viewed publicly? Like, can public attend that?
No.
That's fucked up. Will it be transcripts for it?
Yeah, they're gonna be transcripts. Yeah.
Oh, let's see. Can't wait for that. Okay, so you got the brief. You have the brief, and then you got them countering the brief or responding to the brief, whatever that is. I don't know the correct terminology for it. And then you got them coming back to do you have the defense coming back speaking again for the final time, right?
If they schedule oral argument, That's what
I was just going to say. This is just the brief. So the oral argument,
they can deny it based off the brief alone. But if you start,
and they can approve it based off the brief alone too, right?
They can approve it based off the brief too. But
even without an oral argument, right?
Right. But if you start raising all that constitutional stuff, then they probably gonna set it for oral argument.
So I don't know if you heard about this. I heard that when it comes to the the appeal or appellate court, and you're doing your oral argument, all that extra, how Canic was and Bogine was, that's frowned upon.
Karen Johnson, not normal Karen Johnson. Get your ass out of here, bitch. What'd you say?
All the extra, how Canic was in court and how Bogine was in court. That that they being extra. I heard that's frowned upon in the appellate court for oral argument. Do you know that to be true or not?
You can't say improper stuff in court anyway.
Not necessarily improper stuff, but you know how extra they was, especially Canic.
Improper.
Improper.
Yeah, it's considered improper. That's what they'll say. It's improper.
So I hope they can't be a firecracker, and they both are. So let's see. I hope they are unable to contain themselves. Because Bozine, when I saw her in Chicago, oh, she was a mess. She was a mess. I was like, oh my God. She kept objecting like every 5 seconds.
Why you mad she was doing her job? You a hater.
Because he already overruled. He overruled it. And she kept objecting to the same thing he overruled. Like fucking 6, 7 times.
Then you just say that that's how you preserve the record. How do you know
Okay, but he
what to
it's just
preserve the
he gonna get a
record?
different.
Yeah.
Ain't like he gonna change his mind.
But we talking, he's setting it up for the appeal. What are you talking about?
Okay, but you got how many times you gonna keep saying objecting to the
As
same
many
thing he
as
overruled?
I need to.
It got to the point he was like, "You're delaying the." He like, "You're delaying the proceedings," and shut the fuck up.
Well, once again, we have somebody that's not in support of Kels, and now somebody not in support of his attorney. I mean, what more do y'all need? This ain't rocket science. If you can't see what it is, I don't know what to tell you.
But
when is it due again? If she'll file another extension, what's the new date?
oh, I don't know.
Now, when
I
she
don't
do her
know.
brief, when she do her brief, will we be able to see that right away in the dockets?
I don't think so.
Oh, that's some bullshit.
I don't think
That's
so.
some bullshit.
I really forgot if that show up in the system. I don't think so though. I'm trying to find this letter motion. When was he the conviction?
I don't know. Shit. Hold on. You know what? I can tell you. Give me 1 second. I was just looking at 1 second.
My ass asleep. I've been on this slide. I knew it.
It was.
We ain't going down without a fight.
You
We
should.
case.
And that his attorney is a fighter. Hell, she ain't getting
It
all
was like
these.
September something. It was September something.
21, right? 21, right?
September 20 something.
I think she gonna come with a whole. I think we.
Because I'm looking at the verdict sheet
Oh,
and it says September 27th on there. On the verdict sheet. So it may be in the 25th or 24th.
Bonjean finna come down a whole different road.
I can't wait. Let's see.
She got it now. She gonna figure. You say September.
This what she gonna do. Yeah. This what she gonna do. She gonna get everybody but the false hope again.
Oh Lord.
What do you mean false hope?
Because
there's no such thing as false hope. What do you mean false hope?
What I mean by false hope is as soon as you find out what she did, what she's appealing, it's gonna give people false hope until it get denied.
There's no
and
such
then,
false hope. It's either it's
you got false hope now with the text messages.
No, we don't. You think that we don't false hope. That's what you
think. Have false hope. Yeah, I saw false hope with the post conviction motion.
Well, you are not a Kel supporter, dumb. What do you think you don't see? You're
false
not
hope.
People like you are not for the righteousness. So
I saw false hope.
So of course
they said that it was a good post conviction motion. He walking up out of there, and then it got fucking denied.
Okay. So listen, what you just said. So with multiple people thinking that, and that's not what happened. Doesn't that make you think like maybe the judge did something wrong, or there was something incorrect?
No, because I keep seeing it. It's not the first time. Every damn near every motion that was entered on the defense side. Oh, they gonna win that one. Denied.
Okay, so that's what I'm saying.
I mean, I've been seeing this consistently.
You think that there is something in question about that? That's why I don't see why you don't think that would be.
Street people was thinking that they were good motions. Street people.
No,
You too. Oh no, you didn't help. You didn't help.
it was attorneys thinking.
No,
know
nope,
what I
nope.
said. Oh, okay, when they said
Angie,
it was,
Angie,
hold on. Just because it's a good motion, that don't mean I'm saying it's gonna be approved.
you help. You
Right.
like, oh shit,
What I'm saying. That's what I'm saying.
oh
That don't mean
shit.
that the motion gonna be
I don't
approved.
know. T
But I'm
That's what
saying,
T lock him up. I don't know. T lock him up. I don't
yeah,
know.
we got some. It's legal people too in the chats, and all of them were saying the same thing. And then next
T
thing
lock him
you know,
up.
boom.
I think y'all.
The,
I don't know about y'all.
Yeah.
T lock him up.
And I still said if it's a good motion. You
And then,
don't know how that motion is gonna play in front of that
check
judge.
it out. Check it
It
out. Let
could
me
have
show you
went
what you
we
did.
do know how
either
it's
way.
gonna play because the
Let me
judge.
show you. Let me show you what you did. Let me show you what you did, Angie. When the defense did their motion, you was like, "Oh shit, team lock him up." I don't know. And then when the prosecutor responded, "Oh, T Cams, I don't." I'm like, "What the fuck?"
Yeah.
You
Damn
going back and
right.
forth.
They
You
got
going
'em.
back and forth.
Yeah, exactly.
But I'm saying with that state and the judge denying all, to me, that is common sense to say the judge's decision should be in question. I mean, like, hello.
Ugh.
Oh God, girl, no.
I need some coffee.
That
All
don't
right,
mean
y'all.
that don't mean none of that. Because if you got a client that rightfully so, shit, he wants you to do this, put this, whatever. And the only thing you could do is write it up as best you can. But
Exactly. You're right, Angie.
and if it's based, but you know, shit,
When the take
that
is in,
ain't gonna go.
when your client is on the line to be hit by the hit squad, there's nothing you can do. And that's the simple fact that people want to deny. They want to act like it was not intentions to take him down, all the way from the beginning, starting with the documentary, all the way to the judge, all the way to the proceedings, all the way to the end of the trial. I don't see why people are just in denial of all of this. They don't like R. Kelly. R. Kelly is public enemy number one, and their goal was to take him down, and that's what they did. So to sit up here and we saw it happen, all motions denied, every defense they ran shut down, couldn't get nothing in. I mean, what do we? I don't see why. I don't know. I just don't know. I don't know.
You don't know why a defense,
Don't know.
not a defense, but you don't know why is this it?
I'm saying it's clear,
Um,
regardless of what motion we put in, it was being denied because the goal was to take him down, and nobody's gonna sway me from that. That's what I believe, and that's what I
find a
said.
little motion.
It happened. It happened right before our
But
eyes.
if but the same thing kind of happened in Chicago too, right? With the motions, right?
We still got the same thing. R. Kelly, right?
Well, yeah, I
Nothing
see what
has
you're
changed.
saying.
We still taking R. Kelly down. So yes, the same thing happened in Chicago. Yes, yes, yes. The goal was to get them, and that's what they did. Point blank. I mean, I just don't get it.
Well, if
He
you think
was.
that way, then is this
I do. I've been saying that. I feel like, and I didn't say it because I didn't want to create what's the word, a lack of hope. But after you saw the first documentary, if you didn't understand that the game was rigged, then I don't know what. You know what I'm saying? The writing was then on the wall, and then as we saw it fall, then I guess some people started seeing it. And but hey, I knew it from the rip. He wasn't getting a fair trial, regardless of what happened.
Oh shit! I found a motion with regards to um text messages number Django number 5. Ain't that some shit?
What it say?
I need to take my ass to sleep. That's what it's saying.
Okay, well save
But
it and we'll read it next.
yeah, cause that. Oh wow, that's crazy. Anybody need to know is document number 150 in the New York case. Anybody need to know before I get to it? That's crazy.
Okay,
Yes, we're talking about text message between Jane Doe number 5 and her mother. Oh, I need to know how was this how did they rule on what did they say?
how long is it? Is it a whole bunch of pages?
It's 8 pages. But
Uh,
the part that I'm talking about is just a section. I'm too sleepy to read it. And it's this would be good to put together with regards to the text messages. Cause now this would be some good reading. Let me save this. And that's some shit.
Andrew,
Oh wow. Oh,
look up the reason why the mistake of fact was denied, and then
I'm
we can go over that next time.
okay. What is this? New York text.
I think we all right, Team Kels. We just have to develop our argument and understand. Well, some of us. I'm not no legal smig.
Like you, but you just not got to know that it's I can't find that damn paper I need. That you just got to
Frank
know.
about though
You
about how
know.
we have to prove that the prosecution knew. If we're doing prosecutorial misconduct, we have to prove that the prosecution knew she was lying
Mm-hmm.
and what she was lying about. So that has to be developed, and
Yeah,
how egregious it
they
is.
gotta be developed.
You know, how and you say how egregious was the lie and was it intentional, all that type of stuff. And we could develop
Yeah,
because there's probably some more lies just ain't came across them.
yeah. It's like what did she testify to as part of those text messages? Where is the damn? Is this it? Defense of a jury charge. Oh, wait. Is this it? Okay, remember 220. Let me see if it's this.
Got to apologize to the people for yelling too, and apologize to you
Girl,
sometimes.
if you don't stop, we done holler and scream at each other. If you don't stop, child. If you don't stop, I'm gonna start hollering at you for real. You don't goddamn stop.
And we
Oh, I
get
think this might be it. At 9.
this stuff
Come
makes me.
on, mistake. Come on, mistake. So I can.
Let me read
No,
it.
this is
Let's see what y'all saying.
the government respect me.
Oh,
This is jury charge. I think that, wait a minute, this 220.
thank you, Mac. Dan. I appreciate the support. Cause Mac Dan, we getting that mom in this
And
case,
like she done been up here getting beat up. Lord
and
have mercy. Thank you,
we
man, down for the support.
getting the mama in this case. We getting them text messages in.
Oh, Lord, help her, help
We is
her.
freeing Kels, okay?
Is
We
this
freeing them.
219? Please let this be it. Please. I think this is it. Bribery. It's got to be it. Please be it. Don't be so pissed if this ain't it. Mistake of fact. Got it.
Oh, okay, good.
Yes, a mistake by reasonable mistake by the defendant of the age of minor defense. Yes, so what page is it? So this is document 219. Hold on. So that's 219. What was
Yeah, we definitely did the third shift, fourth,
yeah.
and fifth shift. Nah, but we hadn't had one of these in a minute, so this was due. You see what I'm saying?
Right. And my ass gonna be struggling in a few hours. Replace it. Oh, I already had it say. So that's 219. So if that's 219, then oh, wait a minute. 220 was what I said it was. Okay, 220, and then what was her? It, it was, what was her order with regards to the jury instruction? Because it came in on as the jury instructions. So I'll figure that out tomorrow. Tomorrow, shit, today is tomorrow. Yeah, hey Sonya. Yes, honey. Let me get the hell out of her before we've been on another goddamn topic. But yes, honey, you got to stop trying to relitigate your case. That's
I'm
not what the appellate area is for. You got to, you
gonna
want to make it, now I got to go through the same goddamn argument with Levi.
nope, because Levi
And he going to be stuck on it for,
finna develop
for
it. He
10
finna develop
years.
it for us. He listening right now, and he gonna have it developed, and he gonna have a couple lines of defense to come down.
Well, it better, if he better know that, they done used the,
But
they,
to me, after we talk, it falls more under insufficient counsel because if you all are saying that they had the opportunity to question her and he didn't come with the correct line of questioning, I
he
still
done,
feel that the judge shut it. Well, the judge shut down the parents being able to be on the stand. I feel that was on her.
in one regard, you just can't put them on the stand if they still got to qualify under the rules of evidence. What are they testifying to?
As to
And
what, as
I don't
real,
know nothing about no goddamn enticing.
no, I didn't say that. I'm saying
Okay.
they're gonna testify as to whether that whole conversation. Did you text Mr. Kelly prior to your daughter communicating with him? I'm talking about stuff like that. You see what I'm saying?
Yeah, that because they talked to her about that.
Yeah, that's what I'm saying.
Woo, they talked to her. Oh Lord have mercy. They talked to her about that. So
Yeah,
the prosecution asked her.
yeah.
So she can now go and answer that question. But yeah, yeah.
All right, well we're
Brought it up.
back. So you found the mistake
Yeah.
fact, and then you found the text message thing. So we'll have some stuff.
Mm-hmm.
All right, well I'm not gonna keep you. All right, chat. Everybody,
All
stay.
right, folks.
Thanks for having me, Annie.
No problem. No
We'll
problem.
later. All right.
And Jeff gonna ask the same question next time I see him. All right.
I'm supporting Jeff and Free Kales. Bye bye.
You crazy. Bye. Bye, y'all. Thank y'all. Goodbye.